Sir, court officer. Court officer. ಸ್ವಲ್ಪ ಆಡಿಯೋ ಈಗ ಆಡಿಯೋ ಕರೆಕ್ಟ್ ಆಗಿದೆ. ಯಾ ಮ್ಯೂಟ್ ಆಗಿದೆ. ಥ್ಯಾಂಕ್ ಯು ಸರ್, ನಮಸ್ಕಾರ.
ಮೇಡಮ್ ಬಂದಿಲ್ಲಲ್ಲ, ಅದಕ್ಕೆ ಮ್ಯೂಟ್ ಮಾಡಿದ್ದು.
ಥ್ಯಾಂಕ್ ಯು ವೆರಿ ಮಚ್, ನಮಸ್ಕಾರ.
ಮೇಡಮ್ ಬಂದ್ಮೇಲೆ ಆನ್ ಮಾಡ್ಕೋತೀವಿ.
ಎಸ್ ಸರ್.
ಸರ್ ಏನಿಲ್ಲ, ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಬರುತ್ತೆ. ಇದು ನಾಳೆಗೆ ಹಾಕಲ್ಲ. You can go to branch and follow up. What happens? You have to mention before the court. B group ಎಲ್ಲ ತಗೊಳ್ಳೋಣ. ಹೇಳಿ ಸರ್. ಅಪ್ಲೋಡ್ ಸ್ವಲ್ಪ ಲೇಟ್ ಆಗುತ್ತೆ. ಎಲ್ಲ 300-400 ಮ್ಯಾಟ್ರ್ ಇತ್ತಲ್ಲ, ಹಂಗಾಗಿ ಸ್ವಲ್ಪ ಅಪ್ಲೋಡ್ ಮಾಡೋದು ಲೇಟ್ ಆಗಿರುತ್ತೆ. ನೋಡಿ ಇವತ್ತು ಹಾಕ್ಬೋದು, ಇವತ್ತು ನಾಳೆ. ಇಂಟ್ರಿ ಮಾಡ್ರೆ ಯಾವ್ದಾದ್ರು ಇದೆ, ಎಲ್ಲ ಎಕ್ಸ್ಟೆಂಡ್ ಆಗಿದೆ.
ಕೋರ್ಟ್ ಆಫೀಸರ್.
ನಿಧಾನಕ್ಕೆ ಹೇಳಿ. ಹೇಳಿ.
ಕೋರ್ಟಲ್ ನಂಬರ್ 32 ಸರ್, ಕೋರ್ಟಲ್ ನಂಬರ್ 32 ಇಲ್ಲಿ ಕಾಲ್ ಔಟ್ ಆಗುತ್ತೆ ಸರ್.
ಏನಾಗುತ್ತಾ?
ಕೋರ್ಟಲ್ ನಂಬರ್ 32.
ಇಲ್ಲ ಅಲ್ಲಿ ಕೋರ್ಟ್ ಆಫೀಸರ್ ಡೇಟ್ ಕೊಡ್ತಾರೆ. ನಿಮ್ಗೆ ಅರ್ಜೆನ್ಸಿ ಇದ್ರೆ ಮಾತ್ರ ಮೆನ್ಷನ್ ಮಾಡಿ, ಫೈಲ್ ತರಿಸ್ತೀವಿ. ಬೇರೆ ಲಿಸ್ಟ್ ಆಗ್ಬೇಕದು.
ಸರಿ. ಥ್ಯಾಂಕ್ಸ್.
ಸಿಟ್ಟಿಂಗ್ ಇಲ್ವಾ? ಕೋರ್ಟ್ ಆಫೀಸರ್ ಡೇಟ್
ಫಸ್ಟ್ ಲಿಸ್ಟ್ ಆದ್ಮೇಲೆ.
ಅರ್ಜೆಂಟ್ ನೀವೇ ಡೇಟ್ ಕೊಡ್ತೀರಾ?
ನಾವು ಡೇಟ್ ಕೊಡೋದಿಲ್ಲ.
ಕೋರ್ಟ್ ಆಫೀಸರ್ ಡೇಟ್,
ಮೇಡಮ್ ಡೇಟ್ ಕೊಡೋದು. ಹೌದೌದು, ಪೇಜ್ ಅಡ್ಜಸ್ಟ್ಮೆಂಟ್ ಕರಿತೀವಿ, ವೇಟ್ ಮಾಡಂಗಿದ್ ಮಾಡಿ. ಆಗಿರುತ್ತಲ್ಲ, ಇನ್ನು ಅಪ್ಲೋಡ್ ಆಗಿರೋದಿಲ್ಲ ಅಷ್ಟೇ. ಲಿಸ್ಟಲ್ಲ ಯಾರು ಸ್ಟೆನೋಗ್ರಾಫರ್ ಯಾರು ಈ ಟೈಮಲ್ಲಿ ನೋಡಕ್ಕಾಗಲ್ಲ ಸರ್. ಅಂಡರ್ಟೇಕಿಂಗ್ ಇದೆಯಲ್ಲ, ಟಿಲ್ ನೆಕ್ಸ್ಟ್ ಡೇಟ್ ಅಂಡರ್ಟೇಕಿಂಗ್ ಏನೋ ಕೊಟ್ಟಿದ್ದಾರೆ. ಅದು ಬರ್ಕೊಂಡಿದ್ದಾರೆ, ಇನ್ನು ಅಪ್ಲೋಡ್ ಆಗಿಲ್ಲ ಅಂತ ನಿಮ್ ಪ್ರಶ್ನೆ. ಆಗುತ್ತೆ ಮೇಡಮ್, ಸ್ವಲ್ಪ ಬೇಗ ಸ್ವಲ್ಪ ಸೈನ್ ಆಗಿರೋದಿಲ್ಲ, ಅದಕ್ಕೆ ಅಪ್ಲೋಡ್ ಆಗಿರಲ್ಲ. ವೇಟ್ ಮಾಡಿ. ಆಗುತ್ತೆ. ಮೇಡಮ್ ಬಂದವ್ರಂತ. ಬಂದಿಲ್ಲ ಅಂತ. ಟ್ವೆಂಟಿ-1 ಯಾರು? MF MF ಅಂತ ಬರ್ದಿದ್ರಿ ನೀವು ಆ ಕಡೆ. MFA ನ WP ನ WP ಆದ್ರೆ ನಮ್ಗೆ ಬರೋದಿಲ್ಲ 24 ಆನ್ವರ್ಡ್ಸ್ ನಮ್ಗೆ MFA ನು ಬರೋದಿಲ್ಲ MFA ಬರೋದಿಲ್ಲ ಮೊದಲಿತ್ತು ಇವಾಗಿಲ್ಲ ಎಲ್ಲ ಮೆಮೊ ಬುಕ್ ಇಟ್ಟಿದ್ರೆ ಅದ್ರಾಗ ಒಂದ್ ಸ್ವಲ್ಪ ಎಂಟ್ರಿ ಮಾಡಿ ಯಾವ್ದು ಹೋಗಿದೆ ಇಲ್ಲ ಅಂತ ಗೊತ್ತಾಗುತ್ತೆ ನಿಧಾನಕ್ಕೆ ಮಾಡಿ. ಇಷ್ಟ ಎಮೋಸ್ ಇನ್ನು ಜಾಸ್ತಿ ಬರೋದು ಇವತ್ತೇ ಕಡಿಮೆ 500 ಕೇಸ್ ಇಷ್ಟ ಆಗಿತ್ತು ಮೊನ್ನೆ 350 400 ಆಗಿತ್ತು ಎಲ್ಲ ಅರ್ಜೆಂಟ್ ಮಾಡಿದ್ದೀವಿ ನೆನ್ನೆ ಎಲ್ಲ 2 ಅವರ್ ಬರ್ದ್ಬಿಟ್ಟು ಹೋದೆ Sitting will be at 11:10 a.m., sir.
Thank you, sir.
Hmm.
The urgency is this, for a demolition warrant has been issued against me. I'm not even a party to the proceedings, brought before the court below. I filed the obstructor application. Unfortunately, the court hall is vacated, my lord. And no in-charge court, no concurrent court has been.
When did you file that?
I filed the obstructor application on 10/6/2026. At God's speed, we removed the certified copy also. However, no court has only been allotted. Thank you, my lord.
Yes.
Put 230. Page wise.
This matter was listed, however, it didn't reach, my lord.
Mike is not.
Use the mic.
For consideration of my interim prayer, my lords, that the KB has acquired my land, my lords, and without any
Here is
pre-notification.
the writ petition.
Fresh matter, my lords.
When it came up for consideration?
Last week.
So then what happened?
The matter didn't reach, my lords. It was filed on vacation bench itself. The matter didn't reach. Before this court, it was listed last week. It didn't reach, my lords. Kindly have it at 2:30. They have already
When is the date given for that?
next month, my lords. They have already digging the trench in my place, my lord.
Tomorrow, no urgency for today. Take that matter tomorrow. Yes.
Date your matter for it.
My lord, had moved this matter on Friday. It was directed to be listed today. The trial court is listed today. The matter is an execution petition. Kindly have it at 2:30, my lord.
230.
Excuse me. My lords, CRP matter, my lords. It's been listed on multiple occasions, my lords. The date is given for next month, my lords. Fresh matter, my
Might have
lords.
been given. What is the urgency? You can
My
tell
lords,
the court
urgency,
now.
my lords. Trial court stays for plaintiff evidence, my lords.
Huh?
Trial court stays for plaintiff evidence, my lords. Fresh matter, my lords. Rejection of plaint, Order 7, Rule 11, A to D, my lords.
Because that's not possible for the court to hear all those matters. That's the reason why I have given dates, sir. That two dates, every day 30 matters I have given.
My lord, it is a fresh matter, my
Fresh
lord. It
matter,
not
my
reach on the other occasion, my lord.
So when the date is given?
My lord, it
Next
is
month,
given next month,
next
my
month,
lord.
July, my lords.
Next month, 15th.
Yes.
Call
the list.
Date given. Page wise adjournments, if any. List number 1,
Small mention.
page number 7.
Friday, my lord, your lordship extended that interim order. It's not been signed. The trial court insists upon the certified copy. Therefore,
We'll do it in the afternoon. Yes.
grateful.
Your ladyship, if I may make a small mention, I have already given a memo of posting. I have filed a WP 17988 of 26. Your Honor, it is an urgent matter because the trial court has given a ex parte stay order in OS 14 of 26. It is a.
Is it numbered? Your writ petition is numbered?
No, Your Lordship.
If it is not numbered, why will it come?
Your ladyship, if it may be posted tomorrow, it is
No, if your writ petition is numbered, if they are not listing, then tell the court officer. I will not give any memo without numbering the matters and no fresh matters not required. Yes, call the list.
List number 1, page number 7, seal number 20 to 24, page number 8, 25 to 36.
Seal number 42.
Tyagaraj?
Yes, madam.
Serial number?
32, madam.
Yes.
2 weeks time may be granted.
Why?
Because I'm not well, madam. I'm running everywhere.
This is matter in the month of July. Yes.
Page number 9, 37 to 44.
With lordship kindly, Milan. Seal number 37. I appear for petitioner. Annexure C. Impugned order dated 19/5/2019. Already writ petitions are filed pending. May be clubbed along with connected writ petitions and call in the month of July.
Just along with, it is submitted with the land council that the connected matters are there. This list the matter along with the connected writ petitions, that's WP 1440/2026 and WP number 5490/2026. Yes.
Well, serial number 40.
Yes.
2 week adjournment. Senior incarnate ಇದೆ.
This is matter in the month of August. Yes.
Murali Krishna.
Yes.
Page number 10, 45 to 48. Page 11, 49 and 50. List number 2,
Well,
page
it's
number 1. 1 and 2. Page number 2, 3 to 5. Page number 3, 6 to 9. Page 4, 10 to 15. Page 5, 16 to 20.
Serial number 13 may not. 2 weeks time maybe get may not.
13.
13.
This is matter in the month of August at the request of current counsel for the petition.
Stay may be extended may not. Stay may be extended may not. Stay.
Oh, you have a stay and you want it after 2 weeks. This is matter tomorrow, no further time. Yes.
Page number 5, 16 to 20. Page 6, 21 to 24. Page 7, 25 to 30.
Serial number 28, my lord. I am open for petition, my lord. Senior is out of session 3 days, my lord. Next week, any date may be petition, my lord. Other side inform, my lord.
28, I appear for respond number 1, my lord. We have an interim order operating against us. It may be taken on Thursday, my lord. We are ready with the matter.
Next week, senior is not out of session, my lord. 3 days or 4 days. Next week, any date may be. Intimation, my lord. Other side intimation. Senior is calm, my lord.
This is matter on 23rd.
Interim order continue, my lord.
Interim order earlier granted is extended at the request of current counsel for the petitioner. Yes.
Please read.
Page number 8, 31 to 37.
Serial number 19.
19.
Short account.
Complete this list. Will not go back.
Page number 9, 38 to 45.
Serial number 44, Lordship. Waste time for 2 weeks.
40?
Time for 44.
Archana Murthy.
Yes.
Who moved the memo?
Time for respondent number 1.
Who moved the memo?
Memo ಯಾರು?
They have moved the memo. Have you informed them?
ಇನ್ಫಾರ್ಮ್ ಮಾಡಿದ್ದೀವಿ ಸರ್. ಇನ್ಫಾರ್ಮ್ ಮಾಡಿದ್ದೀವಿ. ಕಾಲ್ ಮಾಡಿದ್ದೀವಿ, ಮೇಲ್ ಮಾಡಿದ್ದೀವಿ.
They don't have any objection.
ಇಲ್ಲ ಸರ್.
This is matter in the month of August at the request of learned counsel for the respondent. Look at it. If interim order is there, extend.
Inform the
Yes.
other side.
Watch out.
Page number 10, 46 to 51. Page 11, 52 to 54. Page 12, 55 and 56. The dismissal matters.
My lord, serial number 52 in the first case, it was not caught. My request 52, my lords, battered matter. My request for 230, my lords. This is a matter I had moved on Friday. It was listed.
Oh, 52 in which list?
First list, my lords. That was not called. That was 231. Great.
Inform the other side again. Don't.
I'll request Mr. Shetty to be there.
List number 1, being spoken to. Serial number 1, Syed Azharuddin.
I appear for the caveat respondent.
There was a mention for 230 minutes. There was an urgent matter before the proceedings start. This pertains to the electricity, the installation of poles within a land. And we have challenged the order of the deputy commissioner passed under section 16 of the Telegraph Act. Not serial number 1. It's a mention
No,
for.
it should go before the very same judge, isn't it? This for being spoken to.
No, not this minutes. An urgent mention for a 230 matter.
Oh, you wanted a matter to take.
Yes,
Yes.
So the deputy commissioner has granted a protection order with respect to installations of certain electricity poles, where the entire land consists of 24 acres undivided. They've just passed one order against us and say, the deputy commissioner says that let the poles be installed in your number as in your land, and then let the hissa port or the survey can take place. This is the urgency, Miraj. Now, all of us have been given an impression that the entire lands, the poles will be installed in the entirety of
The
this.
order you're expecting, will the court stay the laying of the towers?
I'm sorry.
Transmission lines?
No, sir, let them demarcate exactly the place where they want to. But because today GPS survey is available, at least let them have a GPS survey in which place.
Come tomorrow. There's no urgency for that.
Can it be tomorrow then? I'll just place the memo because
If you filed it, it will come tomorrow as well.
it's been filed. It had
is
come
there.
up. The matter did not reach on the other day. So there is an urgency. Now the officials were at the spot. That is why we had to make this mention. If it is possible for.
No, not today, tomorrow.
Very well. I'll just hand over the memo. My colleague shall hand over the memo to the court. I'm grateful.
No, this is with regard to this rejection of claim.
Please, my lord. I am for the caveat respondent.
Yes, no, non-filing of the written statement.
Please.
In one of the matters, there was a stay with the validity of the amendment was a question.
My lord,
And
this
the
is,
coordinate bench of this court has
that
granted.
is with respect to the CPC amendment which has taken place in 2024-25 by Karnataka High Court. Now the impugned proceedings which are challenged by the petitioner is under the Commercial Court Act of 2015, which are completely different proceedings, and the law laid down under the Commercial Court Act is very settled, my lord. Now the stay with respect to the non-filing of return statement within period of
Similar
120
provision
days.
is, similar
That
provision
is
is.
the similar provision, which is an amendment to CPC by the Karnataka rules. But the Commercial Court Act is a central act which has been amended, which has been in force for last more than a decade. And this is the settled law, my lord. CPC amendment is very recent and that has a bearing on the regular civil suit. Whereas this is a special statute and the stay operating thereunder is not applicable to the present case, ma'am.
This court has disposed of the matter on 4th, no, when is that order? This court has dismissed a writ petition on 11/6/2026. For signet clarification, the matter is posted today. Yes. Next.
Number 2, Kavita HC.
In this matter, office has raised an objection with regard to the maintainability of the CRP, my lord. It's an order allowing the review petition, my lord. I ought to have filed the miscellaneous first appeal, my lord. I may be permitted to convert that.
The office has raised the objection with regard to the maintainability of the petition. The office objection is same. The petitioner is at liberty to convert this petition
Into a miscellaneous first appeal.
Miscellaneous first appeal within a week from the date of receipt of the copy of this order. Please to is directed to return all the documents.
Appeal number 3.
Lord,
Srikanth.
Lord, certified copies, my lord.
I said to return all the documents.
Please.
For petition this case, my lord.
Notice to respondent number 1 and 3.
1 and 3 is
As
refused, so they may be
amounts
placed
to-
ex parte, my lord.
Amounts to deemed service of notice. Then what about non-compliance of
My lord, I
office
have
of-
written advocate submission with respect to that, but the concerned case worker has not put up those advocate submission itself.
What is the objection?
My lord,
What is the advocate's submission?
my lord, firstly, they have stated,
2025 matter,
yes,
11th time office objections.
I have written the advocate submission repeatedly, but again, the same objections they are raising, my lord.
Yes, what are they? What are the objections that?
My lord, the objection they have raised is all ratios to be attested by competent authority. I have attested.
Serial number at index at volume 2 to be stated.
Yes, my lord, that have stated properly.
Nature of respondent number 1 to be
I have stated.
a WP cost title.
I have stated.
Summons of authority after verifying.
Summary of authority, my lord.
Huh?
Summary of authority. That is summary of authority, not summons of authority.
List of authorities filed by petitions, counsel to be made as annexure and stitched along with WP.
Yes, list of authorities they are telling to make it as annexure, my lord. I am
When
first
you
of
want
all.
to file it along with it, there should be something.
Well, I'm not pressing at all. I'm not pressing at all.
Don't
the list
file
of
it.
authorities.
When you're filing it, you have to follow the
My
procedure.
lord, earlier the case was filed by the party in person. Unfortunately,
Whatever it is, there is no way out. Whatever is the procedure, whatever is the rule, you have to follow it. As per the WP cost title, R2 and R3 are not a party before the trial court.
My lord,
To be clarified.
I have clarified clearly. R2 is, my lord, he was PW1 witness. R3, my lord, is PW2 witness. Now I'm
You will implead the witness as a party to the writ petition.
because I'm challenging the order on IA and number 11 and 13, which was filed under orders 18 rule 17.
Witnesses are parties to the IA.
Yes, my lord. The
How can it be?
They have made. There's no plaintiff at all in this case. While filing the case, my lord, 6 to 7 plaintiff filed the case.
Show what is the cost title show?
Yes, ma'am.
Where is the cost title?
Yes, ma'am.
Where is the IA?
The order on IA number 11, my lord, it can be
There are
seen.
so many objections.
My lord,
For everything you have an answer for that. Except this objection, all other objections, whatever are there, you have to clarify. You have to comply within 4 days. No counsel submission on that. And now please show to the court, where is this IA?
Page number 50, my lord, the order of the.
Page number?
50.
My lord, I am not pressing annexure A, my lord. I am challenging annexure A and annexure B both. But while passing the interim order, the then sitting
Who are the
judge,
parties to this page number 50?
my lord, party is R3. This one number
Look
3.
at it. Come to
R1.
page 50.
That's R1. Madam.
There are two respondents.
Yes,
Who
my
are the respondents in this?
My lord,
CR?
here
Petitioners
the
hearing. Petitioners hearing.
Hmm?
Petitioners hearing are the respondents there.
Come to the cause title before this court. Where is it?
my lord, the respondents is here petitioner, my lord.
Come to the cause title.
Yes, my lord.
Where is it?
Page number 8.
Respondent number 2, my lord, he was PW1 witness.
Party in person might have done it. You have to understand.
Yes, my lord.
Just like that, anybody you will make them as parties to the writ petition.
There is a reason why we have made him as a witness. Because, my lord, first he gave deposition PW1.
You understand the court question and then answer.
Yes.
You are questioning an order passed by the trial court. Whoever are the parties before the trial court, you will make them as parties, and anything, whatever you are submitting, whether the court will consider or not, that the court will consider if you file an IA. Just like that, you can't make everybody a party.
But there are no parties at all in the trial court, my lord. Everybody is resigned and everybody went off. There are no parties at all. There is no plaintiff at all in that case.
Office objections to be complied with. Any interim order in this?
Yes, my lord. Interim order was
There's a
granted.
stay on the suit. May I make one submission? Lord, this is a suit by the first respondent hearing. There was no instruction to the counsel who was representing the first respondent hearing before the trial court. He retired. Defended suit for my lord, declaration.
For declaration to declare the intellectual property rights, trademarks, and copyrights belonging to plaintiff, that is respondent, my lord. They filed this suit along with
Yes,
7
my lord.
directors. Later, what happens, my lord? All those 7 directors, that 7 plaintiffs, they resign from the company, and they never appears to the, this suit at all.
Lords made
All of them went off. Later, my lord, the one who represented the respondent number 1 company, he also resigns. So there is no plaintiff at all in the suit. But later, the respondent number 3, my lord, he comes along with the authorization letter that I am authorized to give deposition on behalf of the respondent number 1 company. And he gives his deposition. And later, he was cross-examined. And later, my lord, we filed IA under Order 18 Rule 17 to cross-examination respondent number 3, my lord. That was dismissed. So I am challenging that IA here.
And whoever are the witnesses, you have made them parties to this.
Yes, because I want to cross-examine him. There's no plaintiff at all. There's no
And the
plaintiff
suit
at all.
is stayed. If I don't know, my lord, if the stay is vacated, I don't know whether the suit will survive or not. Suit is stayed because on the instance of the
Because of
petitioner.
this suit, my lord, I lost my intellectual property rights. I lost my trademarks, copyrights, everything.
has
First
been
they filed
declared so
suit,
far.
they obtained interim
Come to
injunction.
the implement order. Come
My lord, annexure B, my
Page
lord.
number.
Annexure B.
Page number 50, my lord. Annexure B is the page.
The operative parties at 59, my lord, page number 59, para number 10, my lord.
Reasoning starts from 54, my lord.
54.
54.
54 operative parties from para number 10, page number 59, my lord.
Just give me 2 minutes.
Yes.
When was the cross-examination completed?
My lord, cross-examination was completed. In volume number 2, my lord, volume number 2.
No, you just have to give the date.
My lord, 28/7/2022, my lord.
28/7.
2022.
When was this application filed?
My lord, on 21 February 2024, my lord.
Come to your affidavit.
Yes, my lord. In my affidavit, my lord, I request your lordship to kindly come to page number 75, para number 5. Para number 5 to para number 7, my lord. I have clearly stated why I need to cross-examine PW2. What and all I want to ask. Para number 7,
What were
particularly.
you doing from that to for a period of 2 years? Whenever you want to recall the witness can't be recalled. Or if you, all these questions you remember if the trial is completed, again the witness will not be recalled.
My lord, the only reason why witness need to be recalled is that, my lord, he has deposed which was not at all in his knowledge. He joined to the
What were
company.
you doing for 2 years? That's the question. There is a time frame for everything. And there should be a reasonable cause.
My lord, there was no plaintiff to file any. I have filed multiple application, but there was no order for any of the applications, my lord. Even today, I think 10 applications are pending before the a trial court judge.
And 38 different cases.
None of the applications have been answered. Moreover, I noticed the perjury against a respondent. So I filed perjury application. I was pressing that application. Have annexed that also.
Please
That is
stop.
also pending.
Agreed with the order passed in.
No, I request your lordship to kindly come to para number 7 in page number
I've read
75. Para number 7, my lord.
7 of what?
Page number 75 of my affidavit.
I saw that affidavit. Agreed with the orders passed in. I number 11, lowest number 2 of 2021, dated 4th July 2024. Whereby the court had dismissed the application. The petitioner who is the defendant before the court is before this court. The suit is filed. Voice number 2 of 2021. Where is the suit, sir? Where do you get the plaint?
It is sued for declaration.
Where is the plaint?
Page number 96 to 135.
Annexure F, my lord. Page number 96.
Suit is filed. Seeking a declaration with the assignment deed dated 30/7/2021 or any other document executed as the first defendant as the signatory of the plaintiff company in favor of defendant number 1 and 2 with respect to the patent, design and trademarks of the plaintiff as per suit schedule A, B and C properties are illegal, non-est and not binding on the plaintiff. And a perpetual injunction restraining the defendants, his employees, servants, agents or any other persons acting or claiming under them in whatsoever capacity from carrying on the business of manufacturing, selling, marketing, distributing, and in any manner trading with products, goods or services, embodying the patent design with similar name, and a perpetual injunction restraining the defendants and persons, other persons claiming under them from carrying on the business of manufacturing, selling, marketing and distributing.
I
And
beg your
also-
pardon for interruption, my lord.
Mandatory injunction directing the defendants to render true and correct accounts of the sales of the products. In the said suit, the cross-examination of the witness, the plaintiff, is completed on 28/7/2022. Thereafter, the present application is filed to recall PW2 for further cross-examination. In support of the application, it is stated that the PW1 who was examined on behalf of the plaintiff company is not a competent person, as he is not having personal knowledge with regard to the facts to which he has deposed. He has suppressed several material facts, and in order to bring out the same, they have prepared list of 200 questions to be asked to PW2 and gave it to their counsel. However, the previous counsel fails to ask any of these questions to PW2 at the time of cross-examination. Hence, the present application is filed to recall the witness. The court, by order impugned, and dismissed the application. While dismissing the application, the court has observed that in appropriate cases to prevent abuse of the process of the court, the courts can use its discretionary power to recall a particular witness for further examination or cross-examination. And it depends upon the facts and circumstances of each case. And unless it is satisfied with either in the interest of justice or to prevent abuse of the process of court, no discretionary powers can be exercised, either to reopen the case or recall the witness. Since PW2 had already been cross-examined at length, and the reasons assigned to the defendant, the 200 more questions are left out by his counsel without disclosing the particulars of those 200 questions is not satisfactory. It is not feasible to recall PW2 by exercising the discretionary power under Order 18/17 of CPC, Section 151 CPC. Given the other grounds urged by the defendants for recalling PW2 had already been covered at the time of examination in chief, as well as cross-examination of PW2. Hence, question of recalling PW2 on the grounds urged by the defendant is not, it cannot be considered. The counsel appearing for the petition submits that the petition has given a detailed reasons why he has to cross-examine, further cross-examine why the PW2 has to be recalled for further cross-examination. The court, without considering the same, has dismissed the application on technical grounds. Then counsel appearing for the respondent submits that. What is your submission?
Or my submission is that this application itself is a frivolous application
Lord,
because
first of all, he cannot make any submission because he is representing respondent number 2. There is nothing against
he has
respondent
made
number
me
2
a
in this
party, my
case,
lord.
my lord.
He has made me a
The
party.
application is against R3, my lord.
Why did you make him a party? A person who is Party to this, whatever he wants to submit, he'll submit.
Because-
Whether to record or not, that's for the court. Yes.
Just one submission before that, my lord. One submission before that, my lord. Just one submission. I will finish my submission. Just one submission, my lord. Or kindly see, annexure S, my lord, page number 216, my lord. It was, cross-examination was done on 19/8/2023, my lord. I would like to correct myself for what I told earlier, my lord. The cross-examination was done on 19/8/2023.
19/8/2023.
Later, I filed this application.
You said 21/2/2024.
I was, I correct myself. It is an page number, annexure S, page number 216.
To the date, when is it?
19/8/2023. Cross-examination was completed, my lord.
When did you file the IA?
I filed IA on 21/2/2024. Just after 4 months, 5 months.
Yes.
Please, Lord, with respect to the submission made on the merits of the matter, my lord, the suit was by the company, my lord, that's respondent number 1. There is no prayer as against the respondent number 2 concerned. They have made a party. With respect to respondent number 3, my lord.
You are the witness?
No, I am not the witness. I'm also for the witness. I'm not for the company. For respondent number 2, he was PW1 and he was not tendered before the court for cross-examination, and his witness was not considered, and later PW2 came into picture. Lord,
He
with
withdrew the deposition.
Let me submit this. What is it?
My lord, he is making false submission.
Please.
He withdrew his deposition, my lord.
That's what I'm also saying.
No. I beg your pardon for that.
That's what I'm also saying.
Beg your pardon.
No, you should learn how to make submissions. Whatever
your
you want to submit, you have submitted. I heard. When the other counsel is submitting, you have to listen what he is saying and you can respond.
I beg your pardon.
Yes.
My lord, it's a matter of public record that PW2 was assaulted at his house. This is an intentional application was filed to make him retract his submissions. The petitioner number 1 herein went to the house of PW2, assaulted him with 4 to 5 people, and there's a criminal case pending. I may be permitted to submit those records also if necessary, my lord. This intention is.
As far as this application is concerned, those are all not necessary facts. Whatever it is, if you will have a remedy for that. If is already there's a criminal case, then take action on that.
Correct, my lord.
How will have bearing on this application?
My simple submission is this, my lord. They very.
The court has gone for the reason.
Yes, my lord. The 200 questions he says, my lord. I don't know what 200
all
questions.
the questions he should write and give it to the.
Not necessarily, my lord. At least what is the line of question here that the court has answered? Why the line of question is that he don't have personal knowledge of the facts that he has deposed before the court.
Given by the court cannot be sustained. Yes. Counsel for the respondent submits that this is a frivolous petition only to drag on the proceedings, and the court has rightly dismissed the application. As per having the counsels on either side, there is a material knowledge. The petitioner has filed an application to further the cross-examination of the witness is completed on 19/8/2023. On 21/2/2024, an application is filed seeking further cross-examination of the witness that came to be dismissed by order impure. The court, the reasons that are given by the court, that is a discretion.
No, one more submission. Just a change of counsel, can it be a ground to allow this application, Lord?
We can understand if it is as early as the dates that are submitted. Immediately has come up with an application.
No, correct, my lord. Lord, that counsel was also not the first counsel. The order sheet is not before this
tell the
honorable
court
court.
to conclude it and not to allow this kind of application. Your suit itself is state.
Correct.
You want something.
No, it's not my suit. It's the respondent one's suit.
Whosoever suit. So let's.
No, the only submission that I am making, my lord, the witnesses are being harassed without any reason. And this is one of the.
Bring it to the notice of the court. Yes, what did you write? This court has there is the reasons that are given by the court. That the reason is since PW2 has already been cross-examined at length, and the reasons assigned to the defendant 200 more questions are left out by the counsel without disclosing the particulars of those 200 questions is not satisfactory. It is not feasible to recall PW2 by exercising any discretionary power. When an application is filed, court has to look at the same in the interest of justice. And whereas in a very, very hyper-technical manner. The court has considered this application and dismissed the same. The cross-examination is completed on 19/8/2023, and on 21/2 this application is filed. Even there is no much delay, and in a substantial, in the interest of the parties, the court ought to have allowed the application. However, considering the submission of the 10 counts for the respondent, the petitioner is filing frivolous applications one after the other. It is made clear. It is made clear that the trial court shall within a very time bound manner shall conclude for the further cross examination in a very time bound manner shall conclude the same. In that view of the matter, the order impugnated so and so is set aside. The matter is the IA number so and so is allowed. The trial court within
Only with respect to Annexure B, right? Only with respect to Annexure B, because Annexure A has rendered infectious, as earlier submitted by the.
No, that application.
No, there are two applications challenged in this petition.
What are those?
Annexure A and B.
Annexure B, my lord. I'm not pressing Annexure A. I'm pressing only Annexure.
Only as far as IA number so and so is.
Annexure B, that's all.
Annexure B.
Order is very specific on IA number.
So, okay.
Filed by so and so.
Please.
Yes.
But one humble submission, my lord. Kindly direct the trial court to dispose all the pending applications, my lord. It is pending since the case is
Not
filed.
all your requests in one petition.
That is not a prayer at all.
Yes, next.
Much obliged.
They shall conclude the further cross examination. Yes.
Obliged.
Number 4, Upesha.
The notice to R1 and R3 returned as not clear. Wants to deem service as notice. Yes.
Suit for partition, my lord. By the petitioner herein, my lord. Wherein, my lord, earlier I have filed an application for temporary injunction in respect of item number 5 and 6. That was came to be dismissed, my lord.
What is the suit?
Suit for partition and separate possession. In respect of item number 5 and 6, sixes are concerned, my lord, which are the, my lord, properties of the different number 1 under husband.
Before that, what is IA?
Now, my lord, appointment of commissioner and depositing the, my lord, they have harvested the, my lord, crop in the item number 5 and 6, which was exclusively belong to the different number 1 and my father, my lord. In the partition,
Let's see the order. Page number.
Order, my lord.
Yes.
My lord, order at, my lord, annexure L, my lord, page number 77. Court says, my lord, since I have executed release deed in favor of my father and mother, I don't have any right, my lord. Now my father and mother are died, my lord. I will also come under class 1 years. That was not considered by the court. My lord, that findings can be at page, para number 15, page number 81. From para number 15, my lord. If my lordship read para number entire 15, my lord, court has said, since I have executed my lord release deed, I have no right. Though I have executed release deed in favor of my father and mother, my lord, both of them are now died.
So earlier your injunction petition is already dismissed.
Milord,
Your injunction petition.
injunction,
Restraining them from whatever cultivating. or-
cultivating,
That is already
let them cultivate, my lord, there is no problem. The problem is that, my lord, now court has observed that I don't have any right because I have executed released in favor of my father and mother.
I will say that.
Father
as
and
far-
mothers are,
As far as that finding is concerned, we'll set aside and that will be decided by the court.
no.
In the
But my
trial.
lord, in respect of, they may harvest, my lord. Trees they are cutting, my lord. That is the problem, my lord. Now they are cutting the trees. That application was,
What do you do when your application earlier is dismissed?
my lord,
IA number 5 is dismissed.
at that time, my lord, my mother was alive. Since my mother also got, my lord, share in the property, I have raised my share, my lord. Therefore, I kept quiet.
Whatever your mother has suffered in order.
No. My mother has not suffered. Myself, my lord. Myself has suffered during the lifetime of mother. My mother is also now died, my lord, without any testamentary, my lord, disposition of the properties, my lord. Now, my lord, in view of class 1 years, I am.
How it will make your situation better from there to now?
The,
As far as this observation is concerned, that we will set aside and remain, we will not interfere with this order.
my lord, at least, my lord,
What you can't get in the other order in which you kept quiet, you can't seek in this. Please come. Agreed with the orders passed in I number 9 and 10 in OS number 45 of 2021.
at least early disposal of the suit.
Suit of 2021 early disposal. How can it be?
Otherwise, my lord, year by year they will.
39 2024. By the second additional senior civil judge and JMFC Hassan, the petitioner named the you're arrayed as
My lord, plaintiff, my lord.
The-
Myself was plaintiff.
plaintiff is before this court. The plaintiff has filed a suit seeking partition. In this, the present application is filed seeking direction against defendant number 3 and 4 to deposit the amount which they have collected from harvesting coffee, pepper, and also by cutting and selling of the standing timber in suit item number 5 and 6 of A scheduled properties. The court by order impugned has rejected the IA. While rejecting the IA, the court has observed that during the pendency of the suit, the plaintiff and defendants number 1 filed I number 5 and 6 seeking to pass an order of temporary injunction against the plaintiff from harvest against the defendant from harvesting and processing coffee and pepper in suit item number 5 and 6 of the properties and not to interfere with the possession of the said properties. The court, by order dated 23/2/2023, allowed the IA number 6 filed by the plaintiff in part and granted an order of temporary injunction only with respect to item number 1 to 4 of A scheduled properties. The plaintiff is restrained by way of an order of temporary injunction from harvesting coffee and pepper seeds in item number 5 and 6 of A scheduled properties and interfering with the first defendant's position. It is observed that after passing orders on I number 5 and 6, the plaintiff has come up with these applications, again contending that the defendants number 3 and 4, after death of defendant number 1, high-handedly and illegally are harvesting the coffee and pepper seeds and also cut and sold hundreds of standing timber in the properties and sought for appointment of the forest officer as court commissioner to access value of the timber cut by defendant number 3 and 4. The court has observed that he has not placed any sufficient document to show that the defendant number 3 and 4 have legally entered the suit item number 5 and 6 and harvested the crops grown there. The court observes that the court has already granted injunction in favor of the defendant. Earlier I said injunction against defendant, no, injunction against plaintiff. When the court has already granted injunction in favor of defendant and I number 5, holding that the plaintiff has not made prima facie to grant claim any relief in respect of the suit schedule item number 5 and 6A property, then the question of considering the claim made by the plaintiff again under I number 9 will not arise. The court has observed that in the said suit, the plaintiff, first defendant, second defendant, and J.R. Venkatramu were the parties, and all four persons were allotted shares. After disposal of the suit and after 10 years, the
That
court
is earlier
observes
suit.
that in OS number 219 of 1998, a partition suit was filed by one H.R. Keshavamurthy, the brother of the plaintiff, and was disposed of by virtue of the compromise entered between the parties, and final decree was also drawn as per the terms of the compromise. In the said suit, the plaintiff, first defendant and second defendant, and J.R. Venkatramu were the parties, and all four persons were allotted shares. After disposal of the suit and after 10 years of allotment of shares to plaintiff, the plaintiff and second defendant relinquished their shares in suit item number
516, only 516.
Huh?
Only in respect of item number 516.
You have relinquished your share after the partition.
After the partition, after the suit, my lord, there is a partition. In that partition, in my father favor and mother favor, I have relinquished my rights, along with my defendant number 2. Now, my lord, my father and mother died, my lord. I will also become class 1 heirs. Though I have relinquished my right in favor of my father and mother, in view of death of without any testamentary disposition. After death, my lord, I will also become class 1 heir.
That observation we will not.
Otherwise, my lord.
No. Share to plaintiff. The plaintiff and second defendant relinquish their share in suit item number 5 and 6 of the scheduled property. Therefore, they have become absolute owners absolute properties of defendant number 1 and J.R. Venkatramu. Hence, in those circumstances, the plaintiff cannot make this application. Then counsel for the petitioner submits that. Though after the partition, the petitioner has relinquished his share in favor of defendant number 1. Now, after the death of the defendant, the petitioner, being the class 1 heir, is entitled to partition. Such a finding by the court cannot be sustained further unless a commissioner is appointed, unless an order is passed. If the defendants continue to cut the trees and sell the same, that would cause a lot of hardship to the petitioner. Next part. Though the notice to so and so, just now dictated that unclaimed so and so. Next, having other counsels on either side, there is the material on account. The petitioner's mother was the defendant number 1. During her lifetime, court has granted an injunction restraining the plaintiffs from interfering with the cultivation of defendant number 1. Now, after her death, now again the applications were filed seeking the appointment of the forest officer as court commissioner to access and ascertain the value of the timber cut by the defendants in the suit schedule item number 5 and 6A of the property. The court considering the fact that the court has considered the fact about the earlier suit and about the relinquishment of the rights by the petitioner plaintiff and rightly rejected the IA. When the petitioner, who was unsuccessful in getting an injunction in the earlier IAs, cannot seek the present relief, and all other contentions with regard to whether the petition is entitled for partition and all, that would be decided by the court in the pending trial. And at this point of time, petitioner is not entitled for any relief from this court. Accordingly dismissed. Yes, next.
For 5, Pradeep Nayak.
This court should decide all other issues, my lord, on merits.
All are left open. That's what court will decide, I say.
For the petitioner, as insofar as the respondents mentioned that the notes 2, 4, and 5 are concerned, the service has been refused by all of them.
Please come. The notice to R20 and 21 returned as refused amounts to deep service of notice. Then
Serial number 2, 4, and 5 are all refused ones.
R29 to 32 also refused amounts to deemed service of notice. Steps to be taken in respect of deceased R1 and R28. What
Their,
are-
their
One
LRs
submission, my
are all on record. R1's LRs are on record already as 1A and 1B.
Oh, whether it is, have you filed a memo in that?
No, they were impleted at the start itself. They don't need to be substituted because they're already on record.
So you have to say, you have to file a memo saying that.
They're
they're-
there, the
Record, my
cause
lord.
list itself
I
shows.
represent the respond number 225.
Then why this is shown? Steps to be taken in respect
Trial
of.
court itself, they are on record, my lord. Trial court itself, they are on record.
They're already on record in the trial court.
Trial court.
Please, my
Then
lord.
why, where is the question of steps to be taken in respect of deceased R1 to R28?
I think it has come by error, Manoj, both.
Third, the office objection, the steps to be taken in respect of deceased R1 to R8 land council officer. Already the LRs are on record as the R1 and R28 died during the, before, when the matter was pending before the trial court itself. Then you 20 and 21 refused amounts to team service of notice. Then what is this not
So far as
claimed?
the first one is concerned.
R22,
R?
5.
Five, that also I had submitted,
The-
2, 4 and 5. That
the-
not claimed may also be taken as.
The R22, notice returned as not claimed.
R22 to R26.
Amounts to deemed service of notice,
22 to 26.
22 to 26. Then,
IA number 1
uh,
was for dispensation of production of some of the annexures. Copies are
what
produced.
is the matter argue?
Please. The serial number 1, there are certain respondents who have not been served, for which I have filed an application for substituted service through newspaper publication. That is R7 to 9.
The suit is not pending.
What has happened here is that a preliminary decree has been passed. After the preliminary decree was passed, final decree proceedings are initiated. In the final decree proceedings, the LRs of one of the defendants files an application saying amend the plaint and the decree, preliminary decree, to bring a new property on record. Through that amendment application, my property is brought in on the first time in the FTP, which is clearly impermissible in law. The courts have held continuously that if a new property has been
No,
brought
I'm
in.
asking you, when if the matter is pending before the trial court, with the executing court, so why can't you take no notice by instead of substitute?
We have done so. We have served them.
What happened?
They have chosen not to come forward.
No, where is that? Have you filed a memo?
One submission, my lord. This matter is in respect of only one item, my lord. My learned friend filed this petition in respect of only one property, my lord. We sought for amendment of the client in FDP proceedings. My application is allowed. That's only the subject matter, my lord. Only respond number 2 to 6 filed that application, my lord. Others are formal parties in this matter, my lord.
Well, in the partitions.
We are the
what is formal-
contesting matters.
Why? All are.
There are subsequent purchasers are there, my lord.
Whoever it is, they are
After
also
passing
the same.
preliminary decree, my lord, that too. It's the
Anyhow.
matter of 1981, my lord. After 45 years, it's
When
still
was
it
the
is
stay
pending.
granted in this matter?
In the 2025, my lord.
It was granted on 7th July 25. I mean,
My application was allowed.
Where is that memo? Why have you not filed it?
I'm so sorry. There's one request, one submission I could make, that my grievance is only with regard to one item which has been added as a scheduled property. The FDP has been stayed as a whole. If that,
No, you have taken out hand summons, or what did you do? What is this?
I was permitted to serve the counsels who are appearing in the trial court for
You have
these.
served it like I see some postal receipt.
In the FTP proceedings, apparently some of the counsel were not appearing in court. So we could not, when we went to court, they were not present. Therefore, those have been served by SPAD.
But how many days is 81 suit final decree proceedings will be stayed?
3 times notice has gone out from this honorable court and we have tried, which is why I filed an application for substituted service by,
Who are these?
they are family,
what
they
is
are
the
family
number?
members.
Their address respondent number?
7 to 9,
Who are they?
they are family members of the original family.
You represent whom before the?
2 to 6, my lord. In this matter, I represent 3 to 5, my lord.
They are arrayed as before the trial court.
Petitioners number 325, my lord, in trial court.
Is
Only number of the property is changed, my lord, on the basis
No,
of
that's not
commissioner
correct.
report.
That's not correct, man.
It's not for adding new property.
Entirely new property has been added.
No,
There
no,
was
my
some
lord.
leasehold
No,
rights
my lord.
over survey number 191. Subsequently, survey number 85 was sold to petitioner number 2. A completely different property is being sought to be in
Kindly turn to
the
page
matter is posted before the trial court,
29th of June.
29th of this month. Then on that day, serve the council.
I'll make one more.
And bring to the notice of the court also. The petitioner shall take out hand summons on the council appearing for the respondent number
R7 to 9,
R7 to 9,
R15 to 19,
15 to 19,
27 and 33 to 36.
27 and 32 to
33 to 36.
33 to 36. It is submitted, the matter is coming up on 29. On that day, the hand summons shall be served, and also shall be that this aspect shall be brought to the notice of the trial court, and the memo shall be filed before this court by 1st of July. List the matter on 2nd. If on 1st of July, if the memo is not filed, the stay granted by this court shall stand vacant.
Please, the interim order may kindly be
Interim order earlier granted is extended.
deeply aware.
Number 6, Narasimhaya.
My lords, I appear for the respondent number 1, my lords. There's an interim order operating against me, my lords. There's a stay of execution proceedings. If your lordships will see the
It's not
prayer,
extended on the last occasion.
my lords, it's not till the next date, my lords. That was a absolute interim order which was granted. It's not till the next date.
Where is that page number?
That order did prayer, my lords.
No. When was that order passed?
Just a moment, my lords. On 15/10/2025, my lords.
15/10.
25. The executing court shall not precipitate the matter.
No representation on behalf of the petitioner. The list this matter for dismissal on.
In fact, it has become infructuous also, my lords. The writ has become infructuous also.
How?
This is an order, my lords, challenging refusal of right to cross-examine the DHR. Thereafter, their objections under section 47 itself has been dismissed by the trial court, my lords. That order they have not challenged. This is a decree of 2002, my lords.
That's what we'll feel. He has to be here. List this matter for dismissal on 23rd.
Much of it.
No representation on behalf of the petitioner.
7, Monica Patil.
For the petitioner in the matter.
Yes.
Sorry. My lord, the office objection is on IA for recall and reopen of defendant evidence was the IAs filed before the honorable trial court, my lords. And we have filed a common writ petition since it was a common.
Objection with regard to the filing of common writ petition. It's overruled. It is submitted that it's a recall and reopen. Yes. What is the suit?
My lord, suit is for partition, my lord. The impugned order is at page 23.
Suit is of which year?
My lord's 2012, my lord.
When was the cross-examination completed?
My lord, if I may kindly request my lords to peruse the order sheet. 11/1/24, my lord, was the date when the
11/1/24
was when the defendant evidence was taken as nil, my lord. 11/1/24. Thereafter, my lord, on the very next date, we file an application for recall and reopen. Subsequently, my lord, numerous applications are filed by the plaintiff for impleading, amended.
Come to the order.
Please, my lord. It's at page 23, my lord. There's no reasoning as such, my lord. At page 24, the honorable court indicates that I have carefully perused I 17 and 18. May I read, my lord?
No, what is this? I'm not able to understand.
Please,
When
ma'am.
counsel for the defendant submitted that when the case is posted for defense evidence, if the court has taken defense evidence as nil as per the order dated 11/1/2024 and already reopened the stage of the defense evidence, what is this?
My lord, no, that order was never passed, my lord, for reopening the stage of defendant evidence. Our IAs which were previously filed were kept in abeyance because of numerous applications filed by the plaintiff thereafter.
Please come. Then counsel for the petitioner submits that on 11/1/2024, their evidence is recorded as nil. Then immediately on the next day, an application is filed for reopening and recall. The court, without giving any reasons, without any reason, assigning any reasons, has dismissed the IA. It is submitted that it is stated that on the day due to oversight and bona fide mistake, they have not appeared before the court. And the court ought to allow the IA, considering the same, there shall be stay of all further proceeding, pursuant to the order dated so and so. Till the next date of hearing, same hand summons, memo shall be filed by 2nd of July, or else the stay granted with this court stands vacated.
May I also request, my lord, there's another connected matter where the suit stands stayed. Plaintiff has filed a writ and sought for stay of the suit, my lord. And if I may request for that to be tagged, because an amended, on application for
Tag
amendment.
along with that so and so. Yes, take that. Next.
I'm grateful. ma'am.
Number 8, CS Prasanna Kumar.
For. Respond, my lord.
Use the ten-
Petition.
Yes. All are served.
So all are not necessary. I am the only necessary party.
That's for him to say. Did you say?
Yes,
so?
yes, my lord. Now the question is,
I
as
will file a memo also. We have to record it if there are.
I am not seeking dispensation of notice to anybody. It is he who says it. As far as I am concerned, everybody is a necessary party because the order affects everybody. The order affects everybody because an order.
First, let me hear. What is the?
May I take your
What is the
lordship?
impugned order?
The impugned order. my lord.
Impugned order
Kindly take the impugned order.
Page number.
and annexed A, page 42. May I make a backdrop of the case so that your lordship could find it very easy to understand that?
Yes.
Your lordship may kindly see this is suit for declaration and possession. The claim of the plaintiffs are that one Shilpa Shi,
You are the,
one Shilpa Shi, a girl name.
for the defendant.
I am for the defendant. I am for the one Shilpa Shi died as an orphan.
Yes.
Died as an orphan. She was cremated with by the corporation. She was working in the TCS company.
Mm.
Her death was not known to anybody. It's only when it was condolences were offered in the Facebook, the plaintiffs came to know of the death of Shilpa Shi. They said, we are the legalists. So they say the mother of Shilpa Shi died long back. Her father is living in incognito. Your lordship, may kindly, the word used is incognito. So as such, the father is also not entitled to any share. We being the maternal aunt children, we are entitled to for a declaration, possession of two properties. One property is an immovable property. Other property is the movable of the terminal benefits of Shilpa Shi amounting to more than 1 crore of rupees.
Yes.
They filed this present suit for a declaration and possession of all the property. The defendants are, some of the defendants are the tenants, some of the defendants are the persons who claim to be sitting on the property by virtue of an agreement of sale by 53A. Now what happened to your lordship, initially all the defendants were placed ex parte. The first defendant filed an application for setting aside the ex parte order. It was set aside. He filed a written statement. He was the evidence was let in. The plaintiff, that is the respondent number 1, was examined in chief in Bangalore at Bangalore court. When it posted for cross-examination, he appears to be in Germany. So cross-examination was done with the mode of which it is not known. Anyway, the cross-examination was done. Thereafter, I came to know the pendency of the proceedings. I filed an application order 9 Rule 13 to set aside the ex parte order and afford me an opportunity. The application was allowed. I filed a written statement. Then I filed an application, IA number 31. Your Lordship may kindly turn 31 at page 119.
Yes. Yes.
I filed an application stating that the procedure conducting the cross-examination was without reference to the VC rules, and the entire proceedings is vitiated on account of non-observing the VC rules. Then the learned judge agreed with that and passed an order. Your Lordship may kindly see, he passed an order at page 129. At 129, Your Lordship, IA number 30. IA number 31 is filed by the defendant number 2 and to recall the order passed by this court on 9/1/2026 on the ground that it is not in consonance with the provisions of video conferencing rules. Needless to mention that the evidence to the video conference shall be recorded as per the rules for the conference for the courts. So then he said, the court accepted that the earlier recording of evidence without reference to the video conference rules. Then I made and I was called upon to cross-examine. The next time the BC was appointed, then when I filed an application, memo stating that the cross-examination so far conducted as part of the PW1 is concerned requires to be expunged because it's contrary to the video conference rules. The learned judge said it is a procedural irregularity. I will not recall it, and he rejected my memo. It is that order that has been challenged before this court. The point that requires consideration by this honorable court, whether the video conference rules is mandatory or a directory, whether any evidence recorded in utter violation of the video conference, could it be legal? These are the 2 points that has to be answered by this court. Now, Your Lordship may kindly see the video conference rules. May I pass on the rules, my lord?
Let us first look at the impugned order.
The impugned order is at Annexure A, saying that it's a procedural irregularity, so it can't be Annexure A at page 42. May I take Your Lordship to para 7? Up to para 7, it facts what happened to court transpired is the summary of it. Para 7, Your Lordship may kindly see. Your Lordship got it. Para 7 at page 47.
Yes.
On 4/12/2025, A number 30 is filed by the second defendant, that's me, to set aside the ex parte order passed against him. In the application, defendant number 1 has not contended that someone's due was not duly served. Still, the plaintiff submitted no objection, and therefore, IA number 30 was allowed on cost of 30,000, with a condition that the defendant shall file the written statement, if any, on or before the next day hearing date, and cooperate for the disposal of the suit at the earliest by proceeding with the trial as far as possible on day-to-day basis. But when the case was posted to 15/12, again the defendant number 2 sought time to file a written statement, and defendant number 2 filed the written statement on 16/1/2026. Additional issues were framed on the request of the second defendant. PW1 was recalled for cross-examination. In the order dated 9/16/2026, the court has recorded that earlier also the cross-examination of PW1 was recorded virtually and posted the case to the 24/1/2026 for cross-examination. But that day, defendant number filed an application IA number 31 under section 151 of the CPC to recall the order dated 9/1/2026 to record the evidence in accordance with the video conference rule prescribed by the Honorable High Court. IA number 31 came to be allowed and posted the case today for cross-examination on behalf of the defendant with a direction to the Consulate General of India, Munich, Germany, and also PW1 to tender the cross-examination. So earlier, remote point was not done, consulate was not given, consulate was not provided. So the learned judge says yes.
Where is your IA?
IA 31/119. Annexure G.
When was that ex parte order set aside?
On the 14, on 4/12/25, IA number 30 was, your lordship can turn at page 7, para 7 of the order.
When was he cross-examined?
Cross-examined on him on, the earlier it was cross-examined earlier by the first defendant.
This virtually, when was he cross-examined? What is the date?
Virtually cross-examined on a later date, I mean, I'll say your lordship. ಇದಲ್ಲಮ್ಮ. Your lordship, I'll take it. I think it's after I think on the very same day, I believe it's done.
Cross-examined by the first defendant.
24/1/2026.
How? Lordship, I may kindly take Lordship to the para 5. Kindly take 5. May I go through? This is a suit filed for reversionary right, basically. 2010 seeking the relief of declaration, possession and other reliefs. There are 7 defendants initially.
What is the prejudice that is caused to you?
Now, your lordship, I kindly see.
Where did you say in your affidavit?
I have said your lordship, may kindly see in page 31, IA number 31, the evidence recorded without reference to the VC rules is void. Is illegal. That is the precise contention. This court has to decide whether the VC rules promulgated by this High Court, is it mandatory or regulatory? If it is mandatory, then whatever has been recorded without reference to the VC rules has to be go. Now the question is whether it is admitted by the court the procedure for VC rule conducting the exam, cross-exam VC rules was not followed. Your lordship may kindly see under the VC rules, the entire proceedings has to be videographed, and I entered to copy of it. Rule, your lordship may kindly see. Your lordship may kindly see at page 5, I mean para 531. Whenever there is a overseas evidence, the witness is at overseas, the official, it shall be at the embassy, not at his from his home.
That's what, that is number 1. That is according to you, that one that is not followed.
Yes.
Yes. Then what is the other one?
The other one is whether the non-following of it makes the evidence so recorded is valid or not.
So what is the irregular? What was not followed? That is one. And that it was recorded from his house, but not before the
In consulate, not before the consulate. It was not. It's not videographed as contemplated.
Number 2, it is not videographed.
Yes.
Anything else?
Yes. Then the third point is that there was no person to identify him as such and such a person is the witness, and there was no procedure where the other people could be present, because the very purpose of video conference cross-examination is to see that he is not tutored by somebody. So the court should.
Kindly take 5(1) in the rules. There shall be a coordinator both at the court point and also at the remote point from which the required person is to be examined or heard. However, coordinator may not be required at the remote point only when the witness or a person accused of an offense is to be examined. This in the present circumstances.
This aspect we have already examined. If you look at further, there is some confusion in this.
There is absolutely no confusion.
No. You read it. To read the further provisions.
May I take your lordship to the 8, section 8.
Rule 8 is the process for examination of persons.
ಅಲ್ಲ ನಾ ಹೇಳ್ತಾ ಸೇಮ್
ನೀ ಹೇಳಿ ತೊಂದ್ರೆ ನಂದೇನು ಅಬ್ಜೆಕ್ಷನ್ ಇಲ್ಲ.
ಇದರಲ್ಲಿ kindly take up 8. Any person being examined, including a witness, shall before being examined through video conferencing produce on file proof of identity by submitting an identity document issued or duly recognized by the government of India, state government, union territory, or in the absence of such a document, an affidavit attested by any of the authorities referred to in section 139 of CPC or 297 of CRPC, as the case may be. The affidavit will inter alia state that the person who is shown to be party to the proceedings or as a witness is the same person who is to dispose at the virtual hearing. A copy of the proof of identity of affidavit, as the case may be, will be made available to the opposite party. The person being examined will ordinarily be examined through the working hours of the concerned court or at the time of the court may deem fit. The oath will be administered to the person being examined by the coordinator at the court premises. Court point, where the person being examined or the accused to be tried is in custody, the statement or as the case may be, the testimony may be recorded through the video conferencing. The court shall provide adequate opportunity to the under trial prisoner. This will not apply. Subject to the provisions of the examination of the witnesses contained in the Evidence Act, before the examination of the witness, the documents, if any, sought to be relied upon shall be transmitted by the applicant to the witness, so that witness acquires familiarity with the said document. Applicant will file the acknowledgement to the court. If a person examined with reference to a particular document, then the summons to the witness may be accompanied by duly certified copy of the document. The original document should be exhibited at the court point in accordance with the law. The court would be at liberty to record the demeanor of the person being examined. The court will note the objections raised during the deposition of the person being examined and rule on them. The court shall obtain the signature of the person being examined on the transcript once the examination is concluded. The signed transcript will form part of the record of the judicial proceedings. The signature on the transcript of the person being examined should be obtained. If digital signatures are available at both the concerned court points and remote points, the soft copy of the transcript digitally signed by the presiding judge at the court point shall be sent to the official email to the remote point, where a point out the same will be taken out and signed by the person being
There is
examined.
complaints of 8.8 and 8.81.
Yes, it has been complied with. It is by the first defendant, D1, who did all these things. He was satisfied. There was no objection from him. It has been accepted. Now the present problem has been raised by the defendant number 2, who came on record as the contesting defendant after 4 years, not initially. And he directed the court, not requested, directed the court to expunge the earlier recorded video conferencing orders. So how can a party can direct the honorable court to expunge it? It is a public order. And what he sought is the record of the video conferencing was as per the rules. And it is not absolutely necessary for a court to engage a media of the embassy for examining through the video of a plaintiff. He was not an accused. It is not necessary. 5(1) exempts it. And it certainly permits even the video conference through the what you mean, television or his own laptop. It is permissible. I shall show you the gazette copy itself. I have made a note of it. It is everything is permissible. If judge is satisfied, Karnataka Gazette. I think it's 15 it comes, I believe.
Password.
Right. I made a note of it and
For 9, Arjun Santosh.
Yes.
Happy for petitioner. The petition is filed challenging the common order filed in the common order in 2 IAs filed by the respondent under petition under section 16(3) of Telegraph Act, my lord. All office objections were complied, but still shows 3 office objections, my lord. One office objection is court fees paid is sufficient or not. Mention the amount payable. We have already paid an amount of 200 rupees as court fees as 2 distinct IAs common order being passed, so 200 rupees court fees has been paid. Whether the name, age, proof of senior citizen, address of the petitioner response stated is full. Everything has been stated as full as per the cost title, my lord. And whether reason of not making any other parties in the court below.
All that are not listed, you know, what is to be complied with?
All of-
Single red petition for challenging more than one, that's only remaining.
Yeah, that office of assumption, my
The
lord.
other office objections are not there.
Okay.
Office objection,
That's complied, my lord. Well, the office objection is with the common.
office objection. Is overruled. Yes, sir, with the matter.
Yes, my lord. This is a petition which is filed under section 3 of the Indian Telegraph Act. The petitioner, Power Grid Corporation, they had laid lanes in the year 1991.
Full matter, the other date has come.
Yes, my lord. Your lordship.
Post it.
Date it's not.
Give the number.
Yes, my lord.
List along with so and so notice to the respondents.
Yes, my lord.
Yes, 10.
10 and 11 and also content matters.
Same, list along with so
I'll
and so
should give
notice to the
the
respondent.
much obliged, my
Yes,
lord.
12.
12, Karan.
In all these office objections are over. Yes, 12.
Appearing for the petitioner, my lords. My lords, office objection is that, my lords, there are 2 suits, my lords. Common order has been passed, my lords. And the office objection is that, my lords, the parties in OS number 1017 have not been made as party herein. Plus, this petition has been filed, my lords, with respect to OS number 2017, my lords. Another petition has been filed, my lord, with respect to 1017, wherein I have made the parties, please.
Where is impugned order?
Impugned order is at annexure A, my lords. Page number 18, my lords, is the page number 18, my lords. It starts. My lords,
No, all are parties to this.
please, my lords.
2 suits are
There
clubbed
two
together and
suits.
the application is taken together. The
So
only
I-
point is whether the civil court has jurisdiction or the commercial court. The learned judge has said, since there is a dispute with regard to the lease deed itself challenged, that it is a bogus and fraudulent, that court has jurisdiction, so it assumes its jurisdiction. Ventilating the grievance before the commercial court is rejected. That's the only point to be answered.
No, with regard to the parties.
Yes.
Parties, my lords, with respect to the parties in OS number 1017, my lords, there is a separate petition filed. In that, they have been made as parties.
Where is that petition?
That petition is pending, my lords. In fact, that was heard before vacation, my lords, and this court
The
said.
number, both we will have and dispose it of.
Please,
Can
my
be.
lords.
Post
But
along with,
They are not paying rents.
post along with.
A defaulter is before the
After
court.
tomorrow.
Please, my
Yes.
lords.
Give the number.
Please, yes, obliged.
13. Tucker Reddy.
Responding.
Yes.
Petitioner, my lord.
What is office objection?
Office objection, my lord. The respondent number 2 is repeated as respondent number 3. That is not correct, my lord. Respondent
and
number,
R2 and R3 made a party twice.
yes. No, my lord, they are the different parties. my lord.
Let's
Kindly
see.
see cast statement. Respondent number 2 is Munraj. Respondent number 3 is Yellamma. In the petition, writ petition.
This
Respondent
R2
number
is
2,
Ratnamma, R3 is
Yellamma.
3 is Yellamma, defendant.
Yellamma.
Lamma.
Not repeated. my lord.
Munirasu is repeated.
Munraj is what happened, my lord? Yes,
Son of Dodda Ellappa, aged
Yes.
53 years.
Munraj is repeated.
Son of late Ramakrishnappa, aged 55 years.
Yes, as a respondent number 2. Earlier, my lord, he was a plaintiff number 2.
No, in your respondent number 2 and 10 are not one and the same.
Yes, I filed memo to delete that one.
Which one?
The respondent number 2 as a respondent number 22 as repeated.
22.
22 minutes.
22 is Krishnappa.
Krishnappa.
Ram Krishnappa.
C. Krishnappa.
C. Krishna.
Respondent number 2 in the petition and respondent number 22.
I am looking at your cause title. Please look at the
That
cause
is
title.
corrected.
Now look at your cause title.
Yes, 23.
Muniraju
Kindly
and
see.
Muniraju are repeated at
Respondent number
23.
23 minutes.
23. If my lords would see it, page 8.
Yes.
Yes.
Muniraju, son of Krishnappa, Ram Krishnappa.
What
Munir.
about this Ellamma?
Yellamma is not repeated. madam. That
It's
is
not repeated.
is
Only
not
this.
repeated.
Then who is defendant number 22?
22, my lord, he was a plaintiff number 2 earlier, my lord. Because again, transpose application was filed before the court.
Now he's transport as
Yes,
plaintiff.
transpose as a respondent number 22, my lord.
Then take steps. You should have deleted it long back.
My lord, I filed memo for
Then,
deleted.
sir, take that. Memo is filed. Taking permission to delete respondent number 2 and retain respondent number 22 as plaintiff number 2 is transferred as defendant number 2. Accordingly, memo is taken on record and the petition is permitted to carry out the necessary amendment. Yes.
My lord, in this petition, the IA number 15 has been challenged by the
Page number
page number
84.
order.
80.
IA is 84.
My lord,
Order
IA
is
is 84.
order.
Order is, my lord, the annexure A, page number 19. It is, my lord, the between the defendant versus dependent. This is the IA. Earlier, my lord, the defendant,
Read as?
my lord, the defendant number 6 is a defendant number 11 has filed the IA. This is the IA number 15. Filed their the application for amendment of the written statement by deleting the admissions. Earlier, all the defendants, my lord, 1 to 12 and to 15 to 18 filed the joint written statement in the suit. But after lapse of 9 years, this application was filed for delete their admissions and insert 2 paras in the written statement without consent of other defendants.
No,
This
Who have filed the common written statement?
common written statement filed by the petitioner along with the defendant number 11. 11 is filed this
Got
application.
defendant number 6.
Defendant number 6, who is the petitioner before this court?
That's what I'm saying.
Yes, my lord.
Defendant number 6 and who are the other defendants?
Other dependents, my lord, the dependent number 1 to 12 and to dependent number 15 to 18.
You have filed a common written statement.
Common written statement filed.
When was it filed?
2016 filed.
Uh,
Now there, the dependent number the 11, that 18 to 19 defendants filed
Defendant 11.
dependent number, my lord, this application filed dependent number 3, 11 to 18.
3.
11 to 18. Filed the application. for delete their, the admissions, delete their as a false, that is deleted as a true. And where their true is there, that has to false. These are they are supported the plaintiff case now. Entire the case is supported to the plaintiff case.
Now please come to the affidavit.
Affidavit, kindly see the 84
86.
application, 86 is the affidavit. Para number 3, madam.
What is the stage of the suit now?
Now is malad their
Issues are
the
framed.
amendment.
Amendment is,
Amendment
the
and implementing,
evidence is yet to commence. And 10 years, my lord, all these applications, IA-12 was filed, he got IA-12 allowed. Now when 15 is filed, he is in the writ petition. The suit is for partition. Intersay between the same parties they are
In the
seeking.
para number 4, in the last 4 paras, malad, since malad, I permitted to read malad. Since I and my other family members are not having a much knowledge about their court proceedings, defendant number 4 and 6 are well versed with the litigation and other aspects. We have believed them, they will render the justice to all, and on blind faith on them, we have signed the wakalat and a written statement, other court documents, which was prepared by the counsel engaged by the defendant number 4 and 6. This is the allegation. In para number 6, I and other the defendants have obtained the NOC from other earlier counsel. While briefing the case onto my present counsel, I and defendant number 3, 12 to 8 noticed that there are the important facts which are twisted by the defendant, twisted the defendant number 4 and 6, and which are not our intentional statements. The defendant number 4 and 6 have taken the responsibility to look after the case on behalf of all. That point of time, we have clearly instructed to them to allot the share to the plaintiff. Now they're denied their share. Now they're agreed to give the share to the plaintiff. I further submit that the defendant number 4 and 6 intentionally not brought to notice of this honorable court about subsequent developments which are happened during the pendency of this suit. I submit that meantime it is noticed that share is not claimed in the suit scheduled properties item number 1 so and so. Since in the above properties, I and other defendant number 3, 12 to 18 are having a lawful rights to claim the share equally along with the plaintiff and other defendants in the above suit. 7. The schedule item number 3, 6 and 16 are the properties fall on to the share of deceased defendant number 1 through a partition 5/9/2007. Defendant number 1, the Papamma died 11/1/2021. I further submit that I and defendant number 3, 12 to 18 have noticed that defendant number 6 filed IA under 6 rule 17 to insert the additional para number 26 in the stating that properties which are in the name of the Papamma was bequeathed in favor of defendant number 6. On the strength of will, he becomes absolute owner of these properties. The said application is pretended to file dependent number 1 to 12 and 15 to 18, but filing the application is not within our knowledge.
Yes, please come to the order now.
Order in para number Milord, in regard to this IA is concerned, total 4 IAs are disposed by the trial court. On para number 15, Milord, the reasons, page number 26 in the petition. The defendant number 3 and 11 to 18 have filed IA number 15 to delete the denials in para number 9. Add admissions. They are also intending to insert the about the partition deed dated 5/9/2007, execution of the will. The proposed amendment does not alter the nature of the suit or cause of action to take away the defense of the admission. Hence, the proposed the amendments are just and proper. But this is the admissions filed by the joint the defendants. One defendant filed the application for withdraw his admissions. It is affect to the other defendants. It is not the immediate, after lapse of 9 years.
It is all basing on, if you come to page number 84.
84. That is the.
What is it? No, when it is not mentioned, what is wrong in bringing all these facts to the notice of the court so that the court will adjudicate, no prejudice?
This matter, one joint written statement, the question is joint written statement filed by the defendants. After lapse of nine years, one of the defendant filed their application for the amendment of the deletions of the admissions.
Look at para number 5. There is a registered, what is that?
Will and partition.
So this document, nobody can deny. It's a registered document. That facts were not pleaded by you. Now the defendant, he has stated that these are all the grounds not pleaded, so he wants to plead it.
One submission. This is the defendant number 6, the 6 has filed the amendment application 6 to 17. Because under the will, he has claimed the right over the property. That amendment application is allowed.
That is IA 12.
That is
When
IA
that
number.
was allowed, but this amendment becomes necessary. And he doesn't challenge that IA 12.
This is the written statement cannot split by the parties. In case if he has the independent right, he has to file their independent suit. Or the
partition.
But of the written statement is the defense by the defendants. Later on, the defendant versus defendant.
Please place any law on this that it cannot be done.
That is, I refer citation. I will give that in our pleadings in the writ petition. In the grounds, para number 18. The impugnment order is opposed to the law declared by the Supreme Court and High Court in Bombay so-and-so. That is amendment of the written statement. Admissions given in the written statement cannot be allowed.
No, it is not about that. Your submission is that it is not open to them. No, they can't be another written statement. Separate written statement, they cannot take. Separate pleadings, they cannot take. This is a general proposition which you are reading.
No, Malad, in this specific, in regard to the amendment, the written statement is concerned. In the example, two defendants filed the common written statement.
Is this the court? This case deals with it?
Yes, Malad. I will give that citation or any date may be given, Malad. The matter is on 18th.
No,
18th date is there.
No, it is just a simple
Malad,
issue.
the question
If you
3,
can clarify
Malad,
that it is done.
Malad,
That's the only
sorry, Malad, the 3 questions is there. One is the admissions cannot be withdrawn by the parties, number 1. Malad, another, the joint written statement by the defendants. One of the defendants cannot withdraw the admissions without consent of the other defendants. But the written statement cannot split by the parties. That is the question before this court.
But if there is a joint written statement, they have given a reason that they had engaged a common advocate and
another submission, sorry.
One.
Annexure H they filed subsequently. Malad, the court allowed to amendment the para number 26. Again, Malad, the court allowed the amendment of the defendant number the 11 to insert the para number 26 and 27. That is again the defendant number 11 has filed the memo. That is ambiguity. The court has allowed the amendment insert the para number 26 to the petitioner. Again, the trial court to allow the amendment, insert the para number 26 and 27. Very same, the defendant number 11 filed the memo, Annexure H.
Yes.
Annexure H. The question is before the court, Malad, the written statement filed by the defendants jointly. One party cannot withdraw this.
That I understand.
Yes,
that's why we'll hear
yes.
him what he says.
That is a memo filed by the very same defendant before the trial court.
The co-defendant is retracting from the earlier written statement filed. The earlier written statement is placed on record, which is at Annexure D, page 64. In that written statement, there are only one contentions that there is only a denial that is put forward. And they contend insofar as their rights are concerned, insofar as defendants.
No.
1
From
to
the
9.
earlier written statement to this written statement, he says that your certain admissions which you are retracting from those admissions. What are they?
It is not retracting from the earlier admissions. There are no admissions there.
Let's see the written statement.
Yes, there are no admissions.
Come to that.
That is application, my lord. In
Not the
prior
application. Kindly turn to what
84,
the written statement is, my lord.
para number 4. in
Page
the-
67, para 19.
84 in prior, page number 84, para number 4. To add in the line of 15, as at para number 9, delete false and are hereby specifically denied. Add is true and correct. Earlier, all the defendant says it is a false and denied. Now there, one of the defendant says it is a true and correct. And to grant their partition in favor of the defendant, it is the support of the plaintiff case now. Another para number, the 5, para number 5. Starting line number,
In respect of this, already you say that the court has allowed that amendment.
yes, madam.
In respect of this registered document.
This was allowed. Now, that was challenged before this court in this petition.
No. Earlier, that's what you were.
IA 12 was allowed. Now kindly see IA 12. He doesn't speak about that. Page 95.
That is it. 12 is filed by me, madam.
Yes, you get it allowed. Kindly go to IA 12 minute. Defendant state that Papamma, wife of Ramkrishnappa, had executed a registered will in the name of the sixth defendant Gurumurthy Ramkrishnappa on 17/7/2009. In respect to the property, survey number 23, 22, 63.
This was ordered.
This was ordered. Now, when this was not challenged by us, this is now being amended insofar as the plaintiff is concerned. Thereafter, IA 15 was filed. IA 15, we consider to add and delete. Page 84, two things that may require mirror. That is to add in line 15, delete false are hereby denied. Add true and correct. Now take page 67 minute. Para 15 I would point out. My lords get it. That's what is the, I just put it very shortly for your, my lords consider. Para 15, amendments made in para 12 of the plaintiff.
67.
Written statement. Page 16, para 15. Page 67, para 15.
Yes.
15. Para 12, the plaintiff that defendants are making attempts to alienate suit properties, that in regard to the plaintiff's approach, defendant in the first week of October 2015 and requested them to reopen the alleged partition and to effect fresh partition and also to allot their share over the suit properties. The defendants threatened the plaintiffs and denied their share are all false. Is what I said. Denied their share are all false and are here specifically denied. This last sentence is sought to be denied. And they say that to delete those two words is true and correct. That is insofar as reopening of the partition is concerned. Reopening of the partition and application in IA number 12 is with regard to the registered will, etc. that is stated. So if he had not got that application allowed, I would not have filed this application. Now go to para 5 minute, to page 84, to line 1, to start fifth line in para 19, to delete defendant state that long back of 25 years, during the lifetime of their father, Ramkrishnappa, all the family members divided the joint family and ancestral property. The said partition was reduced into writing, registered before the sub-registrar on 5/9/2007. But this was what was stated.
No, both 4 and 5 pertains to the very same transaction which the court, permitted the plaintiff to amend.
Yes. And once when they allow it to amend, then I lose my right insofar as it is concerned. Therefore, I sought for amendment. Then in 6 minutes, delete para 20, delete sentence, defendant states that in last 25 years, they are living separately and independently. But that may not be necessary. It all relates to the evidence that could be conducted. So 1 or 2 sentences where they intend to retract and say that this is the true facts that have gone into on the basis of the registered document. My amendment.
And what is this para number 26 and 27?
Not
I
para.
pick up a new case now.
Not para 26 and 27. This is only in reference to a facts that took place, not as on the date. Papamma's death, I have said. partition deed 59/2007. A schedule properties have fallen to the share, but it would amount to an equitable division insofar as properties are concerned. Practically, the suit itself can be gone into on the basis of these contentions. No harm would be caused to them if this amendment is allowed.
Yes.
The para number, page number 70 in the written statement prayer, last prayer.
Yes.
All the defendants filed the written statement. Defendant prays that this honorable court to dismiss this suit.
Now he has submitted what was the earlier stand, what is the present stand?
Present stand is, my lord,
Almost 3 paragraphs of the present amendment pertains to the registered deed of the year so and so. That amendment is already allowed, which is taken by the plaintiff. And as far as
No,
the
my lord.
registered
No,
document
my lord.
is
IA
concerned,
number 12 is the amendment of the written statement filed by defendant number 6. Written statement has to amend as per the IA number 12, because the 21, the defendant number 1, who is the mother of the petitioner, died. But they leaving behind their the registered will.
the same contentions are taken now.
Same contentions, para number 26, I have no objection. Delete their the false and true in their admissions earlier given in the written statement. That is affected the rights of the petitioner versus dependent the written statement as amended by the trial court. One is insert the para number 26. Another is the delete the admissions. It is a joint written statement. How which followed by their the trial court by the without consent of the other defendants to delete their amendment of the admissions given by the both parties after lapse of 9 years. Now their insertion of the will, my lord, the IA number 12 is, that is the petitioner's will. He has filed the amendment. Amendment is allowed. Again, there the insertion of the defendant number 6 is not necessary. 26 already inserted. But the deletion of the admissions earlier has a pass. Now is it true? And we have no objection to partition of the properties. What is the prayer of the written statement? In case if they are having any right and prayer, they have to file the separate the written statement with the permission of the court. But that is not there before this case. Now they are affected the rights of their other defendants.
Yes, I'll consider.
This,
Yes, sir, reserve. This next.
14.
What is this letter?
The date is 18. But the proposed amendment will be affected. Till that, the
No, list on 18th for pronouncement. List on 18th for pronouncement.
The prayer in the writ petition is to dispose, direction to dispose of the FDP of the
One minute. We have
2004.
received the report from the concern. Why it is?
amendment.
I think there is no officer, I think, present.
My lord, the order sheet, my lord, there is a now regular officer is there, my lord, from 2014, my lord. 2014 is the FDP proceedings, my lord, started. Earlier it was 1 of 95 FDP. Then there was a, my lord, change of law and therefore new FDP was filed. Then it was registered as, my lord, FDP number 4 of 2014, my lord. From 2023, my lord, only applications for appointment of commissioner was heard and orders were reserved. Then it was released. Again, it was posted for arguments on the such applications, my lord. For 12 years, my lord, FDPs, my lord, kept pending.
Oh, a regular officer is there only from 15/6/2026. From a long time, no officer, regular officer is not there. Somebody is in charge, I think.
May not be from 2014, my lord, and the regular matter was heard, my lord, by the court also on several occasions. Order sheet reflects that, my lord, applications were heard and
please come. The present petition is filed saying the following prayer. Land council appearing for the petitioner submits that this is the original FDPs of the year,
1 of 95.
one
Then
of
my lord,
95, and thereafter, in the change of law, they have filed another proceedings in the year 2014.
14, FDP 4 of 2014.
4 of 2014, and the same is pending from there on. Hence, the present petition is filed. This court has called for a report. A report is placed before the court stating that till recently there was no regular officer to this court. Now, a officer is posted. Considering the fact that this is the original FDPs of the year 2000, 1980.
1995, my lord.
1995, and even the second, and these proceedings were also initiated in the year 2014. This court deems it appropriate to direct the court to dispose of the pending FTP as expeditiously as possible. How many are, what are the property, how many respondents are there?
No, no, the contesting is only respondent number 1 to 4, my lord. Other respondents shares I have purchased, my lord. Petitioner had purchased. Only respondent number 1 to 4, one family members is contesting, my lord.
But still it takes time, final decree proceedings, like we can't, a month or two it won't happen.
Lordship may fix some, at least a year, my lord, lordship.
Within expeditiously, as expeditiously as possible, but not later than a year.
Please, great.
Yes.
Lord, the petition arises out of,
It appears for both one, avoid service of notice.
Lords, wakalat has been filed by both advocates, my lords, as per the Honorable Court's website. On 8/6 and 10/6, wakalat has been
It
filed.
appears for both,
No, my lords, perhaps not.
look at it,
Mr. Giridhar appears for the other.
his name is not printed in the copies.
Please.
In the name of Mr., this is 15.
15.
In the name of Mr. Giridhar.
SV Giridhar.
SV Giridhar for respondent number,
2, my lords.
respondent number 2.
Correct, huh? Lords, any short date, only reason is my suit is closed.
Matter on 19.
Great.
Yes.
16, Prasanna Kumar.
Applied with. One of the obvious objection is that the first petitioner has to be represented. They are represented by partner, all the names of the partners are finding there. And the other objection is, there are 2 IAs which were disposed
Single
of.
petition filed for challenging more than I1 to be clarified.
The-
Received signature of caveator
There is-
advocate at presentation for tally.
There is no prohibition that a single writ petition cannot be filed in respect of 2 orders. Because we have to pay the court. The normal practice is.
That is true. There is a circular issued to them saying that there is a confusion with regard to all that. So let there be 2 separated petitions. What is the impugned order?
The impugned order is with regard, kindly turn to.
Is it
page-
a common order?
Common order,
Where is that?
107.
Yes,
Normal practice we follow is pay the court fee on each of the IAs.
that is true. Recently a circular is issued.
There is one judgment of.
That is the difficulties while passing the orders, 2 different IAs unconnected. If they are questioned and like when we say writ petition allowed, writ petition dismissed, it is creating a kind of confusion. It has come across in several matters. That's why I said to file a separate instead of paying the court. Anyhow, you're paying the court fees. You can
I have
as well
paid the
file-
court fee.
You can as well file 2 writ petitions. Anyhow, as far as this is concerned, yes, office objections are overruled. Then what about the other one? That is, you have received the, yes, office objections, 1 and 2.
That is,
overruled.
the first petitioner is represented by other partners.
Yes.
2 to 4.
Only one respondent.
Only one respondent.
Yes, what is IA?
IAs are that there is a, kindly see, the suit is filed for recovery of the money on the basis that we have supplied the goods to you from February 2025. Kindly turn to page 16, madam. Page 16.
Yes.
It is submitted to the defendant have completely stopped forthwith for effecting payments in respect of the invoices raised with effect from February 25.
Where are you reading 16? Oh,
Claims,
yes, sir.
page 16.
Yes.
0. It is submitted to the defendant have completely stopped forthwith of effecting payments in respect of the invoices raised with effect from 2/25. The claim is that the sales which have taken place after February 25. Now application is filed. They don't say that what are the documents filed. Kindly turn to page 73.
Yes.
We are being asked to place entire our business records. Serial number 1, page 73.
Including the sections pertaining to
April 24 to February 26.
produce the below mentioned documents. 24 to 26.
They can't seek for the information from the documents of business transactions which are not connected with the suit. They have to specify what documents they want.
What is the affidavit that is filed? Why they want all this? Let's see.
They don't say why these documents are required. They simply say some things. Para 15 is relevant at page 78. In fact, para 15 they say
Para 10.
para 10 is that production of the document, invoices. The invoices they say, but they does not say why they require the documents of the year 2024 and others. Simply they refer to so many statutory provisions. And so far as other IA is concerned, kindly look to para 15, my lord. Para 15. I submit that the plaintiff has preferred another application order 11 to 1C2 CPC, which are documents related to ITC and TDS claims of the defendant. Though the same are insufficient, as the same do not link the transaction to each other. In view of this admission, the other IA should not have been allowed. And one other aspect is, kindly bear in mind, the Commercial Courts Act. Kindly have a look to Order 11. Rule 6, Subrule 1, Subrule 6 of Rule 1. Unless they comply with this rule, they can't maintain an application. It opens with the heading Disclosure and Discovery of Documents.
1 minute.
Order 11, Rule 1. ಬೇರೆ ಪೇಜ್ ಇರಬೇಕಲ್ಲ, ಅಲ್ಲಿ ಬೇರೆ ಪೇಜ್ ಇರ್ತದೆ.
There are all some amendments.
Because
Commercial courts.
the sub rules are also numbered in the same, the numericals. It becomes little
No, it's all amendments, sir. This,
amendments.
starts with the amendment.
Yes. You know,
Amendment to section 2, amendment to 3.
Order 11. Disclosure, discovery, inspection of the documents in suit before the commercial court of the High Court of Commercial Courts.
4, 7.
Commercial Courts Act is there.
Look at it, give it to him.
Not check. Even for the subclasses, same numerals are there. That is the Order 11, Rule 1. Kindly turn to Sub Rule 6. The plaintiff shall set out. Got it, madam? Next page. Our same page. Sub Rule 6.
The plain shall set out details.
The plaintiff shall set out details of the documents. Got it, madam? Documents which the plaintiff believes to be in power, possession, control, or custody of the defendant, and which the plaintiff wishes to rely on, and set out the leave for production of thereof such documents. Unless he sets out the documents which are in my possession power, at the time of filing the plaint, he can't maintain an application.
Yes.
Then kindly see the Order 11, Rule 5.
Yes.
Production of documents.
Yes.
Now they have to issue a notice. Rule 2.
Yes.
Notice to produce the documents shall be issued in form provided in Form 7 of Appendix C of the report. Any party or person to whom the notice is produced is issued shall give not 7 days time and not more than 15 days to produce the documents or to answer the inability to produce the documents. The court may draw adverse inference against a party refusing to produce the documents is the provision.
Yes.
Now what the court says is, you give a notice to him. If the notice is given, I must produce the documents.
Yes.
The rule does not contemplate once the notice is issued. If I don't produce it, adverse inference drawn if I am without the documents, that is at the trial. But they can't. The court cannot direct that produce the document which are mentioned in notice, because court has not decided the available documents with me.
Yes.
Only I relied upon one of the judgment of the Delhi High Court.
Take it.
First page. First page.
Yes.
Para 8, Muller.
Yes.
Para 6, I'm sorry. The operation of entire rule full, there is no intervention of the court is called for. Merely issuing notice to the counsel for defendant, production of originals with the office copies would be suffice. The contention of the counsel that the plaintiff that after hearing an application will be higher pedestal than merely issuing notice cannot be accepted. The underlying idea of the Commercial Court Act was to expeditiously appear the plaintiff is not interested in the expeditious disposal of the claim suit. PW1 has been under examination on 20th April 21. Now, Rule 8 of Order 21 is as applicable to Commercial Court is not a new provision and similar to provisions Order 11, Rule 16 and Order 12, Rule 8. The plaintiff, as the author of the document, the copies of which are already claimed to have been filed before the original which are claimed to have been sent to defendant, merely by issuing notice under Order 11, Rule 5, can produce the office copies in accordance with law. And then the rule for the benefit of the counsel plaintiff is explained that witness of the plaintiff is then required to prove that the original documents which the office copies are filed were delivered to the defendant. The office copy is produced or a extract replica of original. Service and notice is followed by the Rule 16. Plaintiff has issued notice prior to the putting PW1 in the witness box. So all such exercise must be completed before the evidence completed. Now in this case, the plaintiff has commenced his evidence and he examined PW1 on 5/2/2016. At the time of after commencing the trial, such an application cannot be filed. And the court cannot say that issue a notice to him and after receipt of notice, I must produce the documents.
Yes.
The court can draw the adverse inference if it is found that relevant documents are withheld. To that extent, the order is required to be modified. And the other application to condone the delay has to be dismissed because they themselves say that these documents are not relevant.
Yes.
The other judgments are, the documents are denied, it can't be directed to produce. That is 2018 2 KCCR 1439, 1433. On the same point, there are two judgments. When I deny the document, there can't be a direction.
Yes. Which
Then
paragraph?
2019,
Which paragraph?
yes,
Which judgment?
a short judgment. Appearing for the parties are noticed that the plaintiff has stated that original of this document is not in his custody. As such, same cannot be directed to be produced by the plaintiff. On these grounds also, memo filed by defendant came to be rejected, which the impugned order presents it appeal. Paragraph 4. Then the other judgment is Justice Krishna Kumar. Paragraph 4. When I deny the existence of documents with me, there can't be direction. Number then,
Kumar's judgment, para 4 is the contention.
yes,
Where is the finding?
I perusal of material record include the impugned order will indicate that the trial court has correctly and properly considered the appreciation of the entire material record and has recorded the finding that the petitioners would not be entitled to seek direction to the respondent to produce the said documents. In the context, it is pertinent to note that respondent plaintiff has specifically stated that he does not have the custody of personal documents. Then, the other judgment is 2019 1 KCCR. You can't shift the burden on me. Kindly see, it is only documents which are admitted in the written statement can be summoned. The petitioner defendant have filed the writ petitions of this court in Article 2 of the Constitution of India, passed by learned trial judge rejecting the defendant's application seeking production of certain documents with our following observation. Suit filed finding for recovery of money. The suit of the year 2010. There is a present application is filed in direction to production of certain documents. The direction has to be direction plaintiff are denying the complaint. On perusal statement, there is no whisper about the documents which are stated to be in the present application. The learned counsel plaintiff read upon judgment of so and so. The learned counsel plaintiff submitted that the order of production of document is to be based on justness and relevancy of the document. It is an argument of plaintiff that the defendant has to prove his own case taken by written statement. The defendant cannot ask production of documents which are never cited in the written statement. Unless it is pointed out that these documents are relied upon by me in the written statement, the application cannot be maintained. On these counts, my submission is the writ petition deserves to be allowed.
Yes.
The Lordship and Lord had rightly said that there is a need to have different writ petitions for a different reason, because in this there are two orders which are called in question. One is an order on an application which I filed seeking permission to produce certain documents by me, which has been allowed. The other application I filed is for him to produce certain documents. Now, if your Lordship sees the writ petition, all the grounds which are raised are only against the second order. There are no grounds insofar as my own production of my documents which has been allowed.
That's why, my Lordship sees the grounds. All of them are insofar as only the other application is concerned. Though both page 6 onwards, if your Lordship sees the grounds, they're all insofar as the order directing him to produce documents. Insofar as the order directing, permitting me to produce my documents, there's no ground raised insofar as writ petition is concerned.
So those two AS are questioned here.
Two AS, those are sought to be questioned. No ground is raised insofar as my own production of documents.
No. Yes, Mr.
Kindly see, my lord, the order. There is IA 13 and 14.
The plaintiff other filed by the respondent because there is a common order. There can't be one writ petition. This is precisely the difficulty why the circular is issued.
Lordship had pointed out.
Office objection with regard to the maintainability is upheld. Petitioner shall file the two writ petitions.
Then I am permitted to confine this writ petition to the later order. I will file the fresh petition on the other order.
The petitioner submits that he'll confine the writ petition to one IA. With regard to that, necessary amendment shall be made.
So far as other IA is concerned, I will file a fresh petition.
The other,
I will confine.
for which one you will confine?
IA number 14.
IA number 14, he'll confine this writ petition. IA number 15.
IA number 13, I will file a fresh
IA
petition.
number 13, the petitioner will file the other writ petition. In this regard, the necessary, the amendment shall be carried out. Yes.
It may be, because the trial court has posted the case tomorrow. Some date may be given so that I make a representation.
This is matter on 20.
Meantime, let the evidence proceed,
This is the matter on 18th.
but let the evidence proceed. But let them not precipitate the matter so far as the order is concerned.
18th, we will decide. Yes.
17, Siddaramaiah.
Yes. For representation on behalf of the petitioner, this is matter for dismissal and don't extend the interim order. Dismissal in the month of August. Yes.
18, Chandranath Tarika.
Appeal. Order under challenge is 13 and rule 1 and 2. Appeal comes, I may be permitted to withdraw and file appeal minutes.
The office has raised an appeal lies to this court.
Yes, ma'am.
The office has raised objection with regard to the maintainability as petitioner has a remedy of filing appeal against this order. The petitioner seeks permission to convert this into a miscellaneous appeal. The miscellaneous appeal accordingly, office objection is sustained and the petition is the petition is permitted to convert the same. For all the statistical purposes, the petition is dismissed as withdrawn and dismissed. Then the office is directed to return all the documents, all the papers. Yes, and within 1 week it shall be converted.
Grateful, ma'am.
Yes.
19, Giridhar H.
Office objection has been raised with regard to the non-filing of two writ petition against the common order. In fact, one order is for reopening for considering the other application. Reopening from the stage of argument to consider the other application.
What is other application?
Other application for referring the matter to the expert for handwriting expert. So that both application has been rejected by a common order.
Office objections are overruled.
My lord.
Yes.
Yes, my lord. The trial court has rejected the application on the ground that the discretion cannot be exercised after the matter is being posted for the argument. In fact, the application
Suit is of which year?
2018, my lord.
What is the suit for?
Suit for partition and separate position.
Who are you?
I am the we are the plaintiffs.
What is this IA?
IA is to refer the disputed signature found in the will, which was later initially the defendants have filed a written statement wherein they have not propounded the will. Later, by way of amendment, they got the will to be propounded. And during the course of cross-examination, the disputed signature was confronted. And regarding the
When was this?
because
When was this? When was it confronted?
no, what has happened when during the course of cross-examination it was confronted. Later, application was filed to produce the copy of the register, which later to be sought to be produced original, which was granted under Right to Information Act. The court has expressed whether it while it allowed other related documents, it refused to mark the document, which is a copy obtained under Right to Information Act, compelling us to secure the original document, the registrar from the sub-registrar office. Then it was the order was the application was allowed, and the concerned official from the sub-registrar office produced that document. And after production of
No, so all this, the dates are relevant.
date of order, my lord.
No,
It,
like when was the cross-examination done?
my lord, after cross-examination,
That's what I'm asking. What is, when
I
is
will,
it?
I will. My lord, this annexure, this application came to be allowed. The document was produced on 26 2005.
26, 2005.
Yes, ma'am. Then on next day, application on 19/7/2026.
2005 or
2000, sorry, I stand corrected. 2025. Then next day of hearing of the matter, 19/7/25, the application which came to be applications which came to be dismissed, rejected, came to be filed. Then the order was pronounced on the on April April 26, 9/4/2026.
Yes, please come to the order now.
Big up. Order, man.
Come to the reasoning part.
Yes, ma'am. May I take your lordship to page number 63, my lord. The plaintiff filed the present suit seeking partition and separate position. The evidence on behalf of both the parties has already been concluded, and the matter is posted for argument. At this belated stage, the plaintiff have filed their present application seeking reopening of the case and reference of the document for expert opinion, which clearly demonstrate their intention to protract the proceeding and delay the disposal of the suit. The plaintiff had sufficient opportunity during the trial to take all necessary steps. They have examined witnesses, produced the document, and cross-examined DW1 in detail. The document which now seeks to send for expert opinion are already on record and have been duly marked as exhibit with the knowledge of and participants of both the parties. My submission is that came to be marked only in the month of June 20 on 25th 6 to 2025, and immediately on next date the indulgence of the court was sought by submitting two application.
Please come. Why it has come up, when this matter has come up earlier,
Big up.
this is 18 or 19.
Tomorrow, the matter is set down for tomorrow.
Officers raise an objection with regard to the maintenance of the procedure. Where 2 IAs, where more than 1 IA is sought. Office objections or overruled. Then comes for the petitioner submits that. Petitioner has filed an application to reopen and to send the document, send the alleged will for expert opinion as they're disputing the signatures on the same. And the court, without considering the same, has dismissed the application without exercising the discretion vested with the court. Considering the same, it shall be stay of all further proceedings pursuant to the order dated so and so. The petition is permitted to take out hand summons on the counsel appearing to the respondent, file a memo to that effect by 7th of July, or else the stay granted by this court stands vacated. Yes.
For 20,
Much up.
AG Sridhar.
Suit for partition, order 7, rule 11, filed by the defendant is rejected.
I number will condone the delay.
Delay.
I number 1 of 26 is filed to condone the delay of 18 days in filing the revision. Then counsel for the no objections are filed with the respondents. Considering the delay or reasons such as stated, the delay is condoned. Accordingly, I number 1 of 26 is ordered. Yes.
More submission, there is a proposal for settlement suit for partition. In next week, any
Just
date.
spoke now that we'll consider the contempt.
Next
Some
week- next
2 weeks
week
may be
any-
given soon.
Next week, any date may kindly be fixed.
This is matter on 29th of June.
Yes. Achha.
Yes.
21.
It is submitted that there is scope for settlement. Yes.
21, Janardhan.
Notice to the respondent.
My lord, we have filed 2 IAs. One is for condoning delay.
Huh?
There are 2 IAs been filed.
Notice.
There is an IA for condonation of delay.
That's what I'm issuing notice in that.
22,
Notice in condemnation. Yes.
Nityananda.
Obliged.
Petition is permitted to, or take out hand summons. Take out hand summons. Hand summons on the council. Petition is permitted to take out hand summons on the council appearing to the respondent. Shall file a memo to that effect. Yes.
But there's an IA for stay also.
No. Once notice is heard, we'll see. This is matter on 2nd of July if the memo is filed. Yes, next.
22, Vivekananda.
Where for the petitioner, there is only 4 days delay. There is 4 days delay of.
Take out notice, no issue. Same in this also, but give a short date, 30th. Memo shall be, if the memo is filed. This is matter on, if memo is filed by 29, this is a matter on 30th. Yes.
23, Taranath Shetty. 23.
Nobody is there after that. We'll see. Any signatures? The speed of the span should be reduced. Something it changed, not
My lord.
not increase, reduce.
My lord.
Reduce.
My lord, if I may, my lord, one submission. My lord's one submission. Serial number 24, my lord. It needs to be MFA. We have filed WP. We may be permitted to convert it to WP.
More, at 2:30 you call that.
Yes. Great.
Serial number really. 24.
Next time.
ಅಬ್ಜೆಕ್ಷನ್ ಇಲ್ವಲ್ಲ?
ಅದೆಲ್ಲ ಆಗ್ಬೇಕು. ಆರ್ಡರ್ 41 and 43 ಅಲ್ಲಿ.
ಏನು ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ರೈಸ್ ಮಾಡಿಲ್ಲ?
ಮಾಡ್ಲಿಲ್ಲ.
2:30ಗೆ ಬನ್ನಿ.
Sir, list two. List two no
ಇಷ್ಟು ಕರೆದಿಲ್ಲ, ಇಷ್ಟೊಂದು ಆದ್ಮೇಲೆ
complete ಆದ್ಮೇಲೆ.
ಇಷ್ಟೊಂದು ಫಸ್ಟ್ ಮುಗಿ. ಸರಿ. ಹಾ ಗೊತ್ತಾಯ್ತು ಮಾಡಿ ಓಕೆ ಹೇಳಿ. ಮೊಂಟೇನ್ ಯಾವ ಲಿಸ್ಟ್? ಎರಡನೇ ಲಿಸ್ಟಾ? ಇವತ್ತಿದೆಯಾ? ಇವತ್ತು ಲಿಸ್ಟ್ ಆಗಿದೆಯಾ? ಡೇಟ್ ಕೊಟ್ಟಿರ್ತೀವಿ ನೋಡ್ಕೊಳ್ಳಿ. ಮೇಡಮ್ ಎಲ್ಕೋ ಡೇಟ್ ಕೊಡ್ಸ್ಬಿಟ್ಟಿದ್ದಾರೆ. ಡೈಲಿ ರೀಚ್ ಆಗಲ್ಲ, ವೇಟ್ ಮಾಡ್ತಾರೆ ಅಂತ ಎಲ್ಲ ಪರ್ಟಿಕ್ಯುಲರ್ ಡೇಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ. ಅವತ್ತು ಫಸ್ಟ್ ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಬರುತ್ತೆ. ಯಾವ್ದು ಡೇಟ್ ಕೊಟ್ಟಿದಾರಲ್ಲ ಫಸ್ಟ್ ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಬರುತ್ತೆ.
ನಮ್ದೇನಾರು ಡೇಟ್ ಏನಾರು ತಗೊಂಡಿದ್ದಾರೆ 23 ಸೀರಿಯಲ್ ಲಿಸ್ಟ್ 2 23.
ಇದೆ
ಇದೆ
ಇದೆ.
ಸರ್
ಫಸ್ಟ್ ಲಿಸ್ಟ್ ಆದ್ಮೇಲೆ ತಗೋತೀವಿ.
ಸರ್ serial number 254. List number 2, serial number 54.
ಇದು ಇದೆ. ವಿನೋದ್ ರೆಡ್ಡಿ. ವಿನೋದ್ ರೆಡ್ಡಿ ಇದೆಯಲ್ಲ.
ಇವತ್ತು ಬರುತ್ತಾ ಸರ್ ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್? ಬರುತ್ತಾ?
ಫಸ್ಟ್ ಲಿಸ್ಟ್ ಮುಗಿದ್ಮೇಲೆ ತಗೋತೀವಿ. ಎಷ್ಟು ರೀಚ್ ಆಗುತ್ತೋ ಗೊತ್ತಿಲ್ಲ. ಮಾಡಿ ಇವತ್ತೇ ಕರಿತೀವಿ ರೀಚ್ ಆದ್ರೆ.
ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಕರಿತೀವಿ.
ರೀಚ್ ಆಗಿಲ್ಲ ಅಂದ್ರೆ ಏನ್ ಮಾಡ್ತಾರೆ ಮೇಡಮ್, ಡೇಟ್ ಕೊಡ್ತಾರೆ ನೋಡೋಣ, ವೇಟ್ ಮಾಡಿ.
ಸರ್ ಅದು ಲಿಸ್ಟ್ 2ದು ಅಡ್ಜರ್ನ್ಮೆಂಟ್ ತಗೊಳ್ಬೇಕು. ಅದ್ ಫಸ್ಟೇ ಕರೀತೀರಾ 2:30
ಇಷ್ಟು
2ದು ಸೀರಿಯಲ್ ನಂಬರ್ 19 ಅಂತ ಅಡ್ಜರ್ನ್ಮೆಂಟ್ ಮಾಡ್ಬೇಕು.
19
ಅದು ಲಿಸ್ಟ್ 1 ಆದ್ಮೇಲೆನೆ ಕರೀತೀರಾ ಇಲ್ಲ
ಲಿಸ್ಟ್ 1 ಆದ್ಮೇಲೆನೆ ಕರೆಯೋದು?
List 2, serial number 57.
57.
I want, so it may not come today because it is 57. And I wanted, I'm 14% in this case. I want, if possible, adjourn 1 week. I'm not well. To address it, it was on procedural inconsistencies. I want to refer it. There was a procedural inconsistencies. It was posted for dismissal. And I have filed an affidavit also in that.
If not reached, please wait till raising of the court. Court will give fixed date.
Can I mention it at 2:30?
It will not take mentioning at 2:30 not take.
No, I wanted a date actually.
Sir, court officers. ಸರ್ ಅದು
ಹೇಳಿ.
madam ಇವತ್ತು ರೀಚ್ ಆಗಿಲ್ಲ ಅಂದ್ರೆ ಸರ್ ಡೇಟು ಮೇಡಮ್ ಕೊಡ್ತಾರಾ ಇಲ್ಲ ಅಂದ್ರೆ ಹೆಂಗೆ ಸರ್ ಅದು ಆಟೋಮೆಟಿಕ್ ಆಗಿ ಕೊಡ್ತಾರಾ ಇಲ್ಲ ಅಂದ್ರೆ ಮೆನ್ಷನ್ ಮಾಡಿ.
ಮೇಡಮ್ ಕೊಡ್ತಾರೆ, ವೇಟ್ ಮಾಡಿ ಸರ್.
ಓಕೆ ಸರ್, ಥ್ಯಾಂಕ್ ಯು ಸರ್.
Court officer? Hello.
ಯಾವುದು?
Court officer,
ಹೇಳಿ.
list number 2 morning ಆಯ್ತಾ?
ಲಿಸ್ಟ್ ನಂಬರ್ 2 ಕರೆದಿಲ್ಲ ಸರ್.
ಕರೆದಿಲ್ವಾ?
ಲಿಸ್ಟ್ ನಂಬರ್ 1 ಲಿಸ್ಟ್ 1 ಆದ್ಮೇಲೆ ಲಿಸ್ಟ್ 2.
ಓಕೆ ಸರ್, ಥ್ಯಾಂಕ್ ಯು.
ಈಗ ಬಂದಿಲ್ವಂತಲ್ಲ ಯಾವ್ದು ಸ್ಕೂಟ್ನಿದೊಂದು ನೀವು ಮೆನ್ಷನ್ ಮಾಡಿದ್ರಲ್ವಾ? ಅದ್ಯಾವ್ದು ನಿಮ್ದು ಹೋಗಿದ್ಯಂತೆ ಒಂದು ಪೆಂಡಿಂಗ್ ಸ್ಕೂಟ್ನಿದೊಂದು ಮೂವ್ ಮಾಡಿದ್ರು, ಅದು ಹೋಗಿಲ್ಲ. ನಿಮ್ದೇ ಸ್ಕೂಟ್ನಿ ಇನ್ನೂ ಹೋಗಿಲ್ಲ ಅಂತವ್ರೆ. ಏನ್ F1 ಸೈಡ್ ಅಲ್ಲಿ ಏನೋ ಟೈಪ್ ಮಾಡ್ತಾವ್ರೆ, ಇನ್ನೂ ಬಂದಿಲ್ಲ ಅಂತ.
ಕಳ್ಸಿದೀವಿ ಕೋರ್ಟ್ಗೆ ಅಂತ ಹೇಳಿದ್ರು.
ಹೌದಾ?
ಬಂದಿಲ್ವಾ ಇನ್ನ ಅದು?
ಅವರೇ ಕೇಸ್ ವರ್ಕರ್ ಇಲ್ಲೇ ಬಂದಿದ್ರು, ಬೋರ್ಡ್ ಅವರು ಕೇಳದೆ ಬೇಗ ಕಳ್ಸಮ್ಮ ಅಂತ ಹೇಳಿದ್ದೀನಿ. ಬಂದಿಲ್ಲ ಒಟ್ಟಿನಲ್ಲಿ. ಬೋರ್ಡ್ಗೆ ಹೋಗಿ ಬೋರ್ಡ್ ಇಂದ ಬಂದಿದ್ಯಾ ಕೇಳಿ.
ಆಫೀಸ್ ಇತ್ತು, ಇಲ್ಲ ನಾವು ಕಂಪ್ಲೇಂಟ್ ಮಾಡಕ್ ಕೊಡಲ್ಲ.
ಅವರೇ ಕೇಸ್ ವರ್ಕರ್ ಲಲಿತಾ ಅಂತ ಇವಾಗ ಬಂದಿದ್ರಲ್ಲ ಊಟ ಮಾಡ್ಕೊಂಡು, ಎಲ್ಲಮ್ಮ ಅಂದ್ರೆ ಇನ್ನೂ ಬಂದಿಲ್ಲ ಸರ್ ನಮ್ಗೆ ಅಂತ. ಎಷ್ಟು 17 ಡಿಸ್ಮಿಸಲ್ಗೆ ಹಾಕಿದ್ದಾರೆ ಆಗಸ್ಟ್ ತಿಂಗಳಲ್ಲಿ. ಟೋಟಲ್ 32 ಯಾರಾದ್ರೂ ಮೆನ್ಷನ್ ಮಾಡಿದ್ದೀರಾ? 32 ಮ್ಯಾಟರ್ಸ್, ಟೋಟಲ್ ನಂಬರ್ 32. ಯಾವ್ದು ಮೆನ್ಷನ್ ಆಗಿಲ್ಲ?
ಯಾವ್ದು ಮೆನ್ಷನ್ ಆಗಿಲ್ಲ? ಅರ್ಜೆನ್ಸಿ ಅಂತ.
ಮೇಡಮ್ ಇದು ಟೋಟಲ್ 30. ಹೌದಾ? ಟೋಟಲ್ 32 4 ಮ್ಯಾಟರ್ ಇದೆ. ಮೇಡಮ್ ಅದೇ ಟೋಟಲ್ 32 4 ಮ್ಯಾಟರ್ ಬಂದಿದೆ. ಪ್ರಾವಿಷನ್ ಟೋಟಲ್ ವಿಜಯ್ ಕುಮಾರ್ ಪಾಟೀಲ್ ರಜಾ ಅಂತ ಅವ್ರು ಡಿವಿಲ್ ಕೂತಿರ್ಬೇಕು ಅವರು. ರಜಾ. ಹೌದೌದು 4 ಮ್ಯಾಟರ್ಸ್ ಇದೆ, 4 ಮ್ಯಾಟರ್ಸ್. ಅದ್ರಲ್ಲಿ ಇಂಟ್ರಿ ಮಾಡ್ರೆ ಅಷ್ಟೇ ಎಕ್ಸ್ಟೆಂಡ್ ಆಗ್ಬೇಕು. ನೆಕ್ಸ್ಟ್ ವೀಕಲ್ಲಿ ಅದನ್ನು ಡೇಟ್ ಕೊಡ್ಬೇಕು ಅಷ್ಟೇ ಮೇಡಮ್. 4 ಮ್ಯಾಟರ್ ಅಷ್ಟೇ ಲಿಸ್ಟ್ ಆಗಿದೆ. ಹೌದೌದು ಮೇಡಮ್ ಹೇಳ್ತೀರಾ? ಓಕೆ. ಹೇಳಿ. ಇಲ್ಲ ಆ ಥರ ಏನು ಆಗೋದಿಲ್ಲ. ಎಲ್ಲ ಫಸ್ಟ್ ಲಿಸ್ಟ್ ಮುಗಿದ್ಮೇಲೆ ಸೆಕೆಂಡ್. ಎಲ್ಲ 21 ಮ್ಯಾಟರ್ಸ್ ಎಲ್ಲನೂ ಅಷ್ಟೇ. ಇದೆಲ್ಲ ಫಸ್ಟ್ ಫುಲ್ ಮುಗಿಬೇಕು ಫಸ್ಟ್ ಲಿಸ್ಟ್. ರೀಚ್ ಆಗದಿದ್ರೆ ನೆಕ್ಸ್ಟ್ ಡೇಟ್ ಕೊಡ್ತಾರೆ. ಇಲ್ಲ ಇಲ್ಲ ಅದು ಇಲ್ಲ, ಅದು ಹೋಯ್ತು, ಒಳ್ಳೇದು ಹೋಯ್ತು. ಅವೆಲ್ಲ 300-400 ಮ್ಯಾಟರ್ ಲಿಸ್ಟ್ ಆಗ್ಬಿಡುತ್ತಲ್ಲ. ಅದಕ್ಕೆ ಡೇಟ್ ಕೊಡ್ತಾ ಇದ್ದಾರೆ ಇವಾಗ.
ನಂಬರ್ ಕಳ್ಸ ಬಂದು ಇಲ್ಲ, ಆಮೇಲೆ ಒಳಗೆ ಬಂದ ಎಲ್ಲಿ ಬಂದಿಲ್ಲ.
ಹಾ 19ಕ್ಕ ಯಾವತ್ಗೆ? 19th ಇನ್ನು ಬಂದೇ ಇಲ್ವಲ್ಲ, ಇವತ್ತು 15th ಅಲ್ಲ. ಇದಲ್ಲ ಸರ್ ಇನ್ನ ಡೇಟು 19 ಅಂದ್ರೆ ನೀವು ಹೇಳೋ ಪ್ರಕಾರ ಫ್ರೈಡೆ, ಶುಕ್ರವಾರ.
15ಕ್ಕೆ ನಾನು ಕೊಟ್ಟದ್ದು 10ನೇ ತಾರೀಕು.
ಯಾವತ್ತು ಹೇಳಿದಮ್ಮ? ರಿಸರ್ವ್ ಆಗಿದೆಯಾ?
ರಿಸರ್ವ್ ಇದೆ, ರಿಸರ್ವ್
ಲಾಸ್ಟ್ ದಿವಸ ನೋಡಿ, ಬ್ರಾಂಚ್ ಅಲ್ಲಿ ವಿಚಾರಿಸ್ಬೇಕು ನೀವು. ಏನಿಲ್ಲ ಅಂತ ಬುಕ್ ನೋಡಿ, ಆ ಕಡೆ ಬನ್ನಿ, ಬುಕ್ ಇದೆ ಅಲ್ಲಿ, ಅದು ಎಂಟ್ರಿ ಇದೆಯಾ ನೋಡಿ ನಿಮ್ಮ. 40% advocate represent. Mention and give. ಹೇಳಿದ್ದೀರಾ? On what date it is reserved? Reserved on which date?
Date.
You are not yet signed now. Without signature you are giving. Just attend ಮಾಡದಷ್ಟೇ, ಇತ್ತು ಬೆಳಿಗ್ಗೆ ಎಕ್ಸ್ಟೆಂಡ್ ಆಗೋದಷ್ಟೇ. ಅವರೇ ಡೇಟ್ ಕೊಡ್ತಾರೆ, ಕೊಟ್ಟಾಗ ಸರ್ ರಜಾ ಅಂತ ಹೇಳ್ತಾರೆ ಅಷ್ಟೇ. ಬರ್ತಿದೆ N60 ರಿಸರ್ವ್ ಆಗಿದೆಯಾ?
ಲಿಸ್ಟ್ ಒನ್ ಕಂಟಿನ್ಯೂ ಮಾಡ್ತೀರಾ?
ಲಿಸ್ಟ್ ಒನ್ ಕಂಟಿನ್ಯೂ ಆಗುತ್ತೆ. ಸಿನೋಸಿಸ್ ಅಷ್ಟೇ ಅಲ್ಲ
ಮೆನ್ಷನ್ ಮಾಡಿದ್ನಲ್ಲ, ಅದು ಫಸ್ಟ್ ತಗೋತೀರಾ?
ಸರ್ ಮೆನ್ಷನ್ ಮಾಡಿ ಏನು ಅದೇನು ಆರ್ಗ್ಯುಮೆಂಟ್ ಇದೆಯಾ? ಅಲ್ಲ ಎಂಟ್ರಿ ಮಾಡಿ ಎಕ್ಸ್ಟೆಂಡ್ ಮಾಡಿ ಡೇಟ್ ಕೊಟ್ಟು ಸಾಕಲ್ಲ?
ಇಲ್ಲ ಇಲ್ಲ, ಡಿಸ್ಪೋಸ್ ಆಗ್ಬಿಡುತ್ತೆ.
ಡಿಸ್ಪೋಸ್ ಮಾಡಬೇಕು.
5 ನಿಮಿಷ ಎಕ್ಸ್ಟೆನ್ಷನ್ ಆಫ್ ಟೈಮ್.
ಎಕ್ಸ್ಟೆನ್ಷನ್ ಅಂದ್ರೆ ಡಿಸ್ಪೋಸ್ ಆಗಿರೋ ಮ್ಯಾಟರ್ ಎಕ್ಸ್ಟೆನ್ಷನ್ ಕೇಳ್ತಾ ಇದ್ದೀರಾ?
ಇಲ್ಲ ಇಲ್ಲ, ಅದು ಆರ್ಡರ್ ಆಲ್ರೆಡಿ ಮಾಡಿದ್ದಾರೆ, ಸ್ಟೂಡೆಂಟ್ ಕಟ್ಬೇಕಂತಿತ್ತು, ನಾನು ಎಕ್ಸ್ಟೆನ್ಷನ್ ಮಾಡಿ ಇವತ್ತೇ ಕಟ್ತೀನಿ.
ಯಾವ ಸೀರಿಯಲ್?
52 ಪಾರ್ಟೆಡ್
50
ಪಾರ್ಟೆಡ್
ನಮ್ಮ ಲಿಸ್ಟ್ ನೀವು ಹೇಳಿದ್ದು ಅದಾ? ಹೇಳಿ
ಲಿಸ್ಟ್ ಕಂಟಿನ್ಯೂ
ಅಯ್ಯೋ ಎಂಟ್ರಿ ಮಾಡಿರೋದೇ ಆಗಿಲ್ಲ ಇನ್ನ ಇದೆ.
ಸರ್ ಲಿಸ್ಟ್
ಜಾಸ್ತಿ
ಒನ್
matters
ಲಿಸ್ಟ್
ಇದೆ. ಲಿಸ್ಟ್ 1 22.
ಬಿ ಗ್ರೂಪ್ ತಗೊಂಡು ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಬಿ ಗ್ರೂಪ್ ಆಗಲ್ಲ.
ರಿಸರ್ವ್ ಮ್ಯಾಟರ್ ಬುಕ್ ಇದೆಯಮ್ಮ, ಇದೊಂದು ಪೇಪರ್ ಬರ್ತ್ ಕಳಿಸ್ಬಿಡಿ. 10ನೇ ತಾರೀಕು ರಿಸರ್ವ್ ಆಗಿದೆ ಅಂತಿದ್ದು ಸಿನಾಪ್ಸಿಸ್ ಫೈಲ್ ಅವ್ರು ಕೊಡ್ತಾರೆ ನಮ್ಗೆ. ಏನು ಸಿನಾಪ್ಸಿಸ್ ನೋಡಿ 10/6 ರಿಸರ್ವ್ ಆಗಿದೆ ನೋಡಿ, ಚೆಕ್ ಮಾಡ್ಬಿಟ್ಟು ರಿಸರ್ವ್ ಡಾನ್ಸ್ ಆನ್ ಸೊ ಡೇಟ್ ಅಂತ ಹಾಕ್ಬಿಟ್ಟು ಪೇಪರ್ಸ್ ಸಿನಾಪ್ಸಿಸ್ ಅಂತ ಹಾಕ್ಬಿಡಿ. ಯಾರೋ ಮೆನ್ಷನ್ ಮಾಡಿದ್ರು ಒಂದು 52 ಸೀರಿಯಲ್. ನಿಮ್ದು ಯಾವ್ದು 230 ಇದೆ? 230 ಯಾವ್ದಿದೆ? ಕಂಟಿನ್ಯೂ ಆಗುತ್ತೆ. ಯಾರೋ ಬೆಳಿಗ್ಗೆ ಅರ್ಜೆಂಟ್ ಇದೆ ಅಂತ ಮೆನ್ಷನ್ ಮಾಡಿದ್ರು, ಅದು ತಗೊಬೋದು ನೋಡೋಣ. ಪಾಸ್ ಓವರ್ ಒಂದೇ ಒಂದಿದೆ ನೋಡೋಣ. ಮೇಡಮ್ ಏನು ಹೇಳ್ತಾರೆ, ವೆಯ್ಟ್ ಮಾಡಿ. 230 ಎಲ್ಲಿದೆ? ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ 230 ಅಲ್ಲ, ಅದು ಫಸ್ಟ್ ಲಿಸ್ಟ್ ಮುಗಿದ್ಮೇಲೆ ತಗೊಳ್ಳೋದು. 58 ತಗೋತೀವಿ, 52 ತಗೋತೀವಿ. ತಗೊಳ್ಳೋದಿಲ್ಲ ಮೇಡಮ್, ಅದೇನು ಹೇಳಿಲ್ಲ. ಸಾಟರ್ಡ ತಗೊಂತಾರಿಲ್ಲ ನೋಡು.
230 ಮೂವ್ ಮಾಡಿದ್ರಂತ ನಾನು.
ಮೆನ್ಷನ್ ಮಾಡ್ತೀರಾ?
230 ಮೂವ್ ಮಾಡಿರೋದು ನಾನು.
ಬಂದಿಲ್ಲ, ಇನ್ನ ಫೈಲ್ಸ್ ಬಂದಿಲ್ಲ. 18/6 ಹೋಗಿದೆ ಅನೌನ್ಸ್ಮೆಂಟ್ ಆಫ್ ಆರ್ಡರ್ ಅಂತ. ನಾ ಅಲ್ಲಿ ರಿಸರ್ವ್ ಬುಕ್ಕಲ್ಲಿ ಬರ್ಸ್ಕೊಬೇಕಾ ಏನು? ಬುಕ್ಕಲ್ಲಿ ಬರ್ಬಿಡಿ ಅದನ್ನು, ಫೈಲ್ ಅಲ್ಲೇ ಹೋಗಿದ್ದೇವೆ. ಏನು ಬರೆಯಂಗಿಲ್ಲ ಮೇಡಮ್, ರಿಸರ್ವ್ ಆದ ಬರೆಯಲ್ಲ.
ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಡಿಸ್ಮಿಸಲ್ದು ಡೇಟ್ ಹೋಯ್ತಾ? ಲಾಸ್ಟ್ ಮ್ಯಾಟರ್ 50 ನೋಡ್ಲಾ? ಪಾರ್ಟಿ ಬಂದು ಅಲ್ಲ ಅವ್ರೇನಾದ್ರು ಡೇಟ್ ತಗೊಂಡ 14%. ಬಿಕಾಸ್ ಸಮಟೈಮ್ಸ್ ಶಿ ಡಸ್ ದಟ್, ಅದಕ್ಕೆ ನಂಗೆ ಗೊತ್ತಾಗಲ್ಲ. ಕರೆಕ್ಟ್, ಎಕ್ಸಾಕ್ಟ್ಲಿ ಕೊಡಲ್ಲ, ಅದೇ ಗೊತ್ತಾಗ್ತದೆ.
ಪ್ರೊನೌನ್ಸ್ಮೆಂಟ್ ಆಫ್ ಆರ್ಡರ್ ಫೈಲ್ ನಂಬರ್ ಬರೀರಿ, ಪಕ್ಕದಲ್ಲಿ ಪ್ರೊನೌನ್ಸ್ಮೆಂಟ್ ಆಫ್ ಆರ್ಡರ್ 80 ಫೈಲ್ ರಿಸೀವ್ ಮಾಡಿರೋದು ಅವರು.
Madam, I can mention, right? I can mention the case that she was asking. Serial number, list 2, serial 57. Yes, on procedural inconsistencies, I need an argument. I'm not well today. If possible, next, if today, if it is coming, I will wait. Otherwise, I already informed by message.
ಮೆನ್ಷನಿಂಗ್ ತಗೊಳ್ಳೋದು ಎಷ್ಟು ಹೊತ್ತಲ್ಲ ಅವರು ಮೇಡಮ್, ಓನ್ಲಿ 10:30 ಅಷ್ಟು. ವಿಜಯ್ ಕುಮಾರ್ ಪಾಟೀಲ್ ಲಿಸ್ಟ್ ವಿಚಾರಿಸಿ ಬ್ರಾಂಚಲ್ಲಿ ವಿಚಾರಿಸಿ ಬ್ರಾಂಚಲ್ಲಿ. ಏನ ರಿಸರ್ವ್ ಅಲ್ಲ ರಿಸರ್ವ್ ಅಲ್ಲ ಅಂದ್ರೆ ನೀವು ಇದು ಟ್ರೀಟ್ಮೆಂಟ್ ಅಪಿಯರೆನ್ಸ್ ಪ್ರೊನೌನ್ಸ್ ಅಲ್ಲ ರಿಸರ್ವ್ ಅಲ್ಲ ರೆಡಿ ರೀಸನ್ಸ್ ಟು ಫಾಲೋ. ಅಪಿಯರೆನ್ಸ್ ಬರ್ಕೊಡ್ಬೇಕಂತೆ ಪ್ರೊನೌನ್ಸ್ಮೆಂಟ್ ಆಫ್ ಆಮೇಲೆ ಅಪಿಯರೆನ್ಸ್ ಆಮೇಲೆ ಬರೆಯೋದು ಫೈಲ್ ಬರುತ್ತೆ. ಹೌದು 13. ಅಪಿಯರೆನ್ಸ್ ಎಲ್ಲ ಅಪಿಯರೆನ್ಸ್ ಬರೆಯೋದು ಅಷ್ಟೇ. ಅವ್ರ ಪ್ರೊನೌನ್ಸ್ಮೆಂಟ್ ರಿಸರ್ವ್ಡ್ ಅಂತ ಅವ್ರ ಪ್ರೊನೌನ್ಸ್ಮೆಂಟ್ ಆಫ್ ಆರ್ಡರ್ ಆನ್ 18/6 ಅಂತ. ಎಂಟನೇ ವೇತನ ಆಯೋಗ ಏನೋ ಆಫರ್ ಮಂಜು ಎಚ್ ಏನೋ ವರದಿ ಸಲ್ಲಿಕೆ ಆಗುತ್ತೆ. ಯಾವ ಪೇಪರ್ ಕಟ್ಟಿಂಗ್ ಗೊತ್ತಿದೆ. ಇದು ಮೆನ್ಷನ್ ಮಾಡಿದ್ದ ಬೆಳಿಗ್ಗೆ 52 ಸೀರಿಯಲ್ಲ. ಫಸ್ಟ್ ಫೈಲ್ ಬರ್ಲಿ ಮೇಡಮ್, ಆಮೇಲೆ ಕೇಳ್ತೀನಿ ನಾನು. ಫಸ್ಟ್ ಬರ್ಲಿ ಲಿಸ್ಟ್ ನನ್ನ ಕಡೆ. ಬಂದ್ಮೇಲೆ ನಾನು ಕೇಳ್ತೀನಿ.
ಆಯ್ತಮ್ಮ ಇನ್ನೊಂದು ನಂಬರು WP 11056 11056 26 ಹೌದೌದು 18/6 ಪ್ರನೌನ್ಸ್ಮೆಂಟ್ ಇದೆ ಅದು ಹೆಂಗ್ ಮಾಡೋದು ಹೌದಾ ನಾನು ಸ್ವಲ್ಪ ನೋಟ್ ಮಾಡ್ಕೊಂಡಿರಿ ರಿಮೈಂಡ್ ಮಾಡಿ ಅದು ಮತ್ತೆ ಕೊಡ್ತಾರ ಅವ್ರು ಇವತ್ತಲ್ಲ 18ಗೆ ಇರೋದು 17th ಮಾಡಿ ಹೌದೌದು ಅದಕ್ಕೆ ನೋಟ್ ಮಾಡ್ಕೊಂಡಿದ್ದೆ ಮರ್ತು ಕೊಡ್ತಾರ ಅವರು ಮೇಡಮ್ಗೆ ಪಿನ್ ಮಾಡಿಸಲ್ಲ ನಂಬರ್ ಯಾವ್ದು ಇಷ್ಟು ಆಗಿಲ್ಲ ಇವ್ರು ಯಾವುದು ಆಗಿಲ್ಲ ಇಲ್ಲ ಅಡ್ಜಸ್ಟ್ಮೆಂಟ್ ಆಗಿಲ್ಲ ಇದೆ 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 ಹೇಳಕ್ಕಾಗಲ್ಲ ವೇಟ್ ಮಾಡಿ
Continue the list. Continue the list.
Mentioning list number 2, serial number 57.
No mentionings now. Yes.
It is.
Taranath Shetty.
Here for the petition. My lord, I have challenged the order dated.
We'll take all the matter, doesn't matter. Yes.
My lord, I have challenged the order dated 17/12/2025, my lord, at annexure A, my lord. Page number 7, my, by dismissing my petition for miscellaneous petition for non-prosecution on the ground that on the ground that PW1 was not present for further cross-examination, my lord. On that.
Let's see that order.
My lord, page number 9, my lord. Annexure A, relevant para is page number 10, my lord. Order sheet.
Yes.
My lord, on 3/11, my lord, no representation from petitioner, call at 3 p.m. And case called out at 3 p.m, no representation from petitioner to keep PW1 present for further cross-examination period. Finally, last chance on 17/12. On 17/12, my lord, on that day also the petitioner was, PW1 was not present, my lord. Hence, my lord, page number 11, my lord. Case again called at 3 p.m. PW1 and counsel absent, no representation, call later. Case again called at 5 p.m. PW1 and counsel absent. Perused the order sheet despite providing several opportunities. PW1 has
Why you didn't appear before?
My lord, what has happened is first petitioner, brother's son, my lord, was accidentally died in Indur, my lord. She has not informed the counsel also, my lord. They were in Indupur, my lord. I have produced the medical certificate, my lord. So she has not, the PW1, my lord, is the second petitioner, my lord. First petitioner is 18-year-old son, my lord. Annexure E is the medical certificate to show that, my lord, the 18
page number.
Page number, my lord. Uh, 47, my lord. On 19/11, my lord, he died in the hospital at district of.
Let me see that.
47, my lord, annexure E. Ink page number 47, my lord.
Who died?
The son of Sayyid Ilai, he is the first petitioner, my lord.
On 19/11.
19/11, my lord, in the hospital due to accident, 18 years old, my lord.
And this matter came up before the court on?
My lord, 17/12, my lord. 17/12,
this is on 3/11.
311 was earlier date, my lord, on 17/12.
17 or
12,
7?
17/12 it was dismissed, my lord.
Then comes to the petitioner, submits that the court has dismissed the miscellaneous as the PW1 has not turned up for the cross-examination. And observe that the PW1, the counsel absent, no representation. Case again called at 5 p.m. and both the counsels are absent. Hence, evidence of PW1 is discarded. Consequentially, petitioner is dismissed for non-prosecution. Who died? This is the person who died is PW1 or
PW1's elder brother, my elder brother's son, my lord. He is the first petitioner, my lord, here in the writ petition. First petitioner's son died, my lord.
The first petitioners, it is stated that he is arrayed as PW.
PW1 is second petitioner, Shama, my lord, in this writ petition. Second petition was PW1. His elder brother is first petitioner in the writ petition, my lord. Son of first petitioner died, my lord. Sayyid Eli's son.
Please come to the cause title. Let's not.
First petitioner is
PW1 is who here?
Second petitioner in the writ petition, my lord.
Yes, it is submitted that his son died.
His brother's son. Brother's son.
It is submitted that the second petitioner's son died on 19/11/2025.
19/11/2025.
And he met, how he died?
Due to some, my lord, he had went to his relatives' house at Indupur, my lord. There, due to gas
It is
leakage.
1911. And the matter was called on 17/12/2025. Even the aspect of this was not communicated to the petitioner. Then what is the interim order you want?
My lord, no interim order, my lord. I am seeking restoration of.
For that notice is unnecessary.
Please, ma'am.
Notice to respondent.
24, Vilesh Krishna.
There is small issue here, my lord.
Hmm?
Order is passed, my lord. It is for appointment of receiver. And
Is this a matter you mentioned in the morning?
yes, my lord. In fact, it should have been an MFA, but the order itself mentions the wrong provision. It mentions
Look, ultimately, what is the consequences of that order?
is that if it in law it is under order 40 rule 1, I have to file MFA, my lord.
A memo is filed seeking to convert this petition into a MFA. Memo is taken on record. And the petition shall convert the same into an MFA within a period of 1 week from the date of receipt of the copy of the order. The registry shall return all the documents, same for statistical purposes. Yes, next.
Grateful.
25.
Appearing for petition.
The petition.
My lord, the petitioner herein is challenging IA number impugned order at annexure A, whereby IA filed by respondent number 2 under order 1 rule 10 of CPC came to be allowed. In MA
What is the suit for?
My lord, this I will say the fact.
Yes.
Petitioner had acquired undivided right in scheduled property. Scheduled property is near an apartment. Thereafter, R2 is the apartment association. They file a complaint saying that I have constructed the building without leaving any setback area. Before the filing of complaint, I had executed release deed in favor of my mother. Thereafter, R2 files a complaint before respondent number 1 alleging that I have carried illegal construction and I have not let setback, my lord. Thereafter, an provisional order came to be issued. Notice of provisional order came to be issued under section 321 of Karnataka Municipal Corporation Act, saying that directing me to vacate the illegal construction. Thereafter, I file an objection before R1 stating that no respondent number 2 has not been arrayed as an party and she is the owner. But without considering my objection, R1 passes order dated 8/4/2025, directing me to vacate, directing me to remove the illegal construction, my lord.
Yes, you have filed MA. What
Please,
happened
madam.
in that? Who has filed order 1 rule 10?
By complainant.
Complainant, please come. Then comes with the petition suppress that. The, in MA, the complainant is made a party to the proceedings and he is not a proper and necessary party in the light of the division bench judgment of this court. With this court accordingly, considering the submission, we shall stay of all further proceedings pursuant to the order dated so and so. Notice to the respondents.
My lord, there is another similar matter, my lord. This is filed my mother.
List along with so and so, take that number. Yes, notice to the respondents. Yes, petitioner shall take out hand summons on the counsel appearing before the trial court and shall file a memo to the effect by 6. By 6, if it is not filed, the stay granted by this court stands vacated. Yes, next. Yes.
On this matter. Annexure A is under challenge. Page number 11. BESCOM, my lord, has issued a
The
notice.
KEB matter.
BESCOM, my lord, has issued notice to the petitioner hearing that they would disconnect the
requires the-
temporary connection.
Who appears for BESCOM?
It's served a copy to the BESCOM authorities as well.
Who is it? Any counsel is there? Huh? Bring the name of so and so, so papers on him. I'll take it up tomorrow.
A connected matter, my lord, stay has been granted.
No, I'll grant. Tomorrow we'll see.
Please.
Give papers to him. Print the registry is directed to print the name of Mr. Devraju.
HV Devraju.
So and so. Counsel of the petitions is directed to serve the papers on the council. List tomorrow in the first list. Yes.
27.
My lord, I appear for petitioner. The petitioner is the judgment debtor, my lords, in execution case. I challenge the order dated 2/4/2026 passed by the Honorable Executing Court, my lords, at Annexure K, my lords. In continuation of the order sheet, my lords, by oversight, we could not produce the separate order was passed, my lords, wherein that order was left out, my lord, by mistake from my clerk, my lord, and that is why I am seeking permission of this court. I saw the copy on the other side also, my lords. My lords, at earlier.
Memo is fine, stating that the order copy, the order date, separate order date 2/4/2026 is not filed before the court by oversight. Hence, now by way of this memo, the copy is filed and the same is served on the other side. Copy is taken on account. Yes.
My lords, on earlier occasion, my lords, the petitioner has challenged the order dated 31/7/2025 passed by the executing court, my lord. Wherein this honorable court, my lord, passed an order produced at Annexure H, my lords, page number 74, my lords. There was a direction by this honorable court, my lords, to consider the contentions of both the parties and pass the orders, my lords, to the executing court. When this being so, my lord, the executing court, after hearing the matter, my lords, was pleased to pass the impugned order, my lords. Wherein, my lords, this the executing court has by relying upon the memo of calculation or the petitions filed, whatever the amount shown in the execution petition, that was ordered to be paid, my lord. In excess, already we have deposited.
Where is your calculation memo? Where did you file that?
My lord,
Where is your calculation memo that is filed before the trial court?
yes, my lord,
Executing
page
court.
number, my lord, 77, my lord.
77.
7.
And where is the calculation memo filed by them?
My lord, the petitioner has filed the petition, my lord. In the petition itself, they have stated, my lords, the page number 45, my lords. 3,55,37,101 rupees, my lords. My lord, kindly come to page number Annexure A, my lord, wherein the honorable arbitrator has passed an order, my lord, wherein the interest was not awarded in the order of the arbitrator, my lord.
Yes.
We have disputed the calculation.
What is admitted amount?
My lord,
What is admitted amount?
my lord, admitted amount was 87 lakh, my lord. If the land is considered as, even though it is developed.
No, by virtue of this order, what is the amount directed to be paid?
My lord, by virtue of this impugned order, 1 crore,
According to
7,21,746 is ordered to be paid in excess of whatever already deposited.
That's why I am asking, as per your calculation, what is the amount to be paid?
My lord, 87 lakhs is the amount payable as per my calculation.
Yes. Let him pay that.
No, I've already, my lord, what happened, my lord, I have, in the first occasion, I have deposited 27 lakhs, my lord. When I have submitted my.
That aspect was not considered by the court. What amount have already paid?
Yes, that was not considered. Even apart from that, the court has called the directly.
Both of you file your calculation memos, we'll see.
Yes.
Both the council shall file the.
Stay may kindly be granted till.
He is also here, we'll hear it. Why the stay? Both the council shall file the calculation memos. This is matter on 2nd of July.
Great.
Yes, next.
In the meantime, this matter is posted on 26th, my lord, and the honorable judge has warrant. In the event there is no stay from the honorable high court, then he will proceed for release of the amount, my lord. Since that is the case, I will be put in trouble.
Oh, that's the issue. According to them, he paid, or if according to you it is not paid, first let him file the memo.
The calculations was filed before the executing court. Both was appreciated by the executive court. What the content that Mala?
No, for the better, and ultimately now the court has to pass an order.
Yes, yes, madam.
So please file, then we will pass.
Yes, ma'am,
Till
file.
such time not to precipitate the, I will not pass any order.
Yes, I
Please
will,
inform the court. Yes. Next.
28.
Great.
Yes.
For the petitioner, my lords. In this case, my lords, the impugned order is at annexure A.
What is the suit for?
My lords, suit is for specific performance of the contract. It was decreed directing the my lords, plaintiff, that is respondent, to get the sale deed executed after he deposits 1 lakh rupees within 3 months from the date of my lords decree. Subsequently, when my lords, he files execution petition. Lordship may kindly see the dates. 16/7, my lords, 2019. The suit came to be my lords decreed. 24/10/2000. There, my lords, a decree. In the decree, it is clearly mentioned that he has to deposit the amount within 3 months and get the sale deed registered. That is 1 lakh rupee. May I take your lordships to the decree? It's in Kannada. Page. That is not under dispute also. Page number 38.
Please come to the order now. I understood what you are.
Yes, yes, yes.
Come to the order.
Yes.
Come to point number 2.
Point number 1, my lords. Point number 2 is
14, paragraph
14,
number
yes.
14.
13 and 14. May I just read 13 also, my lord? Because
Yes, it's read.
the learned judge has relied on the
Yes.
decision. At this stage, it is worth to rely on the decision of the Honorable Supreme Court in the matter of Dr. Amit Arya versus Kamalesh Kumar, reported in 2025 NSC 1486, wherein it was held that some delay in depositing the balance sale consideration by the buyer beyond the timeline prescribed in the decree would not render the decree for specific performance inexecutable if the buyer remained ready and willing to perform his part of the agreement. Then, my lords, next para. In the judgment, the Honorable Apex Court further held that treating the decree as inexecutable merely because the execution petition was filed beyond 60 days was clearly contrary to law. Thereby, the above decision prevents technical objections from defeating substantiative rights. As DHR does deposited the balance sale consideration within reasonable time, the JDR fails to make out any good grounds to allow the application. Your Lordship may kindly see the dates on which the.
I've seen
Yes,
that.
my lords, we have relied on a decision, previous para number 11. That is a JDR, page 14.
Yes.
The JDR has relied upon a decision of the Honorable Apex Court in the matter of PR Elumalai versus NM Ravi reported.
That all depends upon facts and circumstances
Yes.
of each case.
My lords, each case, in fact, my lords, there is a latest decision of this Honorable Apex Court where it is clearly held that, my lords, if the conditions are violated, the decree cannot be executed. May just pass on that list.
There are cases and cases where the Supreme Court allowed.
Yes, my lords,
also.
this is a case similar to the facts of present case. There also, my lords, what happened was there was a decree.
Yes, let's see, where is it?
Yes,
Come to the relevant paragraph.
Yes, yes. Para number 25, my lords, that is the facts of the case. I just read the relevant portion. Now coming to the merits of the executability of the decree for specific performance dated 31/10/2002, it may be noted that aforesaid decree is an executable decree, but it is a conditional decree. It provides for the execution of the sale deed by the defendant appellant within 3 months, subject to plaintiff respondent depositing the balance sale consideration. Therefore, as stated earlier, the decree imposes reciprocal obligations upon both the parties. The obligation of executing the decree is upon receipt of the balance sale consideration. Therefore, by necessary implication, for the purposes of executing the sale deed, the plaintiff respondent had to deposit or pay the balance sale consideration within the time stipulated for depositing the amount, aforesaid amount for executing the sale deed, as the case may be. Then, my lords, may I take your lordships to the conclusion portion. It's at para number 42. Para number 42, my lord. In fact, para number 40, this decision is also discussed. And para number 41 from conclusion starts from para number 41. May I read that?
Yes, take out notice.
That's
Notice to the respondent's petition is permitted. Take out.
matter is posted on 29/6. Matter is posted before the executing court, my lords, 29/6.
That day you take notice, that day you reserve the
Before
hand.
that, my lords, your lordship may kindly give.
Not possible. The
Otherwise, my lords, if the matter is to be proceeded,
permitted to
the
take out hand
petition-
summons on the counsel appearing for the respondent. We shall file a memo to that effect by 6th of July. If the memo is filed, list the matter on 7th July. Yes.
29, KL Srinivas.
I am appealed for the petitioners, my lords. The petitioners are the LRs of the original JDR, my lords. The respondent herein has filed a petition seeking to execute the decree for permanent injunction against the original JDR, my lords. And after the evidence of both the parties, my lords, the original JDR died on 5/2/2024. Earlier, the respondent DHR has let in evidence against the original JDR, and subsequently, upon the death of the original JDR, the LRs, that is the petitioner herein, were brought on record, my lords. Thereafterwards, no specific allegations have been made against the LRs of the JDR, and the Honorable Executing Court has passed an order while Annexure J, that is at page number 59. The relevant portion is at page number 66, para number 14, my lords. Upon examining the above provision and material available before the court, it is evident that this is a fit case to take action against the judgment debtor for disobedience of the decree passed by the appellate court. As per sub-rule 1 of Rule 32 of Order 21, if the JDR willfully fails.
When the JDR died?
5/2/2024, my lords.
When you were brought on record?
He was brought on record on 20/6/24, my lords. That is, the amended petition is at page number 56, Annexure H. Earlier, the evidence of both the parties have been let in. And my lords, after the passing of this order issuing the attachment warrant, my lords, that is on 5th January 26, the Honorable Executing Court has also passed another order, wide Annexure H, Annexure K, page number 71, my lords. case called out, both counsels are present, DHR is present. In view of the office note and the submission made by the counsel for the DHR, issue arrest notice to JDR. The endorsement made by the process server is, my lords, attachment warrant.
Please come to paragraph number 9 and read that Kannada portion and tell the court what it is.
Please, my lords. The witness says that in RSA 2010 of 17, there is a stay order, but the copy is not produced. And the witness says that when the DHR has attempted to put in the fence to the decretal property, he has refused, stating that it is his property. That is, the JDR refused, stating that it is the property of the JDR. That is the translated portion, my lords. And my lords, the Honorable Executing Court has not at all recorded a finding stating that the JDR or LRs of the JDR have an opportunity to obey the decree and they have willfully refused to obey the decree.
Then counsel for
But
the petition submits.
only on the basis of the endorsement. Pardon?
Then counsel for the petition submits that the court by order impugned has passed an order. The observing that it's a fit case to take action against the JDR for disobedience of the decree passed by the court. And accordingly, attachment to the order of attachment order is passed for attachment to the property of the JDR's properties. Then counsel submits that the petition before this court is the LR of the original JDR. After the execution petition is filed, JDR died. Thereafter, the petitions are impeded as parties to the execution proceedings. And it is nowhere the case of the decree holder that these petitions are have violated the order of injunction or they are interfering. And without giving any finding on this, the court has passed the order. Considering the same, there shall be stay of all further proceedings. Issued to the order dated so and so. It will hand summons by 3rd of July or else a stay granted by this court stands vacated. Next.
30, Jairaj.
For
the petitioner. Suit for declaration to declare the CLD dated 2nd December 2023 executed in favor of defendant number 1 as null and void by the plaintiff. When the matter was set down for arguments on application filed by the plaintiff seeking injunction, I made an application as per order 6 rule 17 to amend the certain paragraphs, to insert certain paragraphs, that is 2 paragraphs, along with the counterclaim as per order 8 rule 6 capital A. Because now that application is dismissed by the Honorable Trial Court saying that I should have filed it along with the written statement, which is not the law laid down as per the present Supreme Court judgment in the Ashok Kumar's case. Well, Lordships may kindly see that paragraph, para 13, page 62. Although it's a technical issue, but even the consideration of my written statement is wrong. Your Lordships will see para 13. By virtue of this provision on careful perusal of the entire order sheet as well as the record, it reflects that summons to defendant number 1 to 3 served on 2/2/2024, 3/2/2024, 1/2/2024 respectively. On 16th February 2024, defendant numbers 1 to 3 appeared before this court and Sri DSJ filed wakalat. Then on 6th February 2024, defendant number 1 filed written statement in duplicate. Defendant numbers 2 and 3 filed memo to adopt the written statement of defendant number 1 as also their written statement. That memo was allowed by this court and permitted them to adopt the written statement of defendant number 1. But after the lapse of 11 months from the date of service of summons to the defendant numbers 1 to 3 and after lapse of 7 months from the date of filing the written statement of the present application, as on the date of written statement, defendant not filed along any counterclaim as such as per orders 8 rule 6a, counterclaim filed by the defendant numbers 1 to 3 is not valid within time. My written statement is filed on 5th June, not 16th of February. My appearance is only on 6th February. The calculation is from 16th of February, but my return statement is 5th of June. Nevertheless, my lords, the Honorable Supreme Court in these kinds of matters have permitted the defendants to bring on record their written statement as also their counterclaim until unless the issues are framed. Plaintiff is a tenant. She suffered an order. I'm the owner of the scheduled property. She does not challenge the prior sale deed also.
The court says court has no jurisdiction.
Sorry, my lords.
Court says court has no jurisdiction.
That's one aspect, my lords, but I'm saying the very underlying principle, my lords, as laid down in the provision, paragraph number 13, the Honorable Trial Court says I should have filed it along with the written statement.
Para 20.
Para 20. As per Order 6 Rule 17 of CPC and as per the provisions of the Family Court Act, also this court has no jurisdiction to declare the marriage of the plaintiff with Ramesh as null and void. It is not the dispute for matrimonial dispute. The amendment as sought in the application is in no way necessary or required to adjudicate the dispute between the plaintiff and the defendant numbers 1, 2, 3. In view of the so and so, it's held in the negative. Plus, insofar as my other two paragraphs, keeping aside the counterclaim, the other two paragraphs ought to have been allowed. It's not just I'm seeking for a counterclaim.
What is this? What is a counterclaim? You're seeking your marriage to
Correct.
declare the
But
marriage
is
as null and void.
correct.
That relief cannot be sought before the civil court. You have to go to the family court.
Right, that's right. I'm saying this along with the counterclaim. I've also sought an amendment to incorporate two other paragraphs. Your lordships may kindly see that what is the amendment.
Oh, according to you, this should be rejected and part of it should be allowed.
No, I'm saying if at all, my lords, if it is assuming but not conceding to that aspect, if at all the Honorable Trial Court declines.
Come to your affidavit. Where is that?
Your lordships will see the application page 24, annexure A. It's not only my counterclaim. At the most, the other two paragraphs.
No, all these paragraphs are in support of your counterclaim.
No, it's not only in so far as.
Let's see that.
Please.
What did you say?
Your lordships will see the page 24.
Yes.
It is specific. It is a specific claim of the plaintiff herein. It is the case of the plaintiff that her marriage was solemnized with G.S. Ramesh on 17 November 2016, adhering to the Hindu rites and customs, and witnessed by both the family members, which was subsequent to passing away of first wife Shobha. It is a specific case of this defendant that the marriage of the plaintiff with Sri R. Raju was solemnized on 7 June 1998 at Surnahalli as per the.
Notice the respondent.
No, it's even in fact it's covered. Your lordships will see that.
See, we'll see when the respondent comes.
Even in a similar matter, the coordinate bench has passed an order. That's why I'm pressing. Its matter is registered on 18. If the trial court frames issues, then this will.
No, when the court has no jurisdiction, no jurisdiction.
Correct, Manoj. Insofar as my other two paragraphs.
That we will see. That we will know once.
The court says that until issues are
in this manner, let's not stall all the suits. Notice to the respondent petition permitted to take out transcripts.
No.
File a memo to that effect. The memo is filed by 8th. This is matter on 9th. Yes, next.
31, petitioner. The petition filed by the defendant number 2 before the trial court, my lord. The suit for partition filed by the first respondent
against the petitioner herein and respondent number 226, my lord. In this case, my lord, they want to, the application filed by the first respondent herein is in page number 49, my lord. They want to start for the
What is the suit for?
suit for partition filed by the first respondent, my lord. Now they have filed the suit in the year 2018, my lord, seeking partition. I have filed the written statement here, my lord. May kindly peruse the written statement filed by me in para number 4 in page number 35.
What is the stage of the proceedings now?
At the stage when the case was posted for main argument, that time they have filed the application seeking amendment to the prior, my lord, to declare the will dated so and so is not binding to the plaintiff. That is the prayer made by the.
Come to the order.
My lord.
Come to the order.
Come, impugned order is, my lord, in page number 14, my lord.
Come to paragraph 10.
Paragraph 10. Yes, ma'am. It appears from the pleadings of the plaintiff that her claim of share in the suit schedule property is under Section 8 of Hindu Succession Act 1956. It is her specific pleadings and that the Puttalingaya and Puttatayama died intestate, leaving behind the plaintiff and defendant 1 to 4 as their legal heirs jointly to succeed and inherit their estate. In the written statement filed by the second defendant, here, the petitioner here in Mellon, he has challenged the order passed by the trial court. He has taken specific contention at the para number 4 that the Puttalingaya and Puttatayama have executed the registered will dated 5/9/2006, bequeathing the suit schedule items number 6 and 8 properties in favor of the 4 defendant. At para number 7 of the written statement, the second defendant has further contended that Puttatayama executed will, registered will dated 15/3/2008, bequeathing the suit schedule item number 5 property in favor of the second defendant. In view of the above rival contention of the proposed amendments are just and necessary to determine the real questions in controversy between the parties. This is the finding given by the trial court.
Come to the affidavit.
Affidavit, my lord. In the affidavit, the first respondent.
Page number.
Affidavit, page number 50, my lord. Page number 51, sorry, 51, my lord. Affidavit filed by the first respondent. She has para number 2, may kindly consider, my lord. I submit that I have filed the above suit for partition and such other reliefs. The matter now stands for posted for.
When was the DW2's evidence concluded?
DW2 evidence was completed in the year 2025, my lord. But my case is that, my lord, they have filed the suit for partition in the year 2018.
I'm just asking when is it completed?
2025, my lord. 2025, DW2 evidence completed and the will also marked as exhibit D17.
When was the will marked?
That 2025, in the year 2025 itself, because suit was filed in the year 2018, we have filed the written statement in the year 2018 itself. We have clearly mentioned the registered will dated so and so, registration number so and so. My father executed a registered will in my favor, so that acted upon. So after lapse of 7 years, my lord, they have filed the present application.
Will is marked when?
2025, my lord.
When were the pleadings with regard to this will?
Will in the year 2018, my lord. Kindly come to the written statement, para number, my lord, ink page number 35, my lord.
In your pleadings, you have taken those pleadings, yes, but the document is marked in
2025, my lord. Application was filed in the year 2026, but as per the judgment of this Amba court, my lord, time barred amendment cannot be allowed, my lord. Kindly consider.
What is the time barred amendment?
Because 2018 we have will is in the year 2006 and 2008. Suit was filed 2018 after lapse of 12 years from the date of the registered will, my lord. 6 means after lapse of 20 years, 2018 and more than 12 years. So the amendment application was filed after lapse of 7 years.
It's your case. You only have stated about the registered will in the year 2018.
No, 2006, one will was registered in the year 2006.
It is not their case, it is your case.
That is my case, my lord. Yes, my lord. But my contention is time bar amendment cannot be allowed by the trial court.
Time bar? That will be decided by the court.
My lord, kindly peruse the judgment of this court.
I can understand it is their case that it is executed in the year 2008 and they sought for cancellation of it.
After lapse of 7 years, my lord. But before this court, my lord, time bar amendment cannot be allowed by the trial court. That is the finding given by this court, my lord. In page number 11, may kindly consider, my lord. The trial court has not considered page number 11, my lord, judgment of this court. The trial court has not considered the aspect of the limiters while considering the prayer for amendment of the prayer. the same case is applicable to my case also. This being the position, this court is of the view that application for amendment is clearly time barred and the plaintiffs are not shown any due diligence in moving the said applications.
It's all on the facts of the case. How will that apply to your case?
My lord, in this judgment, my lord, they have sought for amendment of when the case is posted for argument. So in the plaint itself, they have mentioned those, those with regard to the time bar
Your
amendment.
case, in the play, it is mentioned in the, when was it mentioned? When
My
you
case,
filed
my
that,
lord, in the year 2018 suit was filed for partition. In the year 2018 itself, we have clearly mentioned in the written statement, para number 4. So my father and mother executed the registered will in my favor. So will acted upon, they have not questioned.
Whatever you are submitting, let us assume that they came to know in the year 2018.
Yes,
When
ma'am.
was the amendment?
2025, they have filed the application. Amendment application was filed after lapse of 7 years. That is a time bar amendment, my lord. Why they have not filed before commencement of the trial?
They have said the reasons for that.
No, they have not stated anything in their affidavit. They have stated that after marking of the documents of the will, they came to know.
Prior to that, what happened? They said so. Look at it. Where is the affidavit?
Affidavit in page number 51, my lord. In the affidavit, they have not disclosed anything, my lord. My lord, kindly comes to the para number 2. I submit that I have filed the above suit for partition and such other reliefs. Matter now stands posted for hearing on IA. Submitted that IA defendant number 2 examined his witnesses DW2. Got marked the will dated 5/9/2006 as exhibit D17. However, there is no revenue entry in the documents which reflected the alleged will while I have obtained the certified copies of the time filing the above case. Hence, I could not seek any prayer on the alleged will dated 5/9/2006. It is only when the said will came to be marked, I came to know about the alleged will, because in the written statement I have clearly mentioned all the details regarding the will, my lord. But she said that after marking of the will, I came to know. That is the false affidavit they have filed. Anyway, hence the annexed application seeking to amend the pleadings.
There is a written statement.
Written statement is in page number 49, in page number 1. In page number 34, my lord. 34 start. In page number 34, annexure C, my lord.
Paragraph.
Which paragraph number 4, my kindly peruse, my lord. Written statement, paragraph number 4. The allegation in para 4 of the plaint are all false and are hereby denied. It is false that Puttlingaya father inherited suit item number 6 from his ancestors. The said property was the exclusive separate property of late Puttlingaya, wherein he has earlier residing. Late Puttlingaya purchased the suit item number 6 and registered sale deed out of his own income. Both father and mother have executed the registered will dated 5/9/2006, which is registered as document number so and so, registered in the office of the sub-registrar Channapatna, bequeathing the item number 6 and 8 of the plaint item in favor of the 4 defendant.
Counsel to the petitioner submits that the court by order impugned had allowed the amendment of the prayer where they have sought the prayer that is sought as to declare that the will dated 5/9/2006 is obtained by misleading and deceiving C.C. Puttalingaya and Srimati Puttatayamma to knock the suit scheduled property, to declare that the alleged will dated 15/3/2008 is created and fabricated, to knock the suit schedule item 5 by the defendants. It is submitted that he filed the written statement in the year 2018. In the written statement itself, he has mentioned about the same. However, they have kept quiet. And now, in the year 2025, they have come up with the present prayer, with the present amendment, which changes the nature of the suit itself. And these kind of belated amendments cannot be allowed, considering the sufficient stay, same hand summons by 6th of July, or else the stay granted by the court stands vacated. Next.
32 urgent, 33, Vivekananda.
Yes. Petition. No, it's plaintiff's petition. The suit is one for declaration. during the evidence of defendants, my lord, they produced one document, that is photocopy of the sale agreement. I raised the objection, my lord, that it is not admissible. The court has rejected my prayer, my lord. The reason, my lord, at page 44,
Yes.
para 8, my lord, here. I have anxiously gone through the submissions of the both sides and the ratio laid down by Supreme Court in Jupadi Keshav Rao's case. In the said case, Honorable Supreme Court has an occasion to examine Section 35 and 36 of Stamps Act and the word instrument used in the said sections and also the definition of term instrument as contained in Section 214 of Stamps Act and held that the chargeability of the stamp duty cannot be made applicable to the copy of the document as it is not an instrument. It was held that the instrument means the original instrument and stamp duty has to be levied on the original instrument. The said principle was followed by Hariom Agarwal's case. Therefore, no longer the said point is res integra and it is already decided the and regards of section 35 and 36 will not apply to the copy of the document or instrument. My lord, now the document is marked. My lord, the trial court has relied on Jupadi Keshav Rao case, my lord. It is nowhere in the said case, my lord, it is said that the copy of the document can be admitted. May produce the
Para 10 you read.
As noted above, when the plaintiff failed to produce the documents, in spite of orders passed by this court on notice under Order 12, Rule 8 of CPC, the defendants have no other option are seeking to summon the persons who are having the custody of the copies of the documents and get them produced through the said third party. When the sufficient foundation is led to lead secondary evidence, the same cannot be found faulted with. Therefore, the objection raised by the plaintiff for marking the second compilation, which consists of photocopy of an agreement of sale said to have been executed by this very plaintiff on 3/2/2012 is rejected. Accordingly, answer this point in this negative. My lord, in the said para only, it is said that I have executed the agreement, my lord. If I am executed the document, I become the vendor. The original of the document will be with the purchaser, my lord. I will not have the custody of the document. And the photocopy of the document which is insufficiently stamped cannot be marked or admitted, my lord. That's what the case which is relied by the trial court also speaks about.
Yes, come.
May produce.
Then counsel for the petitioner submits that. The court has permitted to, court has marked, court has rejected the objection for marking the second compilation, which consists of photocopy and agreement of sale, lying on the judgment of the Supreme Court in Chuturu Krishna Rao's case, and held that and also observed that in the light of the same, the said issue is no more res integra. He submitted that as observed by the court, no such finding is given by the apex court. Considering the submission, should be stay of all further proceedings. Same in this case also by 6th memo, or else the stay will be vacated. Yes.
34.
Great.
Corresponding.
8, please, the honorable court. Lord, the petitioners are defendants in a suit filed by the respondent for specific performance of a registered agreement to sell. The specific contention issue before this honorable court is that in a suit for specific performance, when the vendors have cancelled the sale agreements before the suit is instituted, can the plaintiff maintain a suit without seeking a specific prayer that the cancellation is bad in law or that the agreement to sell is alive, is valid? In the present suit, no such prayer was sought. Therefore, the defendants, the petitioners here, the defendants filed an application under Order 14, Rule 2, praying that the court may frame a preliminary issue. Now, the court goes on to say that in view of admitted pleadings, clearly the agreement to sale has been terminated. But let us take that along with all the other issues to trial, and upon evidence, I shall decide that. My respectful submission is that, my lord, an issue such as that would be a jurisdictional issue, and the law is that even Order 14, Rule 2, very clear that if the suit is not maintainable because of a jurisdictional issue, then it is incumbent on the trial court to decide that issue first.
What did the trial court say?
Will not kindly have annexure A, the impugned order at page 18. The order itself begins at page 20, my lord. Page 21 is the operative portion. May I read, my lord?
Yes.
The application is filed for advocate for defendants requesting the court to frame the preliminary issue regarding maintainability of the suit. In the memorandum of facts, Shri Paras Pandey, advocate for defendants, states that this application is based only on the averments made in the plaint and documents produced along with the plaint. It is further stated that this application is maintainable. This is regarding the memorandum of fact, my lord. It is further stated that the defendants taken specific contention in the written statement at page number 16, para 20, that the suit is not maintainable on facts in law. It is further stated that the plaintiff has admitted with a legal notice produced
Where is
as
your IA?
Lord, the application lordships will find um, page number 81, my lord. In page number 81. Please, I'm not there. My lord has that.
Yes. Yes.
Page 81, my lord. The prayer is, my lord, undersigned advocate for the defendants respectfully prays that for the reasons as stated in the accompanying memorandum of facts, this court may be pleased to frame a preliminary issue regarding the maintainability of the suit in the interest of justice and equity.
The accompanying application is based on the averments made in the plaint and the documents produced along with the plaint.
That's right, my lord. And I have produced those documents.
Then counsel the petitioner submits that. When an IA is filed by the defendant.
May I produce just one judgment, my lord, where this direct point is addressed by the Honorable Supreme Court?
Not necessary. And an IA is filed under Order 14 to Rule 2 of CPC to frame the preliminary issue, the court, without considering the facts of the case, where the issue can be decided as a preliminary issue, as dismissed the IA. Observing that is
Page 24 is the observation, my lord.
that can be decided only during the trial. Then counsel submits that only basing on the plaint and the averments made in the plaint. And on a question of law, this petitioner has filed this IA, which was not considered by the court. Stay by 7th. Yes.
May be permitted to take hand summons on the advocate.
Yes,
Grateful.
certified.
Here for petitioner, my lord. It's a defendant writ petition, my lord. I'm only seeking direction from this honorable court to dispose of the matter, my lord, because
Here
this
is the matter.
suit is for 2006, my lord. And in the year 2006, the WS has been filed, my lord.
What is the present stage?
It's a summons, my lord. Notice of the summons. The plaintiff has filed one application by application. Now he has filed one application for Order 1 Rule 10. But the plaintiff advocate has remained absent since from 2013 to 2023, the PW1 is absent. And now since 1 year, the plaintiff advocate is absent.
What is the direction you're expecting this court to?
Dispose of the early.
How?
It's a year 2006, my lord. Suit is
That's why I asked, what is the present stage?
It's a application for this. We have filed the application and the court has issued the notice, but the plaintiff has not taken any steps.
Then after that, what the court should do?
Lord, he has not come forward, my lord. He has not filed and he has not paid the PF.
So the court is adjourning the matter.
Please, my lord.
Where is that? Where
Lord,
is the
kindly
order
see
sheet?
the order sheet, my lord. Page 136 to Your Lordship, please come to page 137, type the order sheet. Advocate for, it's a 29/10/2025. Advocate for plaintiff number 2, plaintiff place time for evidence finally so and so. And 4/11/25, IA number 33 is filed by plaintiff advocate under order on rule 10 CPC, PF wed, covers given issue notice. And then 4/10/12/25, plaintiff advocate present reissue notice. And 2/1/2026, plaintiff advocate present reissue notice. And then 23/2/2026, plaintiff advocate absent. And 23/3/26, plaintiff advocate absent. And 25/4/2026, plaintiff advocate absent. Finally by 1/6, and today was.
Petition is filed in the following prayer. And the petitioner before this court is the defendant in this court. Then counsel for the petitioner submits the suit of the year 2006, and it is still pending. The plaintiff has not cooperating. It is submitted that on his on the last 3-4 occasions, plaintiff is not present. And several applications were filed. The notices were ordered. There may be a direction to the court to dispose of the matter as expeditiously as possible. This court has perused the order sheet and having heard the grounds for the petitioner. This court deems that the problem. This court is it appears that the 2006 matter is still pending, and the order sheet also discloses that how the matter is dragged on. These circumstances, this court is passed the following order. The court shall dispose of the suit as expeditiously as possible. The same, no notice is issued because no act was ordered. Yes.
36, Vijay, third line. Application, please, my lord, in section 27 for adjudication of all issues, my lords, and an FTP proceedings came to be filed. Now that application, please, my lords, is allowed by the trial court.
Oh, I'm not able to see him. Yes.
That application is allowed by the trial court. Thereafter, my lord, the trial court further in the order sheet observes, my lord, that
What is that? I didn't hear the.
application, my lords, under section 47, please, my lords, came to be filed in an FTP proceeding, my lords, for adjudication of all issues. Because adjudication has to take place. Now, my lords, application came to be allowed. My application, my lords, came to be allowed. Thereafter, my lord, trial court in the order sheet observes, my lord, subsequently that this application is allowed. And my lord, subsequently it takes up the very same application which is allowed earlier and dismisses it by imposing cost of 10,000 rupees. My lords, kindly appreciate, my lords, my application, please, my lords, is at page number 74. This is my application, please, my lords, annexure K. Look, this application came to be allowed, please, my lords. Page number 173 is the impugned order. The order, please, my lords, at 173. It was allowed by the trial court.
You were not present when this order is passed.
I was present, my lords, but it takes up on its own and, my lords, dismisses my application. 173, please, my lords, is the order that has come to be passed, my lords, where the trial court holds, my lord, that this application has already been disposed of, and that application being disposed of, please, my lords, that order, my lords, will get it at.
So it says,
please,
the application filed, so disposed on 31/8.
Yes, my lord. 31/8, my lords, is page number 80. Page number 80, my lords, may appreciate.
Hence, by clarification,
yes,
by 1710.
Kindly appreciate page number 80, my lords. That application is allowed already, long ago.
The court also records that.
Yes, and thereafter, how can, once it is allowed, court becomes functus officio.
That is correct. You were representing before the court. What
no, I have no idea, my lord, that the court will take up the very same application, my lords, and dispose it off. I come to know, please, my lords, I was taken by surprise, page number 186, please, my lords.
On this day, you were not there, 173?
173, please, my lords. I was there, my lords. I have been present. I have already informed the court that this application is already allowed. So all issues will have to be adjudicated.
So why was this?
I am at pains to understand.
Has been allowed already, hence for clarification.
Hence for clarification, we have clarified.
Prior to that.
Please.
Come to the prior orders.
Not the order, my lords, is at page number 163, where the trial court observed, my lords, that this application is already allowed. Not page number 80, my lords, may appreciate for one moment, please, my lords.
Yes.
This is the application that I have filed, and this is the order of the trial court.
84.
Yeah, 80, my lord, 80.
No, the operative portion is at 84.
84, let's say 84, and yes, my lords, order IA under section 47 read with 150.
5921.
Yes, my lord, this was allowed. Now, this order operative portion is 80, IA under section 47 read with 151 of CPC filed by the respondents, number 29 and 30 is hereby allowed in the interest of justice and equity for further petitioner evidence by so and so, so and so, so and so. Now, this application is allowed. Now, my lords, the trial court, my lords, during the course.
Already disposed, hence clarification. Where is the present order?
This trial court, my lords, very same trial court, my lords, observes this at page number 173 that this application is already allowed.
Yes.
173.
Order on IA number 16 filed under section 47. Come to page 80 order again.
80, page 80, my lords. Yes, my lords, please. I am at 80 itself, my lords. My application was allowed by 80, by page 80 only. My application
starts.
But it starts, my lords, at my lords, page number 78, my lords. Orders on IA under section 47. It is very clear. Say page 78, please, my lords, annexurial.
No, it's very strange. How will the court do? No, this is numbered as IA number 16, the present order at page 179.
Please, my lords, but that IA, that is already.
Earlier, there was no number to this IA.
There was no number. That, my lords, IA, what at page number 78, my lords would get it. Orders on IA under section 47 read with section 151 of CPC. This was allowed.
Was filed by respondent number 29 and 30 on 23/3/2021.
This was allowed. But detailed order has been passed. This order was allowed. Now at page number 80 is the operative portion. This IA is allowed.
You can read something.
Please, I will read the whole. I'll read the whole order, my lords.
Come to paragraph number 2.
2, please, my lords. Yes, please, my lords. In the statement of objections, the plaintiff has stated that the respondents have no loco standing to file this application. The respondents cannot seek a preliminary decree in the final decree proceedings. The preliminary decree was not challenged in OS number 850 of 2009. Hence, prayed to dismiss the application, stating the application is devoid of merits. Heard both sides, counsel perused the entire material placed on record. According to respondents number 9 and so on. So the notice was not served.
I'm reading at page number 180, paragraph number 2.
180. I'll come there.
Paragraph number 2.
I'll come there. Please. Please.
Please read after the permission.
After the permission granted, the parties have adduced evidence and thereafter again matter has been posted for order. This court raised a doubt on 12/9/2020 that the application has been already disposed. Hence, called for clarification, where the counsel submitted that the same may be reconsidered only as permission is given on the application. We have not said as such. We have said our application is allowed. And IA number 16 is filed under order section 47 read with 151 of CPC to adjudicate the claim of the applicants, where summons was not served to them. They are subsequent purchasers of item number 1 and 2. The executing court can go into all the questions between the parties relating to the execution, discharge or satisfaction of the decree. Plaintiff has stated that the application is not maintainable as the applicant were parties before the court, where defendant number 25 has appeared through counsel, where defendant number 24 was served with summons but did not come before the court. This court permitted the applicants to come the
petition submits earlier the application that the application that's filed by the petitioner under section 47 at this section 151 CPC is allowed on 29/2021. Thereafter, the very same application was again heard by the court and dismissed the same by way of order impugned. You already submitted that. The same is not permissible. Considering the submission, stay,
So regret. Let's stay further proceeding.
hand summons, memo by 7th of July, or else stay granted by this court stands written. Yes.
37 urgent,
Great.
38. Puneet,
My lord, for the petitioner, please, my lord, may kindly permitted to appear through VC, please, my lord.
Yes.
My lord, I request for tomorrow, please, my lord, since my colleague was appearing in this matter. My lord, since there is an.
Tomorrow, once the matter is adjourned, we can't ensure when it will come. This
Right.
is matter on 30th of June. Yes, next.
39. C. Prakash.
I am for the, now this revision is as against rejection of my application for rejection of the plaint. Rejection of the plaint.
Hmm.
And
What is the suit for?
the suit was for filed by the daughters. The first defendant is the father. He alienates the property in favor of his elder brother. There's one transaction in 1995. And again, a few months later, he sells it to another person. Those two persons are dead. And the third person also alienates the property to the petitioners before your lord.
Please come to the
order.
IA application.
Application, my lord, your lordship finds it at IA number 7. It starts from 36. May I request your lordships to kindly take to 38, my lord. Para 5. Para 5. It reflects of the fact that the first defendant, who is the father of the plaintiffs, is placed ex parte way back in 12/1/2012. So he doesn't participate. He sets his daughters to file the suit. Then kindly take to the next paragraph, my lord.
Oh, in para number 2, you say,
yes,
I submit that after filing of the above said, due to subsequent events, the cause of action regarding so and so have already become abated and infructuous.
Correct.
How the court will know these facts?
Yeah, that is not been stated.
No, court cannot. In the plaint, it is not there. So this ground is not available. Then next, what is other ground?
And then, my lord, the next paragraph, para number 6, the man who purchased the property also dies, and a legal representative is not brought on record. That man dies, and the purchaser, the third defendant, also dies. The suit gets abated. So the prayers, insofar as relating to nullification, a declaration that the sale deed should.
To say that so and so person died.
That's a matter of record. It's in the order sheet. And
who said so?
It's sworn to an affidavit, my lord. In fact, in the order itself, the lordship may kindly take to the impugned order. It's an admitted fact that.
Please tell the court, whatever you are submitting, can it be is it part of the plaint? Is it part of the documents that are filed?
Yes. Lord,
plaint.
The plaint, I'm
You are saying that all these circumstances are subsequent to filing of the plaint.
No, of course I should stand corrected, because it is not subsequent that.
Please come to the order. Come to the order.
The order starts from page.
Paragraph number 9.
Yes, my lord. The above provides a manifest where doesn't disclose the cause of action on the face of appears barred by any law, then the plaintiff has to reject it. It is worth to refer to the decision of the Honorable High Court of Karnataka, the case of
You can come to next page bottom. In the case on hand, the defendant number 4 to 9. From bottom, some 4 lines.
Yes, my lord. Yes,
Yes, did that.
In the case on hand, defendants 4 to 9 specifically contend the plaintiff have not taken any steps to bring the LRs of legal heirs of deceased 2 and 3. Defendant number 2 and 3 and asset suits against 2 and 3 was dismissed as abated. The cause of action against D2 and D3 and prayer sought lapsed and has become infructuous. And perusal of the material placed on record shows that on 16/4/2014, plaintiffs have filed the applications to bring the LRs of the deceased defendant number 2, and no order has been passed on said applications. On 22/2/2018, suit against defendant number 3 dismissed as abated. Suit is for partition and separate possession. Mere suit dismissed as against one of the defendants as abated does not tantamount to dismissal of suit, nor the plaintiff is entitled for it. So this is the solitary reason ground
given by the learned trial judge for rejection because
Earlier application is also dismissed.
that is also rejected. I stand.
And again you file another application.
They did not.
You understand what I am asking?
I know.
You have, an earlier application is rejected, you don't question it. Again, you come up with another consecutive application. Court dismiss with costs of rupees 1,000. So why not this court to dismiss it with 10,000, you have to tell now?
My lord, I can't go beyond the records, whatever that. I only say.
Dismiss with cost of 10,000.
May I request one indulgence, my lord? Because the parties are around court for almost one-sided contest and no plaintiffs appear. And after the evidence is closed, nobody appears. And
if that is the case, your remedy is not to file application under Order 7 Rule 11.
No,
It's something else.
may I request, I would file a memo for withdrawal of the petition, my lord.
Tomorrow for filing the withdrawal memo.
Today itself I file, my lord.
No, yes, memo is for seeking to withdraw the petition.
Will you kindly take on it?
Dismissed as withdrawn.
I would.
Give the memo. Yes, next.
Party adjourned. Kantaraj?
Yes.
This CRP is filed challenging the orders of the trial court under
Please, can you
Order
please
7
come to
Rule
the
11, my
affidavit?
lord.
Please come to the affidavit.
My lord?
Affidavit support, in support of the IA.
Yes, my lord. Yes, my lord.
You can read.
I am the petition number 1 in the above CRP petition and I am authorized to sign on behalf of the other petitions also. I state that accompanying CRP petition has been filed challenging the order dated 2/5/26 passed in IA number 6 in OS number 213 of 2025. I state that the Land Trial Court failed to appreciate the suit itself involves dispute regarding the title, mutation entries, survey proceedings and issues arising out of the alleged transfer of granted lands, my lord. This is under PTCL, my lord. This land is under PTCL and there is already disputes with respect to the title, mutation entries and other things. The client has drafted this very cleverly to instead of filing a declaration suit, he has filed the injection suit, my lord.
What is the full form of this? PTCL means?
Prevention
And
of
transfer of?
the Karnataka scheduled caste and scheduled prohibition of transfer of certain lands, my lord.
What is that?
Prohibition of transfer of certain lands.
Certain lands.
Yes, my lord.
Come to the impugned order now.
Yes, my lord.
Yeah. What gives the finding at 9.1 and 10?
But I'm in the total disagreement with the said contention for mere reason that the alleged transaction between the original grantee Hanumanthappa and J. Devappa under a registered sale deed dated 10/4/1963 is absolutely not the subject matter of this suit. The relief sought by the plaintiff with respect to my lord, there is absolutely no cause of action legally recognizable. There is no cause of action, my lord, because we are in the.
Shall take out answerments on the counsel appearing for the respondent. Shall file a memo to that effect by 6th of July. If the memo is filed, list the matter on 7 July.
42, Kantaraj?
Same one, my lord. The balance is other 20.
This also.
43.
43.
Amarnathan?
The surface notice is not applicable to this finance respondent, private financial, my lord. There doesn't come under section 3 of the Surface Act. My remedy is before civil
What
court.
you have to understand is, it's not DRT, you have to go
But
wherever you.
yes, yes. That's
National
what.
Trust
If my
Finance
lordship I mentioned
Limited.
DRT only, civil court or criminal court.
Yes.
Yes.
Where is
That's
that
all, that's
order?
all correction.
Where is that order? Order. Order copy. I give-
Last paragraph, my lord. According to the writ petition disposed of giving liberty to petitioner to avail the appropriate remedy
This
before
court has
DRT.
disposed of the. WP number 2293/2023 by order dated 21st April 2026, whereby this court has permitted the petitioner to go before the DRT. It is submitted that the Securitization Act has no application.
Here, madam.
Huh?
Section 3, this financial, they are not registered under section 3 of the Surface Act.
That the respondents are not
My
registered.
remedy is civil court or criminal court.
3 of the act, and he cannot go before the DRT. In that view of the matter, the order dated so and so at clause number 1 of the same. Accordingly, the writ petition is disposed of, giving liberty to the petitioner to avail the appropriate remedy. Same, the petitioner shall have the benefit and also pay accordingly. RP is disposed of. Yes, please.
44, Abhijit?
No, call the.
Appearing for the respondent.
Call the other matters, the passovers and 230 matters.
Matter mentioned at 230, serial number 52.
Yes, where is he?
Swarupesh?
His colleague was here, just here. Another matter may be taken, she may be outside.
Yes, next matter.
Matter is moved at 2:30 PM. Serial number 1, Sadanand G. Shastri. Sadanand. Serial number 2, Manu Prabhakar.
Respondent, my lord, please. Let me make one submission before my learned friend begins. This matter was adjourned to 17th, and this morning at around 11:45, I was informed that this matter is moved.
Tomorrow
I
I'll
think
have-
possibly.
Tomorrow I'll have it in the first list.
Indeed, or maybe if day after itself, if your lordship.
Day
may
after in the first list. Yes.
Great.
Yes.
Submission. Previous matter was mine.
Yes,
Moved it at
do
2:30.
that.
Sadanand G. Shastri.
Beg to appear for the petitioner in this matter. Lord, the order that is hurting me is at running page number 62, my lord. My lord, a demolition
number?
warrant comes to be issued in the
Page number?
62.
Yes.
So here, my lord, learned counsel for the DHR present and praised time to file objections to IA number 4 of 2026. Counsel for objector present and seeks time to pass the order of stay of operation of the demolition order. Heard both counsels. Appears that detailed inquiry needs to be held in the application, hence placed before the regular court for passing necessary orders. So the regular court is vacant, my lord. This was the court in which, with great difficulty, we got the matter posted at the first place, my lord. My application comes to be filed on 9/6/2026. That is at page number 61. Previous page at the bottom right hand side, my lord. Case is advanced IA number 4 of 2026 and order 21 rule 97. Read with section 155 is filed for objections on 11/6. The next day only they have given. Thereafter court is vacant. Now for a period of 1 month there is no presiding officer. The issue in list is this, my lord. A demolition warrant comes to be issued on the execution schedule property. The bailiff as well as the decree holder now, my lord, they want to demolish the petition schedule property. The backdrop
When was the warrant issued?
order is issued on 28/4/2024. That is at running page number 57 of
28?
4/2024.
When did you come to know about this?
On 8/6/2026, when the bailiff along with the decree holder comes to my property for demolition of it.
When did you move the court?
I have moved it on 9th, my lord. Next day, I have asked for the certified copies and immediately I have advanced the matter. Immediately, I filed this application. What is pertinent to note is this, my lord.
No, there is no order.
There's no order only passed on the warrant. Simply, they say that it is posted for objections. Because the regular court is vacant. post it on the regular court, that is the order. Erstwhile also, my lord, the very same decree holder, my lord, I will be able to point out, against one Kadarappa, he went to his property to demolish. He failed there. The suit is of the 2004.
What is the suit for?
Suit is for declaration and injunction, my lord. I am not a party to it. Erstwhile, one obstructor came on record, my lord. That is at page number 39, your lordship.
So what is the connection between your vendor and?
I am the neighboring property, my lord. He is trying to demolish my property. All that I sought for before the trial court was this: let my application be decided. The trial court holds that the application has to be decided, inquiry has to be held. Subsequent to holding that, my lord, there is no stay on the execution warrant.
Yes, ma'am. The petition is agreed with the order dated 11/6/2026, whereby the court, instead of granting stay of the proceedings, had only adjourned the matter, observing that detailed inquiry needs to be held in the application. Then counsel submits that there's a threat of demolition, and the court ought to have passed an order in favor of the petitioner. Till the inquiry is conducted, considering the submission, there's a stay of all further proceedings. Pursuant to the order dated 28/4/2026, passed by the so-and-so, this is page 21 interpret, so-and-so. Till the next date of hearing, notice to the respondents, same, hand summons. And if the memo is not, memo shall be filed the 7th of July, or it's a stay granted by this court, stands vacated.
I seek hand delivery because they are at the property today also.
Hand delivery of the order is permitted.
Highly obliged.
Call it.
52.
Yes, come. No, this 51 you can. Yes.
Represent the state in the matter.
One minute.
Sorry, sir.
List number 152.
Alert, so an order dated 2/4/2026, your honor said directed deposit of 1.96 crores and immediately they were directed to release the assets. So that was extended, it was rather corrected and it was supposed to complete this order by 2/5, my lords. Now there was some mistake and there's some transactional errors. Today I'm very ready to pay. From 10th only I filed an application. If they furnish bank details,
My lord,
before your honors raises, I'll make the payments.
That order also they have not complied, my lord. We strongly oppose.
No, that is already stated, so I also understand. That's why it's taking time. What are your instructions on that? No, from the date, like the court has granted the extended 20 days time. From there to now, on that amount, any interest that has to be paid, we'll also direct him to pay the interest.
6% interest.
First of all, let him transfer the amount today. I will take up this matter in the first list tomorrow. Let Mr. Vignesh Shetty come and appear.
Please, ma'am.
The land counsel for the petitioner submits that this court by order dated. When was the disposal?
My lord, sir, 2/4 and 21/4.
On 2/4/2021.
2/4/2026, 20 days was
Has
granted.
disposed of the order.
My lord, sir,
Where is that order?
that is on 2/4, my lords.
1 minute.
It was corrected to 30 days because there was an error in the order.
On 2/4/2026, it's an interim order.
That was an interim order, my lords.
2/4/2026, this court has passed an order that the petitioner shall pay an amount of rupees 1.96 crores within 20 days from today. On the receipt of such payment, the respondent bank shall release the mortgaged property, that is item number 7, in favor of the petitioner. On 21/4/2026,
20 days was corrected to 30 days.
it is submitted the court, before this court, that in the while dictating the order, the court has observed 30 days, but in the order it is reflected as 20 days. Hence, he has moved the memo. Then counsel appearing to the respondent bank has also not disputed the same. Hence, this court has modified the order, and instead of 20 days, it is modified as 30 days. When the 30 days time will complete?
2/5/2026.
The 20 days, 30 days time will complete by
2/5/2026.
2/5/2026. And from when you have started moving this?
10th, my lords, 10th of this month.
It is submitted that. What is the reason why you have not complied with?
So summer vacation is one reason. Another one is he was expecting funds that got delayed by.
It is submitted that as there was some delay in getting the amounts. He could not pay the amount. It is submitted that right from 10/6/2026, the petition is moving this matter before the court as the amount is ready and is ready to deposit the money. Then counsel appearing for the next parallel and counsel appearing for the respondent submits that the petition has failed to honor the order passed by this court and he is repeated and he has failed to pay the amounts. Considering the fact that he is ready with the money and whatever is the delay from the date of the order, the petitioner is ready to pay the interest also. Considering the same, the petitioner is directed to transfer the money and today itself, and tomorrow the matter will be taken up.
Bank cards may be completed tomorrow afternoon, 2:30, it may be taken up, Manoj, by then I think.
List is matter day after tomorrow in the first list, and the court will pass suitable orders on that day.
Grateful.
Yes, next.
List number 258.
Represent the state in the matter.
Phone number 3. Senior counsel Mr. Panindra appearing in this matter for R3. Seeking short pass over.
Could be taken up tomorrow if my learned friend is held up somewhere. He represents the temple. Tomorrow in the first list in the morning itself, it could be
Let it be in the first list tomorrow.
grateful. My lords, he came, my lords. I'm sorry.
Yes.
Lord, my lords were asking me about the compliance. Lord, 23/4/2026. My lords had passed an order. 23/4/2026.
23/4. Yes.
Now, my lord, in compliance of that order, my lord, an affidavit has been filed on 1st of June.
Petitioner exercising the right of preparation of prasadam and selling the same.
Yes, my lord.
Yeah.
My lords had asked me to produce documents.
No. What is the answer? First of all, you have to answer to that in your affidavit.
My lord, first question is, my lord, petitioner is exercising the right of preparation of prasadam and selling from which year? Documents, if any, may be placed before this court. My lord, I have done that.
Say and you have to file.
Yes, my lord. My lord, what I have said is, my lord, for the last, my lord, 50 years, my lord, we have been doing it. Please see, my lord, page 2. 60 years, my lord, we have been doing it. And documents are, my lord, resolutions of the temple committee itself. Resolutions of the temple committee. Please turn to, my lord, page number 6. My lord, this is the first of the documents which were, my lord, available readily. This is dated 6/1/1984.
Where are those documents?
My lord, along with the affidavit, my lord.
You file. Wait,
My lord, 1/6, my lord, I filed it on 1/6.
Printout ಇಟ್ಕೊಳ್ಳೋದನ್ನ ನಿಂತಿರ್ತೀರಲ್ಲ.
There is some document on 36.
1/6, my lord.
10/6. 1/6, yes.
1/6. Please turn to, my lord, first of the, my lord, documents. It has page number 6. The temple committee passes this resolution on 6/1/1984. Lord, I have given the typed copy. I'll take my lords to the typed copy. Then, my lord, the next resolution is of 3/2/1984.
Where do you find the name of the petitioner?
Petitioners, my lord, Adi Narayanappa, my lords will get. There is no difficulty about that. My lord, I'll take my lords to the typed copy. Typed copy, my lords will get at page number.
What is petitioner's name?
Petitioner's name, my lord, is Rangaraju, my lord, and Hema.
Rangaraju and Hema. Where do you find these people's name?
My lord, their grandfather's name is there. Their grandfather's name is Adi Narayanappa. And my lord, these are the grandchildren. He is not there anymore. My lord, I have stated so in my affidavit. Please have a look at, my lord, page number 2 itself. I have stated so.
Adi Narayanappa is the grandfather of the petitioner. That
Yes.
is the first petitioner or second petitioner?
Second petitioner.
That is the, no, lady is the husband of the second,
Yes, yes.
wife of the second petition. Yes.
No, no,
No,
Lords,
no.
I think there is some
Brother,
confusion.
my lord.
Let him
Husband's
clarify.
brother. My lord, the first petitioner is the second petitioner's husband's brother. No, my lord, please have a look, my lord, what I have said in page number 2.
So according to you, the 6/1/1984,
Yes, my lord.
court is given to this Adinarayanappa, who is related to you.
Yes, my lord.
Then what are the other documents?
Then, my lords, will kindly see.
What are the years? We are referring to this one, is dated 6/1/1984.
True, my lord.
Then where are the other documents?
Lord, then,
This till 8, then 9.
Lord, 25/8/2018, annexure Q.
1984.
Yes, my lord. Then, my lord, 25/5/2018. 25/5/2018. Please come to para 5, where the name of my lord, these petitioners is.
Let me just find out here from the
Yes,
papers. I'm looking at it. Then what is at page number 18? So material papers,
Pardon, my lord.
page number 18.
18, my lord, is the proceedings, my lord, where my name is specifically shown. And, my lord, we have been performing these rights. That is recorded in, my lord.
25/5.
Yes, my lord, 2018. Where?
Please read it.
Yes,
what
my
it
lord.
says.
Srimati Hema avaru, Devalayadalli.
What is the heading?
My lord, heading is about the representation given, my lord, by Hema.
Of what? What is that representation?
My lord, representation is, my lord, to permit them to sell, my lord, the prasada items.
Where is that representation?
That I have not produced. I can produce it, my lord. That was given to the temple committee, pursuant to which, my lord, there is a.
When was the representation?
My lord, representation is given in the year 2018. My lord,
What was the necessity when you are continuing from 1984 to?
yes, my lord, I will explain, my lord. My lord, what was happening, my lord, is after the puja hours were over, my lord, prasada items were not being given to the devotees. So, my lord, the devotees who used to come from outside, they made a request to the temple committee saying, we are coming from far outside. After the puja hours, no prasada is being given. So, please make a system where even after puja hours, the prasada is given. Because, my lord, after the prasada, puja hours were over, prasada was not being given. So, they made a request saying, please, after the puja hours are over, please make a system whereby devotees who come from far-flung places, they are able to get. Under that context, my lord, the committee first resolved, saying that you people give the prasada even after puja hours. During the puja hours, my lord, there was no difficulty. We were giving it. The devotees used to get it.
No, you have the stage.
Yes,
You
ma'am.
have the file with you?
The original file, my lord?
2018, my lord, this is recorded. 84 is the first, my lord, where we are able to get them. There are earlier records as well. If the original records are there, there may be earlier documents. We got, my lord, only 84. And if my lords were to turn to, my lord, annexure Q, page number 22, they specifically record, my lord.
Today it hasn't had it, my lords, but then I could take out whatever was there earlier and I have produced it.
Lords,
The
that
very
may not
case
be
that-
necessary, original records. For the
I am-
simple reason, first, my lords, on maintainability, please see the earlier writ petition filed by them.
That is what emanated.
Constructive res judicata, my lords, he goes and participates in a tender, comes before this court, and today is turning around.
That is what everything has started from there. Having given an earlier representation without even mentioning about any of the
Where-
credit
No, my
guys.
lord, please have a look, my lord.
From
Please
where
have a
is
look, my
all
lord.
this?
Please have a look at, my lord, 1 minute, page number 22, their own resolution.
Lords, he could have agitated this
1 minute,
point
sir,
in the
let me
earlier writ petition.
Let me complete, let me
There's a
complete.
new case being made out.
Please look at, my lord, page 22,
What it says.
serial number 3. Srimati D. Emma has been providing, my lord, all the prasada items in the temple. Requested it to be continued for the next 10 years as the period is about to end. After examining the matter thoroughly, Srimati D. Emma belongs to the priest family of this holy area, Kshetra, and has been selling prasada for the last 25-30 years, hereditarily, that is Vamsha Paramparya as per customs and traditions of the temple, without any complaint from the villagers, devotees, and the public, and by paying the money due to the temple from time to time. It is decided that this can be proposed to the Honorable Commissioner to continue the sale of prasada for the next 10 years in the interest. My lord, now it is my
No,
lord,
no, let's
their own
read.
temple. 1 minute, sir. Let me complete,
No,
sir.
no, this-
Now, my lord, it is my lord. Now, my lord, priests, persons who have not read. My lord, the permission that is granted is to give prasada after, my lord, the puja hours. During puja hours, my lord, nobody can stop, my lord, prasada which is given. Devotees will come, my lord, they expect the prasada to be given. My lord, when they have the darshan of the deity, after, my lord, the puja hours are over, persons who come from, my lord, far off areas, they want some facility to be given, that was extended. Now, that is what is being extended from time to time. My lord, prasada is, my lord, prepared as per the Agama Shastra by the persons, my lord, inside the temple. Nobody outside can come and start.
The prasada that is prepared.
But Panchamrita, Panchakajjaya, my lord, all these things, my lord, Kalsakre, all these things, my lord, which are offered to the deity and then given to the devotees. Report is filed by the Agama Pandit, their own Agama Pandit. Now, my lord, it is very easy. My lord, while filing the writ petition, my lord, there may be some, my lord, lacuna in describing this. But it is not, my lord, an afterthought. This is their own record. This is a temple committee's record, which they say I have been doing it, my lord, hereditarily. This is not a new innovation, my lord, as they are trying to project before my lords. Now, this is the, now, my lord, the Pandit come, the Agama Pandit who is attached to the office of the, my lord, commissioner. He comes, he inspects, he gives a report, my lord. Please have a look at that report.
Page number
My lord, that is page number 188.
188.
Oh, sorry, my lord, 24, my lord, I'm sorry. I had made some numbering, my lord, page number 24. My lord, I'm sorry, I'm getting this translated into English. I'll place it, my lord. Agama Pandit, at page number 24, para 3. My lord, about 5-6 lines from the top, serial number 3. I'll just read, my lord. Ipatna. Along with the affidavit ಇದೆ. ಸದರಿ ಶ್ರೀ ಡಿ ಹೇಮಾ ಹಾಗೂ ರಂಗರಾಜು, ದಟ್ ಈಸ್ ದಿ ಪೆಟಿಷನರ್ಸ್ ಅವರು ಆಯುಕ್ತರು ನೀಡಿರುವ ಆದೇಶಾನುಸಾರ ದೇವಾಲಯ ಪಾವತಿಸಬೇಕಾದ ಎಲ್ಲ ಮೊತ್ತವನ್ನು ಸಹ ಸಂದಾಯ ಮಾಡಿರುವುದು ಕಂಡು ಬರುತ್ತದೆ. ಈ ಹಿಂದೆ 2020 ಮಾರ್ಚ್ ಹಿಂದೆನೆ ಸುಮಾರು ಕಾಲ COVID-19 ಕಾರಣದಿಂದ ದೇವಾಲಯದ ಬಾಗಿಲುಗಳನ್ನು ಮುಚ್ಚಲಾಗಿತ್ತು ಸಹ ಸದರಿ ಅವರು ದೇವಾಲಯಕ್ಕೆ ಪಾವತಿಸಬೇಕಾಗಿದ್ದ COVID-19 ಸಮಯದಲ್ಲಿ ಎಲ್ಲಾ ಮೊತ್ತವನ್ನು ಸಹ ದೇವಾಲಯದ ನಿಧಿ ಸಂದಾಯ ಮಾಡಿರುವುದು ಕಂಡು ಬರುತ್ತದೆ. ಇದರಿಂದ ಈ ಮೇಲ್ಕಂಡ ಅಂಶಗಳ ಅನುಸಾರ ದೇವಾಲಯದ ನಿಧಿಗೆ ಹಾಗೂ ಭಕ್ತಾದಿಗಳಿಗೆ ಯಾವುದೇ ತೊಂದರೆ ಆಗದಂತೆ ನಿರ್ವಹಿಸಿಕೊಂಡು ಬರುತ್ತಿರುವುದು ಕಂಡು ಬರುತ್ತದೆ. ಸದರಿ ತೀರ್ಥ ಪ್ರಸಾದ, ತಾಯ್ತ ಮುಂತಾದ ವಸ್ತುಗಳನ್ನು ತಯಾರಿಸಿ ಪೂಜಿಸಿ ಕೆಲವು ಪ್ರಸಾದಗಳನ್ನು ದೇವರಿಗೆ ನಿವೇದನೆ ಮಾಡಿಸಿ ದೇವಾಲಯದಲ್ಲಿ ಹಿಂದಿನಿಂದನೂ ನಡೆದು ಬಂದಿರೋ ರೂಢಿ ಸಂಪ್ರದಾಯದಂತೆ ಹಿಂದಿನಿಂದಲೂ ನಡೆದುಕೊಂಡು ಬಂದಿರುವ ಬ್ರಾಹ್ಮಣ ಸಮುದಾಯ ಈಗಾಗಲೇ ಸಹ ಮುಂದುವರಿಸಿಕೊಂಡು ಬರುತ್ತಿರುವುದು ಕಂಡು ಬರುತ್ತದೆ. This is the Agama Pandit.
What did he say?
He says, my lord, from the last, even earlier to 2020, my lord, these people were doing it, and my lord, they have been traditionally offering this as per the traditions and customs, and my lord, offering to the deity and giving it. And my lord, last 2 lines they say, my lord, this is as per section 58 of the 2002 Act. Even earlier to the Act, they have been doing, that is what he would say. And my lord, these traditions and customs are protected under section 58 of the Act. This is their own Agama Pandit in the office of the commissioner. My lord, now it is trying to be portrayed as if, my lord, I am putting forward a new case. I am not putting forward a new case because, my lord, if I am able to show hereditary rights, my lord, the entire complexion changes. I will tell you why, my lord, I am saying that. Now, my lord, the impugned order is not prohibiting me from, my lord, manufacturing prasada or offering prasada or selling prasada. What the impugned order, my lord, virtually says is, you don't give the prasada here, you go out and give the prasada. And that is what, my lord, the earlier council, my lord, who was representing the state, that is the submission they said. We have no objection, let them prepare prasada, let them offer prasada, but outside the temple. That is what they are saying. The impugned order, which my lords will kindly see, annexure H, only says, you please give the prasada outside. Your contract is over. You give the prasada outside. So therefore, my lord, the question that arises in this writ petition is whether I have got a right to offer prasada or sell prasada. That is not the right. The place at which, my lord, I should sell the prasada is the question. If as per the temple and traditions, my lord, there's a designated place, I have to offer the prasada near the deity because, my lord, after the, my lord, devotees come and, my lord, have a look at my lord, the deity take darshan, my lord, they expect the prasada to be given there. They can't expect the devotees to walk outside, my lord, somewhere and then take prasada there. And that is the submission which, my lord, was made. It is recorded in the order sheet. My lord, earlier, my lord, senior counsel was there, my lord, who was appearing for the state. He says, my lord, let them do it outside. And why all this has become a problem is, my lord, please have a look at the order dated 10/1/2024. The tug of war is because of this. 10/1/2024.
Yes.
My lord, 10/1/2024, this honorable court, my lord, notices the order dated 15/11/2023, where I am permitted to continue the business in the place where I was doing. Last line, my lords, will get at page number, order dated 10/1/2024, first page. Till such time, petitioners are permitted to continue the business. The order was passed on the score that in identical circumstances, government itself had extended the tenure of persons of similarly situated persons like the petitioner by way of a concession. Then, my lords, will kindly see, learned government advocate, after the grant of the interim order, submits that the same was communicated to the Secretary, Hindu Religious Institutions and Charitable Endowments, who in turn directs the second respondent commissioner to permit the petitioners to continue their business and not to disturb them till further orders. The commissioner then communicates this to the executive officer of the Ghati Subramania temple on 26/12/2023. Even then, the executive officer did not comply with the directions of this court or the communication by the superior officer, that is the secretary and the commissioner of the charitable endowments. Therefore, the action of the executive officer in not complying with the order fringes on or borders on contempt. The matter was moved today on the score that the executive officer has not permitted continuance of business despite interim order even as on today. Learned additional advocate was directed to secure details as to why the executive officer has dodged the issue despite orders of the court. Then comes an order dated 10/1/2024. The order runs counter to the earlier contract itself and onerous conditions are added without the leave of the court. The executive officer appears to have passed an order overreaching the interim order granted by this court. Therefore, the executive officer shall explain by way of an affidavit as to how he could impose additional conditions which are not the subject matter of the interim order or earlier contract entered into between the parties. The executive officer has blatantly violated the interim order of this court, which directs continuance of the business of the petitioner poor vendors. It is a small business they are making their living from. The interim order is dated 15/11/2023 and we are at 10/1/2024. Therefore, close to 60 days, the interim order is not complied with and poor petitioners have lost their business only on account of the unacceptable attitude of the executive officer. Therefore, the petitioners are entitled to make good the loss of business, at least to a minimum extent, for the carelessness of the executive officer, and that too in not following the orders of the court, the order of the secretary, and the directions of the commissioner by directed implementation of the interim order. Therefore, the executive officer shall bear the brunt of payment of cost of rupees 25,000 to be paid from his pocket to the petitioners by the next date of hearing. The contract or business of the petitioner shall continue without any additional conditions as imposed in the order dated 10/1/2024, list the matter for further hearing. So therefore, my lord, this is the reason why I am now being hounded, my lord, in this manner by saying, no, he is not even an hereditary person, he does not have any rights. Now, my lord, after this, my lord, on the previous occasion, the learned advocate, my lord, in fact, I think, my lord, he has filed a memo. If my lords can kindly take the memo dated 12/6/2026. My lord, filed by the third respondent on Friday, 12th of June, my lord. They have filed a memo and produced an order. In this order, my lord, they for the first time prohibit.
There is no 12/6.
12/6, my lord, the third respondent, my lord, served a memo and produced some documents.
What did they?
It's probably not put up, my lord. They gave it on Friday. Please, my lord, have a look at, my lord, in that compilation, page number 53.
Yes. Yes.
Lord, this is the resolution, my lord. Now there is a board that is constituted. Now this board, my lord, has passed a resolution on 18th of May, my lord, which is now produced before my lords. And my lord, I am reading the translation which my lords will get at page number, my lord, 53. They refer to a Madras High Court judgment. Please see the last two lines. It is ordered that private individuals should not be allowed to sell prasadam in the temple. So this is for the first time, my lord, they are restricting the right. At present, private individuals are selling about 20 items in the temple for the past 20 years, the period of which expires on 2023. The said individual should be removed from the premises immediately, and all the prasada items should be prepared by the temple itself, and proper account should be kept and necessary arrangements should be made for the temple to sell the devotees who come to the my lord, there is some mistake there. Commissioner's order dated 25/9/2023. This is the order, my lord, which is challenged in the writ petition, saying, my lord, that I must be shifted out and the temple itself must perform the make the prasada. Challenging the order, petitioners have obtained an interim order and writ petition number. My lord, the number is wrong. It is 25004 of 2023 in the High Court and is continuing business. The next hearing is on 2/6/2026. The sanctity of the prasada which has been affected due to the prasadam being made by private prasadam sellers who do not make offering to the deity before selling the prasadam. 5 head priests of the temple have submitted opinion dated 24/2026. My lord, this is contrary to what the Agama Pandit, my lord, says. They get the 5 priests, my lord, ask them to submit something on 24/2026. I am not put to notice based on what these priests would say. In view of the above, the following steps are taken. It is decided to ban the sale of prasada by private persons within the purview of Gati Subramanya Swami temple. So this is the first time, my lord, they are saying that the sale of prasada is banned. As per section 38 of the Sri Gati Subramanya Kshetra Development Authority Act, the draft rules for implementation of the distribution of...
I have seen that.
Yes, my lord. Now, my lord, this is challenged in a writ petition because for the first time, my lord, they are now seeking to prevent, my lord, the preparation and...
What happened to that?
My lord, that has to be listed, my lord. I think it is coming, my lord, day after tomorrow. 17811 of 2026. My lord, that is the writ petition. Because on the previous occasion, my lord, the submission was made. Just like in other temples, we have also brought in a system where, my lord, these things would be done, which is why I am pointing this out. And, my lord, this writ petition is filed. Therefore, my lord, it is in the fitness of things that this writ petition also be called before this court, and, my lord, it can be taken up together because both the matters are interlinked. First, my lord, they say that you don't sell the prasadam here, you sell it outside. That offer was made, my lord, even during the course of the proceedings where the then, my lord, additional advocate general comes and says, I have no objection for them to sell so long as they sell it outside the temple. Then, my lord, we bring the Agama Pandit's report and say, this is prasada, the Agamas.
No, there is no body constituted under the Endowments Act which will decide about the hereditary rights of the people, of the parties involved.
My lord, now there is an act. Under this act, my lord, there is no mechanism, my lord. Now there is a new act which they themselves have produced. Please have a look at that act.
Let's not confuse the court. We should be fair to the court. Any hereditary rights, there is a Raja Dharmika Parishad. They have to agitate there.
Please look
to
at
say this act
lord,
is, lords, my learned friend should confine. What's happening today is, my learned friend is simply going everywhere else.
My lord, under the Endowment Act, my lord, there are two mechanisms, my lord, that is before the Deputy Commissioner and before the Raja Dharmika Parishad. Now, my lord, this temple is governed by a new act which they themselves have
That's
produced.
for management of the temple.
Yes, management means what?
That has,
please have a look at that.
Independent Act.
Lords,
They have brought a new act for this temple.
Lords, only. Lords, I think let him, we will, my lords, we'll argue only on merits because this is
prayer,
going.
my lords, what has he asked and the manner in which he has asked the prayer also. At one stretch, he goes on to say that he is an uneducated employee, I mean, uneducated person. So kindly give me the permission to. Second thing is, my lords,
That I understand. Now, forget about what has been stated. So
Please.
that he has not stated the fact that is already taken note of by the court. No, all the proceedings that he has placed before the court, it appears from that, but he is doing it from a very long time.
No,
Is it correct or
no,
not?
the question is the manner in which they have approached the court also. An annexure is placed at annexure G of page 47, where again they say it was for a particular period of time, that period is over because of the fact that COVID-19 has hit and there was a certain time lapse. So kindly give us extension only to that extent. Now today they come before this honorable court to impress upon my lords to say that no, this is hereditary. Never was there case of an hereditaryship. I can produce the copy of the
Pointed out the proceedings, just now he read.
that is for another person.
Lords, that
May I
is-
point out?
Lords, may I just submit, that is a resolution of the temple committee, managing committee was governed by elected members. And that was to be placed before the commissioner. The government has to take a decision. That never happened so far as they are concerned. Agama Pandit's report, which my learned friend has been flashing, that's a part of the writ petition. That Agama Pandit's report was negatived by the commissioner way back in 2023. That's when tender was issued. My lords, your lordship may kindly take the writ petition at page 27. Annexure C. Your lordships will have the same petitioners, Rangaraju and Hema. Now please see what is questioned in that writ petition. At page 28, the petitioners are before this court calling in question a communication dated 27/12/21 made by respondent to deputy commissioner and district magistrate, by which a tender is called for leasing out the items that were leased out in favor of petitioners by separate official memorandum. Then, my lords, please see what they said. They say they are vendors, never claim any hereditary rights. Now please see what they say at the last three lines in page 29 at para 3, my lords. Commissioner for Hindu Religious Institutions and Charitable Endowments issues 3 official memorandum, one on 28 to 2018. Your lordships have that, my lords. Page 30. It starts 29 bottom, page 30. Conferring certain rights of sale of certain items in favor of petitioner number 1, that is Rangaraju, commencing from 17/3/2018 for a period of 5 years. The period gets over today, 16/3/23. The other lease that was granted on 13/8/2018 was with effect from 23/6/2018, which would get over on 22/6/2023. The third lease is granted on 13/3/2018 in favor of petitioner number 2, which was to commence on 28/7/2018 for a period of 5 years. Therefore, would in subsistence up to 26/7/2023. All the aforesaid leases were granted by the commissioner during subsistence of the leases, and petitioners are carrying out their businesses in terms of the said leases. Later, as a bolt from the blue, a communication came to be made on 27/12/21, not by the commissioner, but by the deputy commissioner and district magistrate of Bangalore Rural District, by taking away the lease rights granted to the petitioners, directing that all those items which are leased to the petitioners, permitting them to sell items in and around the temple, be leased by conduct of an e-auction. It is this communication that drove the petitioners in the subject petition. This court, entertaining the petition, has granted an interim order of stay of the impugned communications, pursuant to which petitioners are now continuing their businesses in terms of the lease pursuant to the aforesaid official memorandum. Learned counsel for petitioners would urge a solitary contention for the present that the order passed by deputy commissioner is without jurisdiction, as the leases that were granted by the commissioner could not have been taken away by the deputy commissioner, who has nothing to do with the power to be exercised under the Karnataka Hindu Religious Institutions and Charitable Endowment Rules 2002. Learned counsel for respondent 3 temple would refute. Then, my lords, please see government's contentions at 8. Now please see, my lords, at page 34 para 12. Admittedly, temple is a grade A temple and rights and privileges apart.
I've seen the order.
So, my lords, what ultimately the court said is, we give a discretion. That discretion was exercised. Then their request was rejected. He comes before this court. Now, my lords, not a whisper in the previous writ. He could not have participated in a tender or a lease if he was claiming hereditary rights. More so, my lords, my learned friend very categorically, strangely reads the affidavit as if it's behalf of 2. Hema is the granddaughter of Adi Narayanappa. He had 2 sons and 1 daughter. 2 sons, every time they claim hereditary rights, rejected, finalized, confirmed.
But how
equal.
the daughter can have a hereditary?
That for the first time, my lords, the Hema is the daughter's daughter. Adi Narayanappa had one, my lords, he had two sons and one daughter. He himself never claimed hereditary rights. Two sons, elder son once claimed, rejected. Second son claimed, rejected. Both of them accept. Commissioner passes.
I have produced the order, my lords.
That is what my learned friend has produced. That's all way back in
respo-
23.
In response to the affidavit which my learned petitioners have filed.
No, just know what you have passed on.
No, I think they had filed it earlier.
Six, my lords. My lords may kindly permit me to give the six car. On 6th of June, I filed it, my lords.
And Rangaraju, nobody knows how he is related. And there is no whisper in the affidavit.
Not in the petition.
Nor in the petition.
6.
Let's just pass this across, my lords.
Yes, it is there. 666.
Yes, my lords. At page number 10, my lords. Page number 10, annexure R3. This would be the first son.
Veerbhadra Prasad.
One Veerbhadra Prasad, my lords. Approaches and seeks rights, which is negated. He challenges it by way of a writ petition.
This proceeding stated 6/11/2020.
Yes, please. 5/1/2023, my lord. I'm sorry, 6/11 is right, my lord. Subsequent to that, my lords.
Some page numbers are given, 337. I think this is page number 8.
Yes, my lords.
To mark
Page
it
number
as
10.
R1.
R1.
R1, my lords. Yes, my lords.
6/11.
Subsequent to that, at page number 10, my lords.
Belongs to whom?
Lords, the first son of Adi Narayanappa, that is Veerbhadra Prasad.
He has two sons. One is Veerbhadra Prasad and one Shankar. This is challenged before the commissioner in revision petition. That's on 5/1/2023. Once again, it's negated. Page number 10 onwards, my lords, annexure R3. And the same is challenged before this honorable court in writ petition 5230 by the very same Veerbhadra Prasad, which again is rejected, my lords. The second son would again make his own claim at page 22. That also is negated. He wouldn't take it up in challenge, but would leave
So
it at
what is
this.
this writ petition in between?
Lords, that is by the first son.
First son, my lord.
Question the order of the commissioner.
Yes.
That also attained finality.
That also attained finality. Specific contention was taken that their hereditary archaks,
And the
Not
petitioner
archaks.
sorry,
approached-
paricharaks.
Paricharaks. They are not archaks.
The court is directed to adjudicate the matter based strictly on the civil court has jurisdiction to decide all this.
My lord, it doesn't have jurisdiction.
Lords, either they go to civil court or they go to a Dharmika Parishad. And that is Paricharak, not even Archak. Lords, Archak is different, Paricharak is different. Now, Lords, if all these issues were there, when they participated in the lease in 2018, when they came before this court, they should have agitated their right, saying that I have a hereditary right. They keep quiet.
There is no endowment tribunal in the state.
Lords, there is it's a Raja Dharmika Parishad.
No, Dharmika Parishad.
No
is a
endowment
different-
tribunal.
No.
Deals about the rituals and other religious.
Lords,
functions.
including hereditary rights.
Lord, that.
Now they, under the 1996 Act, my lords, earlier it used to be suits because we had different acts for different areas, old Madras area, old Bombay area, old Mysore area we had. Then which was governed under Madras Act and the Bombay Act.
No, under the Endowment Act. of Andhra.
There's no tribunal as such.
We don't, the bar of the civil court jurisdiction is completely barred.
Barred.
Yes, my lord,
It's
yes.
only the tribunal.
Tribunal.
From tribunal, it will come to the High Court.
High Court.
High Court has
Now,
an
my lords,
appeal,
it is
as an-
what we call it as Raja Dharmika Parishad.
That is also there. That is with regard to whether a particular ritual or other religious issues.
And this-
But when it comes to their rights,
Hereditary-
they have a right
that
of
also will be
hereditary
agitated.
That's also under that.
will be decided by the tribunal in
But
general.
we don't have a
We-
tribunal as such.
What Parishad is,
One more thing now with regard to this leasing out the leasehold rights and all. Just like that, how can there be for 10 years, 12 years, how can, there are no rules?
now it has to be, my lords, Supreme Court.
Rules?
Earlier it was not there. Now under the, my lords, a board has, the management board has come into existence. Act prescribes it has to be only by e-auction. And the Supreme Court says any government largesse, you have to give it by e-auction. Today what's happening is this Rangaraju sits there. The temple is making about 1 lakh only from Prasad per day. He wants to dominate that area. He'll let him go out. My lord, my learned friend says, I don't want.
The control of the government.
That's the government's
Lord,
thing.
two other proceedings have produced.
I am
along
also
with
part of the government.
Government, all these charitable institutions are under the control of the government, and
Yes,
particularly this being what you call
A
Group
grade.
A grade Mujahid temple.
Notified
It is
institution.
under the notified institution as A.
Please.
So it will be under the.
Endowments department.
No, under the commissioner,
Yes, please.
under the commissioner.
Please.
So the commission has to look into these affairs. How come the revenue of the temple just like can be given to people like
The
this?
impugned order is that only, my lords. The impugned order is passed by the commissioner.
From when this is happening?
I understand, my lords, what my lords are, I'm coming from my lords. They have allowed this to happen for a long time.
Decades.
Yes.
Lord, I have produced two documents, my lord, where, my lord, the very same commissioner, my lord, without calling for a tender, Kukke Subramanya temple extends it for 5 years. One more temple gives it for 30 years. That is what I have filed along with my amendment application.
Lord.
Please take the amendment application.
So even-
Negative discrimination, I am sorry.
It's high time that government should have
Yes, my lords.
should have rules for this.
True, my lord. That's the
all
reason.
the
Negative
temples.
discrimination.
Yes, my lords. Now at least we have passed this order. Subsequent to that, my lords,
Not
the
only this temple, for all the temples which are under the administrative control of
In
the
fact, my
government.
lord,
Commissioner.
in fact, my lord, whether they can do it is, my lord, seized by, my lord, Sabrimala case, where, my lord, the practices inside a temple, who can enter, who cannot enter, what is the right of, are all seized by the 9 judges, my lord, bench.
Let's not get
That has
into
nothing
that.
to do-
I am
He
not-
is
to do with
nobody.
this.
No, in day-to-day.
He has no right to even make some submissions like that.
Administration, when it is under the administrative control
No,
of
my
the
lord, what I'm
government,
trying
that
to
they
say
have to do. It is not about you now.
Not about me, my lord.
No, no.
Whether government
No,
can, my lord.
please listen to the
Yes,
court. We are talking about the leasehold rights. Selling.
That's all.
Adam, you are saying all the while as a leasehold right. Leasehold rights, because the.
My lord, it is not leasehold rights. I will show, my lord.
That is
the
what
word.
earlier you said.
That is the word, my lord, which is used in the order. Let me
That
show.
is, no, if that is, you have participated in the auction, should be for a period of definite.
No, my
period
lord,
of
it is
3
not an
years.
auction. It is not an auction. My lord, I will show it is not an auction.
But now this hereditary issue and all, now the court cannot consider for the reason you are the granddaughter of so and so.
Yes, my lord.
Even under the acts also, who is entitled for hereditary achikatvam, prima facie, when he has 2 sons and 2 sons were unsuccessful before the courts. Now at this stage, you have to go before the appropriate forum for adjudication of that dispute. Whether you are entitled, you are not entitled. And none of these proceedings are passed by the commissioner. Ultimately, because you are under the control of the commissioner, this particular temple, unless the commissioner passes
Lord,
an
now-
order, we cannot take it as it is recognized by the government.
Lord,
And that
now-
too, in none of these proceedings, you are not there. Your grandfather was there.
No, my lord, my
Earlier.
2018, my lord, directly my name is
18
there.
was in the lease.
2018, my lord.
5 years.
We will go
Exactly.
by, we'll go by, let us not take into their documents at all.
Yes,
Let
ma'am.
us go by the order of this court, where the court, Justice Nagprasana's order.
Yes, ma'am.
That refers to the lease, nothing else.
My lord, yes, my lord. The word used in the order is a lease, but
We are only concerned with it. Now, we will not go into all these disputed questions of.
not disputed question, my lord.
But
The
wherever
word
is the
used during
forum,
the course of
parties
the
have to
order
go.
is lease. My lord, let them show one lease document, my
should,
lord,
I
which they have
should.
executed, my lord, in my favor.
If not, we will tell them to conduct the affairs in a fair manner.
That's all.
My lord, that is
It
true.
is a temple, and why they are not, why should somebody be
My lord, that
benefited
is
like
why,
this?
my lord, let my plea of, my lord, being hereditary rights come on record. I filed an amendment
no.
application
Not
that
in
can
the
be
first
allowed.
time.
Then I am at my lord's hands. Then 2 other aspects is, my lord, please have a look at the amendment application filed on 30th June of 2025. For Kukke Subramanya temple, my lord, they extended by 5 years to the existing person. My lord, for another temple, they extended by 30 years to the existing person. And my lord, for there is no
By
unit.
doing that, wrong will not become a right.
Wrong will not become a right, my lord. I am not saying that they must perpetuate. They must bring in a policy. And my lord, what are they trying to do here, my lord? Now for this temple,
That the court will tell them what to do.
Yeah,
But
very
what-
well.
how are you going to benefit or benefited by this?
my lord, now what has happened is, my lord, the latest position is, my lord, please have a look at the memo which.
No, as per the new act, whatever.
New
that
act,
came
my
into
lord, please
force,
have a look at
That's all.
section
As per
19.
that, 1 minute.
Yes.
As per that, what is the procedure?
Yes, my lord. That is what I am.
Going to leasehold the rights.
Section 19, my lord. That is what I am pointing out. Section 19.
Is
Please,
that?
my lord, please have a look at page 28.
That
Of
is
what,
what
yes,
is
my lord, what
passed
they
on
have
now.
filed. They have brought the new act, which is what I was trying to submit. And therefore, my lord, the reliance which my learned friend is
Let's
placing
see
on the,
that. Where is that
my lord, page 28,
section?
section 19, my lord. 19.
From when it is coming to? It's
My lord,
coming
1st of July 2025, my lord.
1st of July.
2025. Or 24, I think, my lord. 25.
What is quality? Yes.
But please see, notwithstanding anything contained in any custom, usage or provisions of any law for the time being
Are you
in
reading?
but
Page
section 19, my lord, page 28,
20. Yes.
19. Notwithstanding anything contained in any custom, usage or the provisions of any law for the time being in force under which the Sri Ghati Subramanya temple is governed, the provisions of the Hindu Religious and Charitable Endowments Act, the ownership, administration and complete management of movable, immovable properties including jewelry, liabilities of the temple shall vest in the state government after the commencement of this act and shall be transferred to the other authority thereafter, which is what I'm saying, my lord. Management, ownership, administration, everything vests with this committee. So therefore, whatever the commissioner has done, my lord, now ceases in view of this new act. Now it is the board, my lord, which has to take a new action. And they claim because of this, my lord, that the order is passed, which I just now pointed out at page number 53, where the board now says, I am prohibiting all private persons from making or offering prasadas. That the board has passed. Now the act is in force. The latest order now says that this is the prohibition which the board wants to bring it, which is why I said there is already a
According to you, your writ has become infructuous.
Infructuous, that's all.
writ has become infructuous.
So we will leave it open, we'll discuss.
Yes,
the
that's all.
jurisdiction.
All this let him raise in the.
No, my lord, it has not become infructuous for this reason. My lord, annexure H, if my lord.
Now, just now you have submitted that whatever the commissioner, she ceases to be the authority.
Yes, my lord. If my lords are holding that whatever commissioner has done now ceases to operate, then my all questions may be left open to be decided in this. I have no difficulty.
Modern, nothing, everything will be open.
My lord, everything will be open. Then, my lord, they will say the order is operating. Which is why I'm saying, my lord, I'm only requesting is, please take up both the matters together and decide it once and for all. My lord, that would be
The
the
interim
proper
order
way.
in this is vacated and taken up. I have no objections.
No, how can
But
that
my
be, my
learned friend cannot say,
During
I will
the-
continue to run the business. I'll keep filing. I'll take new pleas. I'll suppress all these things. He was aware that his
during the
uncle's plea was rejected.
Who is the authority under this, under section 9?
Lords, it's the commissioner himself, my lords.
No,
The
my lord.
board.
No, it's a board, my
Lords,
lord, headed
please
by the
see.
minister.
Lords, also page 20, section 20, there is a plan, development plan at
Please
page
see
28.
Section 3, my lord, Constitution of the Authority, section
Lords,
3.
Pages 28.
3, yes, my lord. My lords will get that page number 21.
There's an
Section
authority.
3. The authority shall have the following members. My lord, there are all these members. And my lord, these are the members, my lord, who have now passed the latest order.
Then the minister in charge of the district.
Member of the parliament, not more than 5 members nominated by the government, chief engineer, secretary to the government, commissioner Hindu religious, deputy commissioner, chief executive officer, chief priest, and other person who is nominated. My lord, this constitutes the board, which is why, my lord, I am submitting. Please take up both the matters. It can be taken up tomorrow itself. My lord, there has to be, my lord, one cannot be, my lord, disposed of and the other kept pending. All that I am request is, please take up both. And my lord, we are at my lord's hands. Whatever my lord decides, my lord, we will follow it. But my lord, let there be a complete adjudication is my request, my lord. Now they say this is the board. This board has taken a certain decision. Lord, please consider everything together.
Lords, with great respect, we are not saying this is the board. It's an act which has come into existence. He can't
I'm
claim
not saying this is
ignorance
a-
of an act. It's an act.
No, my
It's
lord.
an act.
What is that? What is the relief you sought in that?
We do not even know when they have filed it.
I have challenged
My
the-
friend keeps filing but wants the interim order in this. Somebody runs
My lord,
without paying any dues. Somebody runs contrary to the.
18/5
And
2026.
23 it gets over, he makes an amendment to say that because of COVID-19, I could not do it for 2 years. So kindly permit me to do it for 2 years from 23. That also expired in 25. Now he has come out with this plea of hereditary only after the expiry of the 25 also.
Lord,
2025, the 2 years extension which he sought for in the guise of the period lost out during the COVID was also expired. And only then he would come up before this honorable court to say that I have a hereditary right.
And
18/5
hereditary of a,
2026.
Lords, Paricharak is something else. I do not know how we are getting into this hereditary business. He should have contested this in the earlier writ. It's constructive res judicator. Somebody can't keep. Then, my lords, where is the defense for us? Tomorrow somebody else will come. This Rangaraju,
Lord,
nobody
they
knows
have-
what hereditary.
They have
right.
collected
He is
fees up
simply
to
saying,
2027, my lord. They have said deposit 30 lakhs. I have deposited 30 lakhs till
We'll
2027.
refund whatever is
27.
we'll refund it.
So there, no, it's not a question
it's
of
a-
refund. No, my lord, there is.
Deposit also wouldn't come.
Now there is a subsequent order 18/5/2026 passed during the pendency of this writ petition when my lords are seized of this
That
matter.
is not even an
They
order.
precipitate this matter and then now they say all private persons are prohibited from making prasadam.
It's a resolution.
Lord, my respectful submission is please take this matter also up along with this matter and my lord decide both the matters once and for all.
My only request is this, my lords, that the interim order which is granted on the basis of which they have been running as of today should have been expired in 2025 when they said 2 years extension. That this honorable court.
Why don't, in the first list itself, we'll take up that writ petition also, and on the same day I'll pass orders. I think that would be a courteous to
Lords, we
your,
do not even know what he has challenged in that, whether the validity of the act is challenged.
Have you questioned the validity of?
No, I have not challenged the
That,
validity.
that is not even, what is it?
I have
It does not
challenged,
even
my
say.
lord, this resolution of 18/5/2026, which is passed, my lord, about a month back, where it says all private persons should not, my lord, be offering any prasada or selling prasada. That is the
You are questioning the provisions of the act.
It has nothing to do with that,
resolution,
my
my lord,
lords.
resolution. They have
Resolution, my
produced
lords,
the
it's not
resolution.
even communicated to them.
Well, they filed it in court.
So it is it? My lords,
They
can
filed
a
it in
resolution?
court. My lord, please see,
Right.
they have
It's
produced
like
it.
file notings being challenged.
Sorry, my
That
lord.
18th for resolution is not pursuant to the provisions of the act.
Yes, my lord.
Then
Pers-
without questioning the
My
provisions.
lord, I don't
of
want to
it,
question the provisions of the act, my lord. I am
Then
only.
as long as it is there, then what's wrong in
My
doing?
lord, the resolution which is passed by the board. I am only questioning, my lord, not the constitution of the board.
Lords, with great
I am-
respect,
The constitution of the board.
we will take an order.
There are certain provisions as per the new act.
Yes, my lord.
In consonance with the same, they have passed this
My
resolution.
lord, whether it is passed in consonance is what my lords have to see. That is what my lords have to see.
To the number.
Yes, my lord, the number is
Lords, I will, with great respect, I will.
17
No, it is senior counsel in the interest of the. temple,
17811.
Once for all, only one, another petition is pending. If it is disposed of, so that the administration can be run smoothly. Yes, the list is matter along with so-and-so on, day after tomorrow in the first list, after obtaining the necessary orders from the Honorable Chief Justice.
Great.
Lords, in the meanwhile, they can give us a copy,
And
advance
I'll-
copy
I'll
right
give,
now.
I'll serve.
In advance,
Yes,
in
sir.
advance, the
Well, state is
petitioner
already served.
shall serve the copy
State
of
is
the
already
same
served. I'll
on
serve
the
one.
temple as well as the learned AG appearing in this matter on behalf of the
Lord, the
Government, yes.
interim order may be extended. May I request for Thursday, my lord, instead of Wednesday, Thursday? My lord, my cousins,
Thursday.
yes,
Yes, Thursday,
Please.
in the first list.
interim order may be extended. Yes, grateful.
Is called that Passover matters any leftover.
Pass. Passed over cases, list number 1, serial number 8. Yes, Prasanna Kumar.
Yes.
Serial number 8, my lord. I'll undertake to file wakalat for respondent number 5, my lord.
In which case?
Yes, my lord. I'll,
In this case,
please, my lord.
for
Serial
respondent
8,
number?
5.
For BBP. Umesh.
Is already served, Jafar.
Please.
Land counsel.
Allah Bakash M.
Huh?
Allah Bakash M. Please, my lord.
Counsel so-and-so submits his instructions to file. Wakalat on behalf of respondent number 8.
5.
5.
Respondent number 5.
Respondent number 5. Umesh A. Hmm.
Can I,
Yes.
may kindly be permitted to take your lordship through the impugned order?
Not impugned order. We have stopped while you are referring to the rules. You are referring to the rules and you
Yes,
are
yes, correct.
searching for the rules. That's why. I
Only
adjourned the
my
matter.
humble submission is the cause of action for the passing that order, it is very well stated in the order itself. I
That I
totally
have
depend.
seen. That's why after seeing that only I've asked you a question.
No problem. If you are-
Yes. You wanted to point out something from the
Yes,
order that
yes,
it is,
yes.
the order passed by the
Yes,
court is correct.
I'll take your.
Yes.
It could. Kindly take
The act, what my learned friend
You appear in
says,
this?
Yes, please.
For which respondent?
Respondent 9, EBM.
I think he's the only affected party in this.
Yes, please.
they are the nominal parties. I am the affected party.
Yes.
The kindly see in the rule 4, facilities recommended for video conferencing. That is, I depend on that. Point number 1, desktop, laptop,
Where is that?
Mo-
Rule number 11.
rule number 4,
4.
serial number 1.
Yes.
Desktop, laptop, mobile devices with internet connectivity and printer. So whatever we use, these are all permitted to be used in a video conference recording. The law itself permits. Then come to section rule number 8, examination of persons.
Yes.
Any person being examined, including witness, shall before being examined through video conferencing produce and file proof of identity by submitting an identity document issued or duly recognized by the government of India, state government, union territory, or in the absence of such a document, an affidavit attested by any of the authorities referred to in section 139 of CPC or 297 of CRPC, as the case may be. The affidavit will inter alia state that the person who is shown to be party to the proceedings or as a witness is the same person who is to depose at the virtual hearing. A copy of the proof of the identity or affidavit, as the case may be, will be made available to the opposite party. These rules will apply as per to the persons stated under section 5.
So according to you in civil proceedings, wherever.
For me, it doesn't apply.
No, that's what for you, as far
Yes.
as your case is concerned, wherever you are, by using that, whatever has been stated in, say, that rule 4.
Yes.
You can have a.
I can answer the questions asked to me by way of video conferencing.
So anybody can tutor you, that also is not a problem.
No, it's not a problem.
So anybody can tutor the witness, that's what you're submitting.
No, it is up to them because he will be in the house. The tutoring question doesn't arise. He will be in the foreign. Within India, it doesn't apply. It applies to outside India, as far as my knowledge goes. So he may be in the office, he may be in the embassy, or he may be in his own house, wherever it is convenient to him. The law permits.
Yes.
I will take your lordship to that only.
Or remaining not necessary. Yes, anything.
Now, the two questions. First, your
ಅಲ್ಲ
lordship.
ಇನ್ನೊಂದು ಸ್ವಲ್ಪ just one ನಿಮಿಷ.
ನನಗೆ ಕೋರ್ಟ್ ಕೇಳ್ತೋದ್ರಲ್ಲ.
ಅಲ್ಲ ಆಯ್ತು, just 1 minute. The law itself provides section 815, your lordship, I can see.
Yes.
Where a required person is not capable of reaching the court point or remote point due to sickness or physical infirmity, or presence of required person cannot be secured without undue delay or expense, the court may authorize the conduct of video conferencing from the place at which such person is located. In such circumstances, the court may direct the use of portable video conferencing system. Authority in this behalf may be given to the concerned coordinator and or any person deemed fit by the court, subject to such orders as the court may pass. In any case, any party or person authorized by the party is desirous of being physically present at remote point at the time of recording of the testimony. Such a party shall make its own arrangement for appearance or representation at the remote point. Next, only one single thing is on completion of video conferencing. This is 10(9).
Yes.
10(9). Completion of video conferencing, if a remote user is of opinion that they were prejudiced due to poor video and or audio quality, The remote user shall immediately inform the coordinator at the court point, who shall in turn communicate this information to the court without any delay. The court shall consider the grievance, and if it finds substance in the grievance, may declare the hearing to be incomplete, and parties may be asked to reconnect or make physical appearance in the court. Then the next thing is the coordinator at the 12:2. The coordinator at the court point shall ensure that video conferencing is conducted only through a designated video conferencing software. However, in the event of technical glitch during the given proceeding, the concerned court may, for reasons to be recorded, permit the use of software other than the.
So not at all relevant. He's only on 2 points.
Yes.
You don't have to read the entire rule.
Yes, yes, yes.
Yes,
The 2 points that I have raised.
you have already raised anything in addition
Now,
to
the
that.
question before I could proceed,
Yes.
the court asked me a question, how are you prejudiced?
Yes,
The court asked me, how are you prejudiced? It is not the prejudice that counts, whether it is legal or illegal.
yes.
A prejudice it cannot devour the illegality. Suppose a witness is examined without administering the oath. And the court cannot, later he cannot come and say that it was not, technically irregularly was not administered oath. So no prejudice is going to be, because it will be taken as a witness, evidence. It can't be taken as evidence. Now your lordship may kindly return to 8-9. Rule 8-9.
Yes.
An audio-visual recording of the examination of a person examined shall be preserved. An encrypted master copy of its hash value will be retained as a part of the record.
He says it is there.
Now the question is, it is not recorded videograph. Suppose
You're saying so. That's what his submission is. Is it factually correct or not? You are saying that is recorded in the morning.
it's not recorded. It's not recorded. Please kindly see the order sheet. The video.
It is ordered and governed made by the court itself, not me.
Now, can make a call upon the
Not
trial
me.
court to produce that record.
Definitely, you are at liberty, certainly. It is done by the honorable court,
Yes, heard, reserved.
not by me.
Yes, yes. Next.
And
No,
Four-
it's
14
enough, it's enough. I heard it. No more arguments are required. Yes.
obliged.
What? Huh? Oh. No, not necessarily you call. Yes, 44.
Number 44.
No, I'm not going to hear this matter. I'm going to adjourn it. When do you want the date?
The covered by the ordinance.
What is
For
that?
only permanent power connection.
Huh?
Similar matter. The honorable court.
In a number of
Granted.
matters, my lord, this honorable court has
Covered
passed.
by the order.
Yes.
No, my lord, it is not covered by the decision. As it is a temporary connection, let it continue, or permanent it is, let them
No,
continue,
permanent
not to
for-
disconnect. That is the only, the thing.
That's what, that is,
in
same
Stand.
order he is seeking.
No, my
The
lord, we are
permanent power
seeking the
connection.
permanent connection.
Permanent power connection. The covered by the
Yes,
order.
Take that.
Okay.
Have you given her a copy?
Good.
Which order you are relying on?
And one, the first petition, I'm not pressing, already they grant the power connection. Based on the legal opinion given by the advisor of the Piscom.
Give her a copy. At least she should be aware
Please.
of what you are relying on.
In so many matters, I only appeared before this honorable court, my lord. Wherever the temporary connection is there,
I'm
let
pressing
them
now,
continue.
connected matter only one. The first petitioner, they granted the permanent power connection.
What
The
it says
the
is-
adjacent site owners,
Minute.
please.
Taking note of the submission that application for sanction of permanent power supply has been submitted by the petitioners. The second respondent is directed to consider the application submitted. In case the permanent power connection is sanctioned, the same would be subject to the result of WP
Yes.
number.
Yes, yes, the one
Even I am
petition is
also
pending.
making the same submission, my lord. Temporary connection is there, my lord, already. That can be continued, my lord, subject to result of the.
They make my submission, my lords. My lords, we have issued an order for demolition, my lords,
Yes,
for
my lord.
BBMP. We have issued an order for demolition, my lords. We will not be in a position to undertake the demolition, my lords, unless the power is disconnected, my lords. Or else there would be a catastrophe, my lords. That is the reason we have
Yes.
written to Bescom, asking them to disconnect, my lords. Asking them to disconnect the power connection that has been given. Because in violation of the plan sanction, my lords, without leaving any setback, and in violation of the floor area that has been sanctioned, they have illegally
No,
built
how
the
come
construction.
that can interfere with your demolition process?
Not because there would be a power connection, my lords, we will not be able to
No,
carry out the
No, what is this?
demolition order.
My lord, this is
What is
the,
writ
this is the
petition?
matter, my lord. The entire layout is unauthorized layout, my lord.
Unauthorized
In the
layout.
revenue
Revenue
sites,
layout.
they have constructed, they formed the layout and they constructed the houses. They have given,
On agricultural property.
based on the writ petition, they have taken the temporary connections and some of the permanent connections, my lord.
As such, my lords,
Have
It is
you-
agriculture land, my lord.
File your objections in that.
I'll file it, my lord. In number of matters, this honorable.
That's a whole
Actually-
difficulty. No, if you don't file your
Annexure
objections.
N1,
Please wait.
that
Just
procedure
like
was
that one
stayed.
after the other, the orders are
Yes, ma'am.
passed.
I'll file my objections.
I shall also.
Please file your objections.
Please.
Such obliged.
No, there are
This
subject to
is-
condition of the writ petition.
No, this, no result. We should know what it is. The list is matters in the month of August. By the time the respondent shall file their objections, is 45.
I'm appearing for the respondent.
45?
In this case, I want a week's time to file the objections, my
For the
lord.
petitioner.
That's what, please make it a point to file the
Yes, madam.
objections.
I'll do it, madam.
This is
Almost
matter,
it's ready. I sent for the approval. That's it.
this is matter on 15th of July. for
Interim order
filing
may
objec-
kindly be
huh?
extended. Interim order may kindly be extended.
For filing objections, interim order earlier granted is extended. Is 46?
Appear for respondent in this case. Kindly have it tomorrow, my lord. Senior is out of station today.
What is the urgency? If not tomorrow, some other day?
Anytime, my lord.
This is matter on 29th of June. Is 47?
Interim order may be extended, my lord.
47? Which matter?
46.
46 interim
Obliged.
order. Then list it in the month of August. Interim order earlier granted is extended. 47?
I appear for the respondents, my lord.
Pradeep Kumar?
Writ of mandamus.
You that?
You have deposited amount for electricity connection.
So you appear?
Please, my lords. My lords, in fact, on 21st January 26, we have informed them that as soon as they provide us the occupancy certificate for the building, we will supply the electricity, your lord. If I may pass on it's in Kannada.
To issue mandamus to supply electricity so and so. In portion to the power sanction order dated so and so.
My lords, let them provide their occupancy certificate after having completed the building, your lordship.
This power sanction order. Dated 7/2/2025.
Please, my lords. It's at, the typed copies at page 29, your lordship. They have sought LT power supply for new
Already
collection.
sanctioned.
My lords, this was the temporary supply, your lordship. While they were constructing the building.
Yes.
My lord, as per their demand, we have deposited the amount.
Not only demand, they say that you have to give a copy of that occupancy certificate, then only they will give. I'll record that. You produce the occupancy certificate, on that they'll consider, they'll pass orders.
Kindly have it day after tomorrow.
This is
Lords, in serial number 47, name of Mr. Baby Patil may be deleted, my lords.
delete the name of Mr. B.B. Patil. This is matter on 19. Is 48.
48, Joseph Anthony.
For?
This is matter on 21st of July. Yes, next.
49,
I'm
Dimas.
Appearing for the respondent in this case, my lord.
Yes, any
As
interim
per the
order?
instructions of the BBMP, we have issued the notice, my lord. There is a violation of the sanction plan, my lord. The BBMP is taking the course of the action as per the Supreme Court judgment, Rajendra Babu, my lord. In there, it is violation of the sanction plan. They are issuing the notice. They have instructed for us to disconnect the power supply, my lord. Based on their instructions, we have issued the notice, my lord. The BBMP is to answer.
There's an interim order. Interim order earlier granted is extended. This is matter on 22nd of July.
Much obliged.
Yes, 50.
My lord, in serial number 50, notes directed on Thursday, my lord, to serve a copy, I have served on them.
What are
Copy
you
received for respondent number 1 to 6, I appear.
Yes.
Lords, they are seeking the shifting of power lines. That is not high tension power line, my lords. Those are service lines for the agricultural pump sets. And it has been placed exactly in the boundary of the agricultural lands, my lords. I'll place my objections on.
No, what is the relief they are seeking? Please come to the communication dated 2/5/2026 issued by respondent. What is this communication?
Lord, without obtaining my consent and without any acquisition proceedings, my lord, high tension electricity lines and electric,
There won't be any accusation for that.
I'll have make.
That is not a high tension line.
It's a high tension,
Service
my lord,
line.
23 kilowatt. My lord, on 3 different incidents, 3 accidents take place, my lord. On the first incident, 3/4/2025, I give them a representation as to conduct an investigation and inquire as to what is the reason for this incident. My lord, they give me a reasoning that it has been conducted due to some miscreants putting fire on the property. Next, my lord, in the year 2026, another accident takes place and my
2/5/2026 is what is the letter this?
Endorsement.
endorsement, my lord, on the similar, my lord, same representation which I give, my lord, for the third accident which occurs. And my lord, crops were 20 lakhs which was demolished, damaged, my lord. On the same representation without conducting any inquiry, my lord, they give a statement stating that, my lord, this is not conducted because of our fault or our electricity lines. It is because of some miscreants coming there.
We'll ask for their response on this.
Inquiry, my lord, please.
May kindly see, my lords, J1 and 2, the photographs that are produced. There are no electric lines. The fire has taken.
The so and so, your name is printed. HV Devraj, your
No, Ms. Likith R. Prakash.
so and so submits his instructions to
Respondent 1 to 6.
appear on behalf of respondent
1 to 6.
1 to 6. And who is the answering respondent? You are the answering respondent.
Yes.
And
All respondents.
he submits that he'll file his objections. This is matter on 8th of July.
But may I request for a shorter date, my lord, because there are 3 incidents, different incidents. And all the 3 times, my lord, there's damage to life
It
and
can't
liberty.
be shorter than 8th.
My lords, I
Yes,
need
the-
some time to get secured records also.
My lord, because there's a police complaint which I filed, I'm not presently, a FIR came to be lodged against the BO.
In the meantime, look into that. What
Please.
is that you're supposed to do? Mr.
My lord,
Counsel.
electricity line is in my agricultural
That
property.
What is to be done from your department?
I'll surely see.
In fact, my lord, there's an FIR which is lodged against the authorities, BESCOM authorities, for the accidental fire which caused, my lord. FIR is also there in the writ petition. My lords may give it.
Before you file your objection, some get specific written instructions.
Please.
We'll see on that. If any interim order we can grant, we'll grant.
Please.
on that. This is a matter on 29th. The land counsel, the respondent shall get specific instructions. Yes.
Please, grateful.
51.
And for the petitioner in this case,
Here,
Lord,
matter appear for respondents, my lord.
in spite of undertaken approval by the
My lord, they are stating that only one house they are constructing. They have already constructed 3 houses. 3 buildings are there belonging to the plaintiffs.
I'll take up
Defendants.
this tomorrow in the first list.
At the
Yes.
top of the list.
Lordship,
Top of the list tomorrow. Yes.
52 urgent, 53. Kalpana PV. Kalpana.
Let it be in the list. Let it be this matter, say, under the same caption, list on 21st of July. Yes.
List number 2. Serial number 1. Shreyas Jayasimha.
So I appear for the respondent.
Is there any interim order? What about the memo? Has not taken hand summons by order dated 1/6/2026.
Milords, we have already served a copy, Milords, on the.
But I've been
You
served.
appear for the.
Yes, yes, I filed my wakalat this
Learned
morning.
counsel so and so submits that. He has instructions to appear on behalf of the
I
respondent.
filed my wakalat this morning, ma'am.
It is submitted that he has filed wakalat on behalf of the respondents. Registry is directed to print his name. Last time till what the dates have been given. This is matter on 13th of July. Yes, number 2.
Shorter date if may be possible, Milords. A shorter date if your lordships. could
Because every
accommodate.
day there are about already 40 matters are already given in the first list. Even if I give, it won't reach. That's why I'm looking for a date where your matter will reach.
That's because in the trial court, my lords, the matter is listed day after tomorrow for final arguments. That's the
will
only
have to-
request. If a shorter date.
While
is
that
having
is
to
the
be
case,
accommodated.
it had been posted for final arguments contrary to the trial court's own schedule. It would have to be set right. I will go make the submissions
Day
before the
after
trial court.
tomorrow. Yes, 2
Serial number 2,
for steps.
KV Narasimhan.
R3 to R5 may be dispensed with.
Give the memo.
I'll submit a
Memo
memo.
is filed seeking dispensation of notice to R3 to R5.
R5,
Yes, R1 and R2 are served.
please, ma'am.
We'll hear it later.
Please, ma'am. Lord, interim
This
order
is-
may be extended.
This is matter on 3rd of August. Interim order earlier granted is extended. Yes, 3.
Serial number 3,
For the petitioner, in this matter,
with total.
respond number 2 to 11 are the petitioners in serial number 5.
Hmm.
So for that, already office objections were raised regarding the service of the notice. So that may be overruled, Your Lordship. And also a memo has been moved to dispense the service of notice to.
We'll see it's on some
Yes.
other day. This
A
is a
shorter
matter on
date may be.
14th of July. This 3 and 5.
Okay, file,
Together.
some urgency is there.
Yes.
But we already served the contesting party to the plaintiff, and we are in a position, we are doing the construction. Plaintiff 1S3 is troubling us. When we had got a permission from this honorable court for the construction, he is troubling us. For that reason, some urgency
The
is there.
difficulty is how many matters the court can hear in a day.
I'll leave it on this honorable, any convenient date, first convenient date.
That is why I'm just because taking the matters and know.
I understand, Lordship, because our
all
meetings
these
is
matters
morning.
are-
I also understand this, Lordship, for any first available date, Lordship. For that reason, I'm requesting.
Lordship,
This is a matter
serial number
on
3 and 5 are connected, Your Lordship. Same-
8th of July.
Even serial number 3 may be listed on the same date. It's
Huh?
connected matter.
Yes, 3 and 5 on the same day. Interim orders, you have an interim order?
No, there is no.
Yes.
We have, Lordship, is
Less than
directed to
IA.
consider it after the service.
Yes.
Suit is barred by limitation.
Yes, next.
Number 4,
4.
Shiv Prasad.
I take steps in respect of respondent number 28, my lord. In respect of respondent number 28, lord, I'll take steps. If no more, I'll file LR's application.
But for taking steps, this is matter after 4 weeks. Yes, next.
A date may be fixed, my lords. A date may be fixed. my lords.
28th of July. Yes, next.
5 and 10, 6, Raju, yes.
Counsel for petition. Steps in respect of R2, R3, R7 and R8 within 1 week time.
This is matter after 4 weeks.
Kindly permit to
Compliance
not
of-
press the IA number
Huh?
1 and 2 of 26.
Huh?
Not press IA number 1 and 2 of 26 and permit to file a fresh application. Bringing a last
You are not pressing I number.
1 and 2.
Then council submits that he is not pressing I number 1 and 2. Accordingly,
Excuse me.
dismissed as not pressed
Permit to file a fresh application regarding.
and is permitted to file a fresh application. This is matter after 4 weeks. Yes, 7.
That's all.
Submit your other, submit your other.
I may extend it. Interim order may.
Interim order earlier granted is extended. 7.
Signature.
Rajaram.
List number 55, Swami. List number 2, serial number 50.
Serial prakar kariti, wait.
7.
7, Raja Ramesh.
The petition shall play the process within 2 weeks. Yes.
8, Jagan Mohan.
Lord, copy served on the other side and acknowledgement also filed. That original application, whatever filed in counter, that was lost in this court's office. And they asked for to file another application, we filed. So copy already served, my lord.
Then council submits that already the papers are served on the council appearing for the respondent.
Lord, this application filed to recall the order on 3316. These are dismissed as infractions, but we not submitted like that.
Let's see.
Because of submission,
Let me look at. No, give the file.
3326.
There's a petition and on the miscellaneous is decided on. Miscellaneous is decided on merits on 1912. As the impugned order is on IA and in view of the final.
Suit is continuing. Only for the leave of the court, they filed the miscellaneous to prosecute that suit. Suit is continuing. We may be implicated in suit also, my lord. Because the implied application rejected by trial court. That is we are challenged here.
My lords, I appear for the respondent trust. It's a trust matter.
That
We
miscellaneous
sought-
filed to grant the leave to prosecute the case,
It's a section
to
92.
implement the trust.
You wanted to prosecute the suit, that itself is disposed of.
No, that suit is pending, still
What
pending.
is this miscellaneous?
Miscellaneous only to grant the leave to prosecute the suit. Because a trust property, as per orders of this honorable court in RFA, they have implemented a scheme. To implement that scheme, they have filed that suit. And also the miscellaneous petition to grant the leave. After taking the paper publication in that miscellaneous petition, we filed a implied application. That was rejected by trial court. That we challenged here with.
IA that is filed in a miscellaneous.
In miscellaneous.
That
Miscellaneous filed along with the OS suit. Not, it's independently is not filed.
What do you say?
My lords, I appear for the respondent trust. It's a section 92 CPC petition, your lordship. It is well settled that I have to seek the leave of the court before I file the section 92 petition. Accordingly, I filed the miscellaneous petition. In that, they have sought to implead themselves. In fact, they are retired or ex-employees. They have got nothing to do with the prayers that I am
That is on
seeking
merits.
regarding operation of
It's
the
on merits.
trust. Therefore, looking into all these aspects, I have to prove that there are two or more interested parties under section 92.
Look into it
Please.
some other day. Yes, this is matter on 20th of July. Yes, 9.
Number 9, Rita.
Notice to R1 and R2 returned as unclaimed.
Maybe-
Amounts to deemed service of notice. It's a fresh matter.
It's a fresh matter, it should be, that's
List is
order
marked.
under challenge is,
This is matter on 29th.
let's may I seek for a
First list, huh?
first list. Great.
Is 10.
Number 10. Submit this.
Appear for the petitioner, my lords.
Yes.
There's a stay in the matter that may be extended, my lords. Matter pertains to disconnection of electric line. They say that I'm allegedly unauthorizingly using electric lines, which is not so. So
This is the matter
date may
on 15th of July. Look at it, all the matters adjourned, interim order is there extend. Yes, 11.
oblige.
11. Lakshmi
For the petitioner, your lordship. On the last hearing date, we were directed to issue hand summons to the respondent. We have done that, your lordship, and we have also filed a memo within the registry of this honorable court. Yes, your lordship.
Is there in the file? This court has permitted the petitioner to give the hand summons on the counsel appearing to the respondent, and accordingly, a memo is filed before the court. And the memo is, where is that? Where is that memo?
It was filed within the to the registry on 28/4, your lordship.
The notice to is taken as, yes, it's a fresh matter.
Yes, lordships. Your lordships, in the meanwhile, there was an interim order granted on the last hearing date for stay of the trial court
The only
proceedings,
granted is extended.
and the process fee may be dispensed with. Your lordship.
And as the hand summons are already served, there is no necessity to pay the process. Is 12.
12.
Grateful, your lordship.
Ajit PB.
List after service of notice on the respondent.
Appearing for the respondent, your lordship.
You appear for the respondent.
Yes, we haven't received the wakalat yet, so.
So and so
Continue.
submits that, has instructions to file wakalat.
Number.
The registry is directed to print the name of so and so. List this matter on 15th of July. Yes. Yes, 14.
13 urgent. 14. Muhammad Muzasim.
List after service of notice on the respondent. Look at it, interim order is there extend.
15. SK Mithun.
For the petitioner. Lordship has directed me to give a fresh calculation memo on top, along with an affidavit. I'm filing the affidavit.
Milords, 3:45 they served me today. After a week's time been granted.
What's happened?
One small submission. For 100, Milords, for a crore, if 50 lakhs has been paid, the total cannot be 35 lakhs, Milords. And these kind of affidavits, if they keep on filing, Milords,
I will consider it on the merits of it, and if
Please, my lord.
if it is not,
If they are not-
worth considering, it will not
Please, my
consider.
lord.
Yes, list is
Kindly
matter.
have it on Thursday.
List is matter on 22nd June in the
My
first
lord,
list.
22nd, I'm not in, 23rd, my lord, 23rd.
23rd June in the first list. Yes,
please, Milords.
next. 16.
16.
My lord, I appear,
For the respondent, my lord.
I appear for the impleading applicant, my lord. I am the dealer of the petrol pump IOC, my lord. there was an eviction proceedings filed by the petitioner against the IOC. It was decreed. RA is pending before the first appellate court. When RA was pending, they avoided the notice of the.
Many matters are coming tomorrow.
My lord, I am for the petitioner. My only submission is that they are neither the party in any of the proceedings
You've taken it,
before the trial court.
not from this adjournment.
The regular date is already given on 25th. My lord, may I kindly. give
My
on-
per day loss is.
So you can't have an objection for a vacate stay. When you can have a stay, you can't oppose for it. Tomorrow? 44, 46.
Not tomorrow, day after tomorrow.
No,
my-
tomorrow,
My
my
lord,
lord.
day
Kindly,
after-
my lord, we have
day after
waited for,
tomorrow. Day after
waited for 22 days, my lord, now.
My- day
Per
after
day
tomorrow.
loss is 50,000 rupees.
I can demonstrate, I can demonstrate.
If you want, I can give a date, it will not reach.
Day after tomorrow.
I'm saying, Friday, there are less matters. I will take it up on Friday, 22nd.
My lord,
Please,
again,
my
my submission
Please,
is only this, my lord. Already 4 hearing dates have
Shall I
been.
give it? If you insist for that, I'll give. And I'm making it very sure it will not reach.
No,
I'll have to
Friday,
find my
let it come
objection.
on top of the list, my lord.
Not top, it will come in the first list. First list anyhow will complete.
But then your lordship may allow the impleading application, vacating.
Nothing I'll do now. 22nd, list this matter on Friday.
Please, my lord.
That's on, what is the date?
19.
On 19. Next.
17.
Well, so petitioner in this
Order
case, my lords,
granted is extended.
we seek for a short time, my lords. 17, my lords.
This is matter.
Interim order may be extended, my
This
lords.
month it's not possible. List this matter on 14th of July. Interim order is there.
Yes, my lords.
Earlier granted is extended.
18. M. Sudhakar Pai.
My lords, I appear for respondent number 1. We filed our objections and we filed an IA to vacate the stay as well, my lords. The matter is before the
20.
trial court on 29th June. 29th June. May I request for a date in June, my lords?
List this matter on. It's not possible on 22nd, 23rd. This is matter on 30th.
My lords, 28th at least, my lords. List on 29th, my lords. We'll take our chances.
If you're not understanding, I can't help it. Have it. Let it be in the list. I will not even call the list from tomorrow, 28th. I will
19.
stop where I am stopping. Yes, 19.
19.
For the petitioner, Your Honor, seek for short accommodation, Your
This is matter in the month of July. Yes,
Yes, sir.
20.
Interim order.
Interim order earlier granted is extended.
20.
I represent
Then why
petitioner.
did you move a memo if you have, other side must have moved it. 20.
20, my lord. There is a delay of 56 days in filing CRP. Notice was served, though it was served, no representation.
We'll see. This is matter on 20th of July.
Since I have filed a execution, my lord, suit for recovery of money. Earlier, they filed for check bounce case that was dismissed. After dismissal of check bounce case, the small class suit
That is
was
your problem, but you have to understand the court's problem
placed,
also.
my lord. Any dates this
Can't
month?
take up the matters that way. This is a matter on 20th. Yes, 21.
21. Akshay Kumar Gowda.
Petitioner, my lord.
Yes, 21.
They have filed the early hearing application on any one date being fixed.
This is matter on 27th of July. IA number 1025 is ordered. Yes.
22.
For the respondent number 1, please filing the stay vacating application, my lord. And petitioner got the stay interim order despite filing the caveat petition, my lord. It's urgent, my lord.
25.
This month.
Separate petition.
Yes,
This is a matter on 22nd July.
Uh.
Interim order earlier granted. Look at it in all the matters, extend interim orders wherever there are.
23. Yeah, Abhinav Ramanand.
For respondent in this case, ma'am. I was
This
thinking-
matter on 21st, interim order earlier granted is extended.
24.
For respondent in this case, my lords, commercial yes, Swami, interim order ತಗೊಂಡಿದ್ದಾರೆ.
25.
Yes, my lords.
No short. This is a matter on 22nd. Yes.
25.
For the
Yes,
petitioner.
sir, for the respondent, my lord.
Darshana.
Lord, kindly have it on 18th, my lord. There is a connected matter between the same parties. So I'm requesting your lordship.
It's along with, that matter is coming up on 18th.
18th, please, my
Because
lord.
it's not
It wa-
connected matter, my lord. That's
No,
a
between the
separate
same
petition.
parties, it was listed today, my lord.
Along with so and so on 18th. Yes.
Interim order may be,
Grateful.
Interim order earlier granted is extended. 26.
26.
appear for respondent, my lord. In this case, my lord, petitioner has not complied the interim order, my lord. This honorable court was pleased to grant interim order subject to payment deposit of 5 lakhs. My lord, he has not, petitioner has not deposited, only 2 lakh 50,000 is deposited.
This is matter day after tomorrow on the top of the list. Yes, 27.
Lord, in this matter, I beg to appear for the petitioner. The subsisting interim order. May I pray for extension of the interim order?
I appear for the respondent number 4, my lord. I filed the IA for vacating stay in short.
This is matter on 23rd of July. Interim order earlier granted is extended. 29, 28.
Anjaneya.
For the petitioner, my lord. Kindly wait
This
may be
also
given for
vacate
18.
petition is filed. List on 22nd. Interim order earlier granted is extended. 29.
29, 30.
For the petitioner, my lord, seeking for a short leave. Seeking for a short accommodation, my lord.
29. 29. List on 2nd of July. Yes. 31.
I beg to appear for Mr. N.G. Sridhar. N.G. Sridhar for the petitioner's counsel. N.G. Sridhar for the petitioner's counsel. I am appearing. The matter requires, my lordships, the kind consideration at the hands of this honorable court because the trial court has no jurisdiction at all so as to pass on this particular thing.
It's a
And,
fresh matter.
where shortest accommodation may be granted.
This matter. This is matter on 19th in this one.
19.7, my lord. 19.6. Great.
Next,
With great
32.
apology, my lord, with great apology, my lord, serial number 30, my lord. I appear for
Petition in this case,
From the
Interim
morning,
order-
somebody has made a mention.
Interim order may
And you
kindly
said
be
that
referred.
they have already informed to the other side, if I remember. Morning
No,
it is
my lord.
mentioned.
They have not informed me, my lord. I appear for petitioner and interim order to be extended. What is last occasion your lordship has extended the interim order, my lord.
No, it is posted to 2/7.
Please, my lord, the interim order earlier granted may kindly be extended.
Yes. Next, 32.
For the petitioner in this case, my lord. Interim order extended.
Kindly fix a date, my lord. We'll argue the matter.
Listed on 23rd of July. Interim order earlier granted is extended.
33, SP Bhatt.
Submission. Item is list number 2,
I
serial
will
number
call-
55.
I will call the matters. Please wait till till your turn comes. Yes,
33.
33. Interim order earlier granted is, if look at it, if it is there, extend, listed in the month of August. Yes, 34.
My lords, for the revision petitioner, my lords, covered by your ladyship's judgment, my lords, when will the right to sue first accrues, my lords?
We'll have a date.
We'll have a date. Shorter date.
Let's just matter on 2nd of July.
Grateful. my lords.
35, Manjunath.
I am for respondent, Your Honor. I have filed an application for vacating the interim stay. Because of that stay, I could not in a position to pay the
But we'll
GST
hear,
and tax.
we have to hear this. List the matter on 27th of
Friday.
July. Interim order earlier granted is extended. 36.
36,
Much up.
Viraya Hiramat.
Now, whatever I'm giving dates, it should be in the first list that day. Yes, 36.
Viraya Hiramat.
Let's also look at it if interim order is there. List this matter on 27th. First list interim order earlier granted is extended.
37, Prem Kumar.
This also, this on 28th.
38, Srinidhi.
38 or 39?
1 and 2 has been served, my lords.
Huh?
Answering respondent number 1 and 2 has been served, my lords.
Same 39 on 28th.
Not any shorter date, my lords, because financial difficulty, my
No
lords.
shorter days.
In the June month only, my lords.
There is no date in the June month. 40.
My lords, I appear for the petitioner, my lords, in serial number 40. My lords, may I
39.
request for a date in
1 minute. 39.
39, man.
Huh.
I'm for the petitioner.
Hmm.
The trial court reject
It's a fresh matter.
fresh matter, the
This
third time.
30 39. When is the matter coming?
Tomorrow is the issues, my lord, the trial court.
This is matter tomorrow in the top of the list. 39. Yes, 40.
First list, my lord. First list.
First list.
my lords, I
top of
appear for the
list is
petitioner. My lords, I appear for the petitioner in serial number 40. My lords, may I request a date in second week of July, my lords?
Appearing for respondent.
It's not been admitted yet, my lords.
This is the matter on 21st of July.
My lords, a slightly
Yes.
earlier date, my lords, if possible.
Slightly earlier is 29th of July. 41.
No, my lord, I'll take 21st, my lords.
41.
41 Sagar V Shastri.
This is also a fresh matter, I think. This matter also, this day after tomorrow, in the first list.
42.
Then 42 also fresh matter. This in the first list, day after tomorrow.
43 B group. Sagar V
Appear for
Shastri.
the second for the respondent, my lord. Any shorter date, my lord, for the respondent.
List on 29th of July.
44 urgent. 44 urgent.
And make sure that interim orders, look at it and without fail do it. Yes, 45.
For the petitioner, my lords. 44 and 45, my lords, short accommodation.
44 morning urgent.
It is 44 is already they have sought for adjournment in the morning. August it's coming. So because you want same dates for both, so this also in the month of August. 45. Yes.
46.
My lord, appearing for the respondents.
Appearing for the petitioner, my lord. Tomorrow, one more matter is coming between the same party. So tomorrow only the date can be given, my lord.
One more
Give
petition.
the number. List along with that. Tomorrow.
36.
Yes, 47.
Tomorrow only.
Right, my lord.
47.
47. Prakash Timan Hebbar.
This on 27th of 23rd of July.
48. Vinodes.
48, and for the respondent. The short point, my lords, is the mother's entitled to the benefits of the deceased son, which the trial court only on the interest part, which is deposited by the employer. That is all, my lords. I think 1/3 is the interest that she's claiming out of the deposit that has been.
List the matter on 7th of July. Yes, 49.
For respond number 3, my lords, there is extreme urgency, my lords. Kindly have it on Monday, my lords.
Why it is extremely urgent?
My lords, they have violated the compromise deed terms and conditions, my lords.
That is on the merits of the matter, no urgency for that.
There is urgency, my lords.
49 on 24th of July. Yes, 50.
Ravi Shankar.
My lords,